Introduction of Whom We Shall Welcome. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Recording by Larry Wilson. Whom We Shall Welcome, Report of the President's Commission on Immigration and Naturalization. Introduction. The President of the United States established the President's Commission on Immigration and Naturalization on September 4, 1952, and it required it to make a final report not later than January 1, 1953. He directed the Commission to study and evaluate the immigration and naturalization policies of the United States, and to make recommendations for such legislative, administrative, and other action as in its opinion may be desirable in the interests of the economy, security, and responsibilities of this country. This report is the result of the Commission's study, and it contains the recommendations for an immigration policy best suited in its judgment to the interests, needs, and security of the United States. The Commission's functions under the executive order are now completed, and it ceases to exist 30 days after this report is submitted to the President. It is noteworthy that all the major religious faiths of America urged the President to appoint a commission for this general purpose. The General Board of the National Council of the Churches of Christ in the United States of America issued a statement to this effect in March 1952. In August 1952, the American Council of Voluntary Agencies for Foreign Service, through its Committee on Displaced Persons and Refugees, urged the creation of a commission to study the basic assumptions of our immigration policy. Its statement was signed by representatives of the War Relief Services of the National Catholic Welfare Conference, the Church World Service of the National Council of the Churches of Christ, the United Service for New Americans, and the National Lutheran Council. And in September 1952, the General Convention of the Protestant Episcopal Church urged the appointment of a commission to study the need for emergency refugee legislation, and to review our permanent immigration policy and its basic assumptions. It became evident during the debate in Congress and public discussions after the passage June 27, 1952, of the Immigration and Nationality Act of 1952, generally known as the McCarran-Walter Act, over the President's veto, that the new legislation does not adequately solve immigration and naturalization problems, and that the codification it contains fails to embody principles worthy of this country. Immigration and nationality law in the United States should perform two functions. First, it should regulate the admission and naturalization of aliens in the best interests of the United States. Second, it should properly reflect the traditions and fundamental ideals of the American people in determining whom we shall welcome to a participation of all our rights and privileges. This report discusses the manner in which the law presently regulates the admission and naturalization of aliens, recommends revisions, and explains why the Commission believes these revisions better serve the welfare and security of the United States. As a separate document, the Judiciary Committee of the House of Representatives has published the extensive record of 30 sessions of hearings held by the Commission in 11 cities in various sections of the country. The record shows what a substantial and representative cross-section of the American people believe to be the best immigration policy for this country. It is appropriate to examine the second function of immigration policy, the reflection of American traditions and ideals. The Commission would state them as follows. We hold these truths. 1. America was founded upon the principle that all men are created equal, that differences of race, color, religion, or national origin should not be used to deny equal treatment or equal opportunity. Americans have regarded such doctrines as self-evident since the Declaration of Independence. The immigration law is a key to whether Americans today believe in the essential worth and dignity of the individual human being. It is a clue to whether we really believe that all people are entitled to these unalienable rights, for the preservation of which our nation was created. It indicates the degree of American humanitarianism. It is a gauge of our faithfulness to the high moral and spiritual principles of our founding fathers, to whom people, as the children of God, were the most important resources of a free nation. 2. America historically has been the haven for the oppressed of other lands. The immigration law is an index of the extent of our acceptance of the principle that tyranny is forever abhorrent, and that its victims should always find asylum in the land of the free. It tests whether we continue to believe that the home of the brave should offer a promise of opportunity to people courageous enough to leave their ancestral homelands to search for liberty. It is a measure of our fidelity to the doctrine upon which this country was founded, the right of free men to freedom of movement. The immigration law discloses whether Americans still concur in George Washington's challenge: to bigotry, no sanction; to persecution, no assistance. 3. American national unity has been achieved without national uniformity. The immigration law demonstrates whether we abide by the principle that the individual should be free of regimentation. It attests whether we still respect differences of opinion and the right to disagree with the prevailing ideas of the majority, and whether we still welcome new knowledge, new ideas, and new people. It reveals the strength or weakness of our convictions that democracy is the best philosophy and form of government. 4. Americans have believed in fair treatment for all. The immigration law is a yardstick of our approval of fair play. It is a challenge to the tradition that American law and its administration must be reasonable, fair, and humane. It betokens the current status of the doctrine of equal justice for all, immigrant or native. 5. America's philosophy has always been one of faith in our future and belief in progress. The immigration law indicates our outlook on the future of America. Those who have faith in a dynamic, expanding, and strong American economy see immigration not only as part of our heritage, but also as essential to our future. On the other hand, those who regard the future of America in terms of a static economy and a maximum population view immigration with alarm. 6. American foreign policy seeks peace and freedom, mutual understanding, and a high standard of living for ourselves and our world neighbors. The immigration law is an image in which other nations see us. It tells them how we really feel about them and their problems, and not how we say we do. It is also an expression of the sincerity of our confidence in ourselves and our institutions. An immigration law which reflects fear and insecurity makes a hollow mockery of confident world leadership. Immigration policy is an important and revealing aspect of our foreign policy. No doubt our ideals have not been honored in America at every moment and in every respect, but they have certainly governed our thought and actions over the 175 years of the nation's life. They will continue to do so. The Commission believes that these traditions and ideals should be basic to our immigration laws. Insofar as our immigration policy violates these American traditions and ideals, it weakens the foundations of our liberty and undermines our security and well-being. It also damages our position of leadership and destroys the esteem and good reputation the United States has earned in the past. Other considerations must also condition our immigration laws, such as the protection and preservation of our security against the dangerous and the diseased. The Commission emphasizes that one of its major concerns in applying these principles has been the necessity for the immigration law to safeguard the welfare and security of the United States. However, it is convinced that a full regard for protecting our national security does not require a hostile attitude toward immigration. On the contrary, it believes that full security can be achieved only with a positive immigration policy based not on fears but on faith in people and in the future of a democratic and free United States. What we believe. The Commission believes that immigration has given strength to this country, not only in manpower, new industries, inventiveness, and prosperity, but also in new ideas and new culture. Immigrants have supplied a continuous flow of creative abilities and ideas that have enriched our nation. The Commission believes that an outstanding characteristic of the United States is its great cultural diversity within an overriding national unity. The American story proves, if proof were needed, that such differences do not mean the existence of superior and inferior classes. The Commission believes that it is contrary to the American spirit to view every alien with suspicion and hostility. The Commission is convinced that the American people will not knowingly tolerate immigration laws that reflect distrust, discrimination, and dangerous isolationism. The Commission believes that the American people are entitled to a positive, not a negative, immigration policy, and that they desire a law geared to the forward-looking objectives of a great world power. The Commission believes that although immigrants need the United States, it is also true that the United States needs immigrants, not only for its domestic or foreign benefit, but also to retain, reinvigorate, and strengthen the American spirit. The Commission believes that we cannot be true to the democratic faith of our own Declaration of Independence in the equality of all men, and at the same time pass immigration laws which discriminate among people because of national origin, race, color, or creed. We cannot continue to bask in the glory of an ancient and honorable tradition of providing haven to the oppressed and belie that tradition by ignoble and ungenerous immigration laws. We cannot develop an effective foreign policy if our immigration laws negate our role of world leadership. We cannot defend civil rights in principle and deny them in our immigration laws and practice. We cannot boast of our magnificent system of law and enact immigration legislation which violates decent principles of legal protection. Nor can we ourselves really believe, or persuade others to think that we believe, that the United States is a dynamic, expanding, and prosperous country if our immigration law is based upon a fear of catastrophe rather than a promise and hope for greater days ahead. The Commission believes that our present immigration laws flout fundamental American traditions and ideals, display a lack of faith in America's future, damage American prestige and positions among other nations, ignore the lessons of the American way of life. The Commission believes that laws which fail to reflect the American spirit must sooner or later disappear from the statute books. The Commission believes that our present immigration law should be completely rewritten. End of introduction.
Section number 2 of Whom We Shall Welcome. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Whom We Shall Welcome. Report of the President's Commission on Immigration and Naturalization. Part 1. Americans Speak on Immigration. Chapter 1A. The Commission's Hearings. Immediately after the President issued Executive Order Number 10392, dated September 4, 1952, and his public statement of the same date, naming the chairman and members of the Commission and defining its duties and powers, work of organization began. It became evident that if the Commission was to comply with the directive to make a final report not later than January 1, 1953, steps had to be taken promptly to gather the necessary information in different sections of the country. It was obviously impossible to arrange for large numbers of people to go to Washington to express their views orally and in writing, based upon experience and knowledge of the operation of immigration and naturalization laws, regulations, and policies. The Commission decided to visit key places throughout the country and hold public hearings at which any interested person could appear and make a statement. In order to assure attendance of persons especially qualified to discuss existing laws and policies, and those about to become effective, the Commission invited individuals and agencies with information relevant to the economic, social, and other implications of past, current, and future immigration laws and policies of the nation. This was done by specific invitations and public announcements. In addition to those invited, all who requested to be heard were scheduled within the time available. At the time the Commission began its work, the laws on the subject enacted prior to the 82nd Congress were still in effect. The codification, embodied in the Immigration and Nationality Act of 1952, Public Law 414, 66, Statute 163, McCarran-Walter Act, June 27, 1952, had been passed over the President's veto, but was not to take effect except provisions relating to the establishment of a joint congressional committee until December 24, 1952. Schedule of hearings. The task of communicating with individuals and organizations throughout the country and of arranging a schedule of hearings was a difficult one, achieved under great pressure because of the immediate necessity of equipping working quarters and selecting a competent staff, and because of the limited time for the project. The Commission carried out the following schedule of hearings: New York, September 30th and October 1st, Boston, October 2nd, Cleveland, October 6th, Detroit, October 7th, Chicago, October 8th and 9th, St. Paul, October 10th, St. Louis, October 11th, San Francisco, October 14th, Los Angeles, October 15th, Atlanta, October 17th, and Washington, D.C., October 27th, 28th, and 29th. This added up to 15 days of hearings in 11 different cities from the Atlantic to the Pacific coast. Invitations to appear before the Commission were also issued to persons and organizations, public and private, in other cities and areas in the same section of the country in which each of the hearings was held. The appendix to this report contains the names of people who testified and the organizations represented at the Commission's hearings or who submitted statements to the Commission. In addition, the Commission held a number of executive conferences with federal officials entrusted with the administration of immigration and security programs of the United States. The Commission made a studied effort to obtain statements on the subject, oral and written, from all points of view. In view of the fact that a presidential campaign was then in progress, the Commission refrained from inviting anyone who was a candidate for federal office, the sole exception being in the case of Congressman Francis E. Walter, co-sponsor of the Immigration and Nationality Act of 1952. Senator Pat McCarran and members of the staff of the Senate Committee on the Judiciary were also invited. However, whenever any member of the House of Representatives or Senate of the United States requested leave to appear, the request was granted. Considering the brief notice and opportunity for preparations, the wealth of material submitted to the Commission, much of it of great importance and permanent value, is almost incredible. Fortunately, through the cooperation of Congressman Emanuel Seller of New York, chairman of the Committee on the Judiciary of the House of Representatives, it has been possible to print a record of the hearings, containing the statements made during the hearings and those submitted subsequently. Because of its length, the record of hearings could not be included in this report. It contains oral testimony on the subject given by some 400 persons and written statements by approximately 234 others, or a total of 634 statements, some expressing the views of individuals, others made in official capacities on behalf of agencies of the federal, state, and municipal governments, and others on behalf of many religious, welfare, political, and other private organizations. It comprises some 2,100 pages and may be obtained from the Superintendent of Documents, Washington, D.C. In beginning the task assigned to it by the President, the Commission was confronted by certain facts having an important bearing on the feasibility of efforts at this time to evaluate the national policies with respect to immigration and naturalization. They may be stated as follow. 1. The passage by both branches of Congress of the Immigration and Nationality Act of 1952 and its repassage by more than a two-thirds vote in each House over the President's veto message, which gave forceful expression to criticisms of particular provisions of the bill. 2. The failure of the 82nd Congress to take action with respect to S. 3109, introduced by Senator Hendrickson, or H.R. 7376, introduced by Congressman Seller, providing for the issuance during a period of 3 years of 300,000 special non-quota immigration visas to certain refugees, persons of German ethnic origin and natives of Italy, Greece, and the Netherlands. These bills were drafted to comply with a message urging such legislation sent by President Truman to Congress March 24, 1952. The Immigration and Nationality Act of 1952 codifies, for the first time, the many pieces of immigration legislation enacted since 1917, and to that extent supplies a document long needed. In addition, however, to the reenactment of existing provisions, some of which had been the subject of controversy, the new law contains revisions and amendments suggested during the legislative hearings and by the staffs of the congressional committees. Some of these changes liberalized the immigration laws, but many of the others resulted in new restrictions, both in substantive law and in administrative procedures. The President's veto message and the subsequent debates on the floor of the Senate and House had the effect of arousing more general interest in the subject than had been previously shown. The appointment of this commission and the announcement of its plan to go to the country for information as to the effect of immigration laws, procedures, and policies on the economic, social, and other aspects of life in the United States gave opportunity for expression to an increasing public concern. Nationwide interest. The commission was to find, as it moved from city to city and from region to region, that religious, welfare, and other organizations had begun to hold discussions not only within their own membership, but with each other on important features of the Act of 1952, in an attempt to crystallize their views on the question as to whether the new law is adequate to meet the grave and complex problems involved. Renewed consideration of such matters seemed to be prompted by a belief that the United States had not yet fulfilled its obligations to suffering humanity, that the Displaced Persons Program, under which nearly 400,000 persons had been brought to the United States from Europe, had been a great success, but that existing emergencies abroad demanded further efforts in behalf of refugees, expellees, escapees, remaining displaced persons, relatives of those who had reached safety in the United States, and other categories of people whose living conditions and constant dangers are a reproach to our civilization. At first there was a disposition by some to postpone any effort to arrive at conclusions on long-range immigration policies, especially in view of the enactment of the Act of 1952 and the fact that there was no practical experience under its administration, and to concentrate on legislation to meet the emergency situation, such as proposed in the President's message of March 24, 1952. This attitude gave way to suggestions by representatives of the largest and most important organizations for a new and different set of permanent policies, and this attitude was buttressed by the view that the basic principles of the Act of 1952 are the same as those that existed in the legislation it superseded, and that therefore no additional experience with such legislation was needed in order to provide sufficient basis for informed opinions. In addition, members of state displaced persons commissions or committees and their staffs, and the officials of various religious and welfare organizations had been engaged over a period of years in assisting in the reception, resettlement, and supervision of the nearly 400,000 persons who were brought to the United States under the Displaced Persons Program. Their knowledge of the current results of that project, derived through their contact with these immigrants, was made available to this commission. The governors of 36 states appointed state displaced persons commissions or committees, and many of these agencies are still active as this report is being prepared, although their activities at present are reduced largely to problems incident to supervising or recording the results of the integration of the newcomers into life in the United States. Leaders speak. The New York session set the tone of the hearings. It became evident at once that religious, civic, and welfare organizations of national and even worldwide importance were tremendously interested in the subject matter and in the task assigned to the Commission. They welcomed the opportunity to be heard, to record their views, and to cooperate in any effort to arrive at common understandings and a common program for consideration by the Commission, by the President, and eventually by the Congress. The very first person to appear before the Commission was the Director of Field Operations for the Refugee Service of the World Council of Churches, with headquarters in Geneva, Switzerland. He had returned but 2 days before from Europe, and during the year had visited and studied refugee problems in the Middle East and Far East. The Council is made up of the Protestant and Orthodox churches of the world, some 160 major denominations. It was followed in New York and elsewhere by representatives of Protestant, Catholic, and Jewish charitable and humanitarian organizations, by scholars who had done research in population problems and in related fields, by scientists, educators, and those engaged in various phases of social work, by public officials whose experience and knowledge enabled them to speak with authority, by representatives of agriculture, business, and labor, by professors of law and political science, by lawyers specializing in immigration cases, by representatives of various nationality groups whose roots lay in Southern and Eastern Europe and in Asiatic countries, or closer to home in the West Indies, by representatives of organizations especially interested in foreign affairs, by representatives of various sectarian and non-sectarian bodies engaged in activities concerned directly and indirectly with immigration, by representatives of various types of educational institutions, such as universities and art museums, by representatives or members of political parties and organizations interested in political and social and economic issues, by representatives of business enterprises with interests abroad and whose operations are affected by immigration laws, and by representatives of veterans, patriotic and civic organizations, and others especially interested in questions related to the protection of American freedoms, liberties, and privileges. Some appeared as individuals, and others were authorized to speak for groups and organizations, public and private. All interests in the United States affected by the provisions and administration of immigration laws were given an opportunity to record their views on the problem assigned to the Commission for study and report. The Commission was surprised to learn of the widespread and rather determined opposition to the Act of 1952. This is all the more amazing in light of its recent passage over the President's veto, and especially because it had not even taken effect at the time of the hearings. In addition, it is fair to say that approval of the new law was voiced by comparatively few, and that in practically all such instances the favorable opinions were not supported by factual information. The dominant theme of those who appeared to testify or file statements was criticism of the Act of 1952. Some objected to specific aspects, but most witnesses opposed the basic theories of the new law. Recent immigration. Perhaps the most eloquent pleas to the Commission for recommendations for changes in the law were made by those who came fortified and inspired by actual experience with the Displaced Persons program. It should not be understood that enthusiasm for displaced persons was unanimous in all sections of the country, or that no instances were mentioned of displaced persons who either were unappreciative of the efforts in their behalf or were mentally or physically unable to make a rapid adjustment to conditions in this country. There were, of course, a number of such instances. It was stated, for example, that some who were believed to be farmers and who were resettled in farming communities did not possess the necessary qualifications, and eventually drifted to the large cities where they had opportunities to locate among people of the same nationality groups, and there were other criticisms. But the weight of testimony made it clear that by reason of the Displaced Persons Program, the United States was enabled to make a substantial contribution to the cause of humanity, at the same time gaining for itself a large group of capable, hard-working, intelligent, and honest people, whose prompt integration into the economic fabric of the nation is proving an asset of incalculable value. Along with those ready for work on the farms and in the factories came many possessing special skills and those trained in the arts and sciences. These were the people who had come from camps in Europe or from other temporary quarters in which they had been enabled to exist until some permanent arrangement could be made. These were the victims of the wars and the aftermath of wars, uprooted from their homes and tossed back and forth as the armies fought and diplomats wrangled. These were the refugees from slavery and death, the expellees from the land of birth or home, the escapees from the other side of the Iron Curtain, the people robbed of all they owned, and the survivors of once happy families, tortured in body and spirit, and set adrift or herded together to await either death or whatever form of rescue may be provided by some of the free peoples as have the means and the will to respond to the call of despairing human beings. Those who were brought to this country were among those who had survived the severest hardships. They came, most of them strong and brave, to begin life in a new and strange world. The story of their willingness to accept whatever fate has in store, and the almost overnight success attained by many in the United States, makes one of the most remarkable pages of current history. Handicapped by differences in language and customs, and even dress, by many other difficulties inherent in such a transition, they nevertheless have progressed as a group far beyond the expectations of those who advocated the passage of the Displaced Persons Act of 1948. They have been absorbed by agriculture and by industry. They are in colleges and universities, engaged in teaching or research. An astounding proportion of the younger men are already in the armed services of this country, and the economic success of these people considered together is proved by the fact that, according to the Displaced Persons Commission, those who came under the Displaced Persons Program from October 1948 to August 1952, at a cost to the federal government of some $19 million, have already paid in federal income taxes alone more than 3 times that sum. That progress is slower for some on account of age and other circumstances is evidenced by the narrative told the Commission by a minister in a Midwest church, the present janitor of which was formerly the head of the educational system of an entire country in Eastern Europe. But this displaced person, the author of books on educational subjects in his native land, does not seem discouraged, and doubtless will eventually find an occupation better suited to his abilities. It is possible to begin to evaluate not only what has been done for these people, but what they have done within a short space of time for the people of our country, and such information is relevant to any consideration of the problem of future immigration. The Displaced Persons Program brought to the United States Armenians, Czechoslovakians, Estonians, Greeks, Hungarians, Italians, Latvians, Lithuanians, Poles, Russian refugees, Ukrainians, ethnic Germans, nationals of the Balkans, and others. Individuals and representatives of organizations drawn into the project testified to their administration for the ability and energy of the immigrants, and for the rapidly acquired devotion and loyalty to this country. It is not too much to say that the knowledge and experience gained by contact with the newcomers have served to break down barriers among our own people. Moving toward agreement. The Commission learned that the necessity for exchanging information resulting from actual experiences with resettlement of these immigrants was the moving force through which divergent views were being debated and adjusted. The nation's greatest and most powerful groups in welfare activities were reaching agreements on vital issues within their own organizations and with each other. Indisputable evidence of this was given by the circumstances that leading Protestant, Catholic, and Jewish organizations criticized the Act of 1952 for similar reasons, and that in some places a single representative was authorized to speak for many lay and religious organizations of different denominations. For example, at the Boston hearings, a single representative from New Haven, Connecticut, testified on behalf of the New Haven Council of Protestant Churches, the New Haven Jewish Community Council, the Italian American War Veterans, the New Haven branch of the National Association for the Advancement of Colored People, and the Italian newspaper New Haven. During the Cleveland hearings, a delegation of 3 persons from Pittsburgh appeared. 2 of them, including a Lutheran clergyman, spoke for the American Service Institute of Allegheny County, Pennsylvania, the social and civic agencies in Pittsburgh and Allegheny County, the American Bulgarian League, Catholic Slovak Brotherhood, Council of Jewish Women, Croatian Fraternal Union, Federation of Jewish Philanthropies and United Jewish Fund, Greater Beneficial Union of Pittsburgh, Jewish Family and Children's Service, Lutheran Service Society, Serb National Federation, Verhove Association, and the Jewish Community Relations Council. Another witness at the Cleveland hearings was a person from Cincinnati who brought letters from the director of the Catholic Charities of Cincinnati and from the executive secretary of the Council of Churches of Greater Cincinnati, and who appeared on behalf of those organizations and the Citizenship Council of Cincinnati, the Church Federation, and the Jewish Community Council of Cincinnati. One person came to the Cleveland hearing from Buffalo, New York, and authorized to speak for 8 different organizations: the Board of Community Relations of the City of Buffalo, Council of Social Agencies, Diocesan Resettlement Committee of Catholic Charities, Labor Committee to Combat Intolerance, Anti-Defamation League, Council of Churches, Jewish Federation for Social Service, and the International Institute. To the hearing in St. Paul came a Methodist minister from Austin, Minnesota, authorized to speak for his own group and for the Jewish group in that community, and also the Packing House Labor Union there. In Atlanta, Georgia, the commission heard from the chaplain and head of the Department of Religion at the University of Georgia, Athens, Georgia, who presented a statement on behalf of 7 religious leaders in Athens, 5 Protestant, 1 Catholic, and 1 Jewish. To the same hearing came the director of the Archdiocesan Resettlement Bureau of New Orleans, Louisiana, who is also a member of the State Committee on Displaced Persons and the New Orleans Resettlement Committee. He submitted a joint statement of views opposing basic policies of the immigration law, signed by 6 representatives of broad segments of religious and social life in metropolitan New Orleans, including the minister of the First Unitarian Church, the chairman of the Department of Civil Affairs of the New Orleans Council of Churches, the president of the New Orleans Ministerial Union, the president of the New Orleans section of the National Council of Jewish Women, a representative of the Catholic Committee of the South, and the director of the Archdiocesan Resettlement Bureau. These are some of the instances indicating increased unity of study and thought throughout the country on problems relating to immigration and naturalization. They indicate a trend of the greatest possible importance toward the growth of cooperation and goodwill among the people of the United States. End of section 2. Section 3 of Whom We Shall Welcome. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Whom We Shall Welcome. Report of the President's Commission on Immigration and Naturalization. Part 1. Americans Speak on Immigration. Chapter 1b. National Leaders. The record discloses other highly interesting developments. For example, a group of 10 of the foremost executives of Protestant organizations of many denominations appeared at the Washington hearings to urge the Commission to recommend the adoption of new immigration policies. The group made a joint presentation of views with the Director of Immigration Services, Department of Church World Service, National Council of Churches of Christ as the chief spokesman, and with supporting statements from those who accompanied him. Among them were the Executive Director of the Department of International Goodwill and other officials of the National Council of Churches of Christ, the Executive Secretary of the Committee on Displaced Persons of the Presbyterian Church, the Director of the Department of Mutual Aid, Brethren Service Commission, and the Executive Director of the Baptist Joint Committee on Public Affairs, representing the Baptist World Alliance, which includes the Southern Baptist Convention, not a constituent of the National Council. The impressive statements made by these and others, including a representative of the National Lutheran Council, followed those of similar authority and importance made there and at the preceding hearings throughout the country. At the Washington hearings, the Commission also heard the Executive Director of the War Relief Services of the National Catholic Welfare Conference, the Director of the Bureau of Immigration of the National Catholic Welfare Conference, and leading figures of various Jewish organizations devoted to activities on behalf of immigrants. Testimony was also presented by cabinet officers, other leading public officials, important representatives of agriculture, business, and labor, spokesmen for bar associations and for various national scientific, welfare, civic, patriotic, veterans, and other interested organizations. The thoughtful and informed opinions voiced by those with personal experience in the matter, and by leaders in professional fields interested for a variety of reasons in the impact of the immigration and naturalization laws and regulations on the economic, social, and cultural life of the United States, as well as the effect on our relationship in the family of nations, convinced the Commission of the necessity for sweeping changes in immigration policies. Pros and cons. It seems clear that those who took part in the discussions before the Commission, or who submitted written views, represented a large segment of public opinion. It is equally clear that by far the greater number of those who expressed views to the Commission are in agreement that the Act of 1952 is not based upon sound fundamental principles, and that although it did work some improvements, the Act continued and enlarged many existing discriminations and inaugurated new and serious inequities. The sentiment for prompt legislative action was expressed by a leading Protestant official in these words: "We do feel very strongly that the law placed upon the statute books in the last session of Congress is an affront to the conscience of the American people." Comparatively few of the organizations and individuals appearing before the Commission were in favor of the Act of 1952. However well-intentioned, the statements of approval were generally without documentation of any sort, and were seemingly the result either of special benefits conferred by the law, or of emotion and deep-rooted fears and prejudices. Some, admitting we are a nation of immigrants, expressed the opinion that we had not yet properly digested or integrated many of the later arrivals into our way of life, that immigration should now be kept at a minimum or eliminated, that eventually the country would not be able to support an increase in population due to immigration, that increases in the number of immigrants now authorized would invite unemployment, multiply the hazards to security, have an adverse effect on the national economy, and be productive of other evils and dangers. And there were those who think that although discriminations against Southern and Eastern Europeans might be eliminated, immigration should be largely limited to Europeans, on the ground that this nation owes its cultural, social, and economic concepts and traditions to European civilization, and that people of other races and religions cannot be assimilated in any helpful degree. This does not mean, of course, that no arguments in favor of the Act of 1952, supported by objective study of relevant facts, exist. The fact that the law was enacted by more than a two-thirds vote in both houses of Congress over the President's veto would negate such an idea. But it is also true that no argument sufficient to meet the overwhelming weight of evidence against the desirability of much of the Act of 1952 were given to the Commission. Likewise, the number of those who appeared in opposition to the Act of 1952 and who represented organizations with vast memberships adding up to many tens of millions was large enough to warrant the conclusion that they and not the others accurately expressed the sentiments of the American people. General consensus. It should be emphasized again that those who oppose the Act of 1952 do not entirely agree on all their reasons, nor on what should be substituted in its place. Some individuals and groups are especially interested in particular provisions which they find detrimental, and have concentrated their attention on those to the exclusion of others. It is possible, however, to enumerate certain basic policies urged by practically all of those opposed to the Act of 1952, as shown by the statements, oral and written, made to the Commission. They may be summarized as follows. 1. The national origins quota system should be abolished. 2. There should be an overall maximum of annual quota immigration to this country. The determination of the total number of quota immigrants permitted to enter during any year should reflect the needs and capacity for absorption of the United States. That number under present conditions should be approximately 250,000. 3. The allocations within this annual quota should be designed to meet emergency situations of great hardship abroad, such as continued distress and suffering among refugees, expellees, escapees, displaced persons, and other victims of communism and other forms of totalitarianism, overpopulation, and the special and general needs of the United States. These are the most important of the proposed policies and provisions affecting the sources and amount of immigration resulting from the information submitted to the Commission. There is a strong and ever-increasing sentiment against the continuation of a quota system based on national origins. The arguments against it generally, and as it is written into the Act of 1952, are that it embodies principles inconsistent with the Declaration of Independence, the Bill of Rights of the Constitution of the United States, and the institutions of government which have made our nation strong and great and the hope of free peoples everywhere. Moreover, it is argued the national origins quota system is based on unsound theories long since proved invalid, fallacies that are becoming more and more dangerous in a troubled world where colonial empires are rapidly disappearing and national pride is strengthening into demands for national independence. The national origins quota system is criticized on the ground that it is based on a concept of biologically distinct races, and also on the theory that some races are superior to others. The Act of 1952, it was said, promotes a claim of Nordic supremacy, discriminates in favor of the nations of Western and Northern Europe, especially Great Britain and Ireland, and against the nations of Southern and Eastern Europe, the Near East, and Asia. It was argued that laws which deny the inherent dignity and worth of the individual, which deny the equality of man, and which embody discriminations based on race, creed, color, and national origin, have no place on our statute books, and are a denial of all we profess to be and believe. Such laws, it was contended, are detrimental to our foreign policies, are the source of much antagonism and bitterness against us, impair our relationships with other nations, and leave us prey to damaging propaganda by those who promote an ideology that would substitute a police state for individual freedoms. National Origins Quota System. The National Origins Quota System purports to fix immigration quotas on the basis of the national origins of our population, but the Act does not do this. It uses the national origins of the population of 1920, not of 1950. It excludes from consideration Negroes, American Indians, and other non-white people. Thus, it fails to take into account the national origins of the current population. Complaint was made that the assignment of quotas on such a basis disregarded the fact that the nations receiving the largest quotas did not use them. Although the permissible total quota was approximately 154,000 annually, during the last 20 years an average of but 54,095 quota numbers were used annually. Immigration fell to a trickle during World War II, and this helped to bring down the 20-year average. But in the other years during that period, the National Origins Quota System alone has held normal immigration to a figure ranging annually from 1/3 to a little over 1/2 of the total authorized. It was argued to the Commission that if it was thought in 1924, when the quota system was enacted, that approximately 154,000 immigrants annually was a reasonable amount, such a total is unrealistic today in view of the changed conditions, our greatly expanded economy, and our need for additional manpower. Many of the witnesses urged the Commission as a minimum to recommend legislation under which unused quotas would be redistributed to the nations with long waiting lists. Practically all who favor changes in existing laws ask that action be taken to cancel the mortgages on annual quotas, the provision in the Displaced Persons Act of 1948, as amended, under which the displaced persons already admitted are charged against 50% of future quotas, in one instance to the year 2274. The Commission was repeatedly told that the National Origins Quota System is the product of fear of strange people, languages, and customs, an unfounded belief that people of Western and Northern Europe and their descendants make better citizens than immigrants from other areas. The proud record of immigrants from those other areas in times of peace as well as war was cited as proof that the United States has nothing to fear from the repeal of policies which have been harmful at home and which have created enemies abroad. The burden of the discussion on this phase of the problem was to the effect that we can no longer afford to indulge ourselves in policies based on mistaken theories, themselves inconsistent with the principles we preach. Great emphasis was placed in opposition to the national origin system on the fact that it is inflexible and does not allow room for consideration of the conditions under which more than 10 million persons, refugees, expellees, escapees, and displaced persons of various categories, are living in the Europe of today. It was agreed that the United States alone cannot solve this problem, but many insisted that some additional action is imperative, and promptly, to encourage other nations in a position to help and to give some hope to desperate human beings, innocent victims of totalitarian lust for power. Other action needed. Earnest pleas have been made to the Commission to recommend special programs for the reception and care, as well as immigration, of escapees, those who break through the Iron Curtain and reach what for them is the Promised Land. Unfortunately, in too many instances, the promise is found to be illusory, the Commission was told. No adequate provision for them has yet been made. The failure of the free nations adequately to care for those who risk their lives for freedom is a powerful propaganda weapon in the hands of the communists. There was unanimous agreement that as to all immigrants, no matter what their race or creed or color or national origin, stringent security measures should be enforced. Precautions against the admission of Subversives, criminals, or other undesirables were favored, as were safeguards on health and other such grounds. Powerful appeals were made to the Commission for recommendation for prompt action to relieve the distress caused by overpopulation and by great numbers of refugees, expellees, escapees, and others who live in and out of camps, without hope and without prospects for the future, unless rescued through the mercy of their more fortunate fellow men. It was suggested that provision should be made to accept a maximum of 100,000 of such persons annually, at least for a period of 3 years, and that this number should be included in an overall maximum of 250,000 annually for a like period of time. The Commission was asked to recommend that admissions be permitted on a family basis to avoid situations where the breadwinners on this side of the ocean are unable to bring their closest relatives to join them and are separated indefinitely. The heartbreak caused by these separations and the resulting futility of efforts to restore well-ordered family life is incalculable, besides increasing instead of lessening the burden on the nations in whose economic strength we have a stake. The Commission heard much discussion as to the size of the overall annual quota. Various figures were suggested, and in order to obtain a documented basis for a recommendation, the Commission sought advice from scientists, from public officials, from census experts, from those experienced in labor, agricultural, and industrial fields, and from others whose knowledge and experience would shed light on the subject. The result is set forth in the record of hearings. The attention of the Commission was directed to the provisions of the Act of 1952 for the determination of quota areas within the Asia-Pacific Triangle, and for the limitation of quotas assigned to colonies or other dependent areas of a governing country. These provisions, it was suggested, have the effect of deliberately discriminating on account of race and color to such an extent as practically to deny all immigration, except for a token amount, to the people in the areas described. The Commission was told, for example, that the Jamaicans, formerly within the quota assigned to Great Britain, are restricted by the device of treating colonies separately to a quota of 100 annually, instead of the approximately 1,000 who have been arriving annually, a reduction of 90%. The Japanese and Chinese, in whose behalf the naturalization laws were liberalized, are also given a negligible quota. The Commission was told that the new law is a mixture of discriminations based on nationality and on race, irrespective of nationality, and on geography, irrespective of any other factor. Persons of as much as one-half Asiatic blood are charged by the 1952 Act to the Asiatic country of either of their parents, without regard to the fact that they may have been born and bred elsewhere. Administration of the law. Many of those who had experience with or who had studied the administrative features of current laws and regulations criticized the requirement that visa applications be processed through the officials of 2 different departments. The original application is made abroad to the appropriate consular service of the State Department. If he rejects the application, there is no appeal. If the consul grants a visa and the immigrant comes to this country, he is met at the port of entry by an officer of the Immigration and Naturalization Service of the Department of Justice. The Justice Department is not bound by any action taken by the State Department, and the applicant, after making the long and expensive journey to America, may be refused entry, although possessed of a valid visa. This has happened, and is partly responsible for the argument that it is inefficient and wasteful for the United States to have 2 separate agencies with like duties and responsibilities engaged in the same operation, one at the gates to this country and the other in foreign countries. It was suggested that all immigration matters be combined in one agency of government, so that when an applicant receives a visa, he will be assured of admission, except for intervening causes. The Hoover Commission took note of this situation and recommended that all authority over immigration, including the issuance of visas, be centered in one agency, and proposed that the agency be the Department of Justice. Most of those who appeared before the Commission had no definite views as to whether the consolidation, if made, should be in the Justice Department or the State Department, or in a separate administrative agency. There was sentiment against leaving the administration of immigration affairs in the Justice Department on the ground that the department is essentially a litigating and prosecuting agency, and that there is no particular reason why the administrative functions should remain there. Before its transfer to Justice, the Immigration and Naturalization Service was attached to the Labor Department, and the officials there believe it should be returned. Still others urged that an independent agency should be established to administer all immigration laws. Criticism of the law. Many other objections to the Act of 1952 were submitted to the Commission. Witnesses objected to the unreviewable discretion of minor officials to deny visas. The Commission was told that the prohibitions of the 1952 Act apply with great severity to those who may have been convicted overseas of political offenses under the very system that challenges all the free peoples of the world. There was insistent condemnation of the provisions enlarging, unreasonably it was said, the grounds for exclusion and deportation, and heavy criticism of retroactive provisions under which deportation is authorized against longtime residents for actions which may have been entirely innocent and inoffensive at the time they were taken. Some urged that there should be no deportation except for illegal entry, on the ground that deportation was banishment, and the effect upon family and dependents was grossly unfair, a punishment of severity frequently far in excess of the crime. Much concern was expressed about changes brought about by the 1952 Act and the Naturalization law. There was widespread attack against provisions discriminating between native and naturalized citizens and making second-class citizens of the latter. Objection was voiced to the enlargement of grounds for denaturalization and to their retroactive effect. It was contended that if any naturalized citizen commits an offense, except for fraud in obtaining citizenship, he should be punished in the same way as a native-born citizen, and not be subjected to loss of citizenship and deportation. Strong representations were made to the Commission that the punishment of exile for aliens and naturalized citizens was a relic of the feudal ages. Others urged upon the Commission considerations of fair procedure, fair hearings, and proper administrative and judicial review. Representatives of important business enterprises protested against provisions which they felt unduly and unreasonably affected the efficient conduct of their business in the United States and in foreign countries. The Attorney General pointed out that from the standpoint of effective administration, the Immigration and Nationality Act of 1952 requires amendment and clarification, and further that a number of the sections are ambiguous and otherwise defective. One of the sections, a reenactment of previous law, has been declared invalid by a federal district court. Some of the Attorney General's objections go to the Act as a whole because of its bad arrangement and inferior draftsmanship. Other officials cited specific sections containing inconsistencies, the effect of some of which is to place unnecessary and costly burdens on the administrative agency, and make the Act difficult of interpretation and enforcement. Some professors of law informed the Commission that they had great difficulty in understanding the language of the Act of 1952. Conclusion. This summarizes many but not all of the complaints against the Act of 1952 submitted to the Commission during the course of the hearings, and in written statements filed subsequently. The recent immigration legislation was described by those in opposition as the product of isolationism, of baseless fears and prejudices, and a shameful retreat from the principles embodied in the organic laws of our nation. It was pictured as an arrogant, brazen instrument of discrimination based on race, creed, color, and national origin, a return to approval of ex post facto offenses and punishments, weapons of tyranny which liberty-loving peoples have fought since the dawn of civilization. The consensus was to the effect that the Immigration and Nationality Act of 1952 injures our people at home, causes much resentment against us abroad, and impairs our position among the free nations, great and small, whose friendship and understanding is necessary if we are to meet and overcome the totalitarian menace. The gist of the appeal to the Commission was for a fresh look at the problem, with the hope for legislation based on humanitarian principles, designed to fulfill our duties and obligations to suffering mankind, and adequate for our needs and for our security. End of section 3.
Section 4, Of Whom We Shall Welcome. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Recording by PhyllisV. Whom We Shall Welcome. Report of the President's Commission on Immigration and Naturalization. Section 4, Part 2, Immigration and the American Way of Life. Chapter 2A, Immigration and the American Economy. In the President's executive order establishing the Commission, one of the three major areas of consideration set out by the President was the admission of immigrants into this country in the light of our present and prospective economic and social conditions and of other pertinent considerations. This concern led the Commission to inquire into the historic contribution of immigration to the American economy, to consider the extent to which manpower needs are being met under a policy of severe restrictions on immigration, and to consider the possible advantages of immigration to a growing peacetime economy, to national defense, and to a creative civilization. America, a land of immigrants. In a short period of human history, the people of the United States built this country from a wilderness to one of the most powerful and prosperous nations in the world. The people who built America were 40 million immigrants who have come since the Mayflower, and their descendants. We are still a vigorous and growing nation, and the economic, social, and other benefits available to us, the descendants of immigrant forebears, are constantly expanding. Our remarkable national development testifies to the wisdom of our early and continuing belief in immigration. One of the causes of the American Revolution, as stated in the Declaration of Independence, was the fact that England hindered free immigration into the colonies. Our growth as a nation has been achieved in large measure through the genius and industry of immigrants of every race and from every quarter of the world. The story of their pursuit of happiness is the saga of America. Their brains and their brawn helped to settle our land, to advance our agriculture, to build our industries, to develop our commerce, to produce new inventions, and, in general, to make us the leading nation that we now are. Immigration brought wealth to the United States, many billions of dollars. The immigrants did not bring this wealth in their baggage. Many arrived penniless and in debt, but in their skills, their trades, and their willingness to work. In his testimony to the Commission, Dr. Lewis I. Dublin, statistician and second vice president of the Metropolitan Life Insurance Company, pointed out that a young adult immigrant of 18 years today is worth to the nation at least $10,000, since that is what it costs to raise the average American. The average net worth of such a person to the economy of the United States falls between $30,000 and $80,000, depending on his potential earning power. Throughout our history, immigrants have, in this way, represented additional wealth to our country. Scarcely one aspect of our American economy, culture, or development can be discussed without reference to the fundamental contribution of immigrants. No roster of leading Americans in business, science, arts, and the professions could be complete without the names of many immigrants. In our history, the following aliens may be mentioned among many who became outstanding industrialists: Andrew Carnegie, Scottish, in the steel industry; John Jacob Astor, German, in the fur trade; Michael Cudahy, Irish, of the meatpacking industry; the DuPonts, French, of the munitions and chemical industry; Charles L. Fleischmann, Hungarian, of the yeast business; David Sarnoff, Russian, of the radio industry; and William S. Knudsen, Danish, of the automobile industry. Immigrant scientists and inventors are likewise too numerous to list in detail. Among those whose genius has benefited the United States are Albert Einstein, German, in physics; Michael Pupin, Serbian, in electricity; Enrico Fermi, Italian, in atomic research; John Ericsson, Swedish, who invented the ironclad ship and the screw propeller; Giuseppe Belanca, Italian; and Igor Sikorsky, Russian, who made outstanding contributions to airplane development; John A. Uden, Swedish, who was responsible for opening the Texas oil fields; Lucas P. Kyrides, Greek, industrial chemistry; David Thomas, Welsh, who invented the hot blast furnace; Alexander Graham Bell, Scottish, who invented the telephone; Conrad Huber, Russian, who invented the flashlight; and Otto Mergenthaler, German, who invented the linotype machine. Many of our leading musicians, actors, motion picture producers, and others in the arts are foreign-born. Law, medicine, education, literature, research, organized labor, and journalism are only a few other of the innumerable fields benefited by outstanding immigrants. Any such list can only be a sample of how much immigrants have enriched the America which granted them hospitality and welcome. The encouragement of immigration was part of the tradition of the United States, and one of the reasons why it became a great and powerful nation. Immigration to the United States has come from virtually every corner of the globe. The greater part of it, however, came from Europe. It is especially interesting to note that the major impulses to come to the United States from the various countries of Europe were passing phenomena, rising at certain stages of the economic or political life in their homelands, and then subsiding. The sources of American immigration shifted with the changing of needs, both in the United States and in the countries of origin. Each generation, even each decade, brought a changing pattern of immigration. Table 1 portrays the changes in the dominant countries of the origin of immigration to America. The earliest mass migrations were drawn from the English, Scots, and Scot-Irish people of the British Isles. Colonial immigration of such Britons was supplanted in numbers in the period 1820 to 1860 by migration from Ireland, but the most acute migration fever had passed in Ireland by the end of the 1850s. Immigration from West and Southwest Germany became important in this period, and with the opening up of Eastern Germany, total German immigration was the dominant stream from 1860 to 1890. In these years, Scandinavia vied with Ireland in numbers of immigrants. But the crest of this new migration from Germany and Scandinavia was passed in the 1880s and gave way to another new migration, dominated by immigrants from Italy, Austria-Hungary, and Russia. The emigration fever spread across the European continent from west to east and from north to south. Thus, up to 1890, Italian migration to America came largely from the more economically advanced north of Italy. After 1890, Italian migration came increasingly from the south. The main founts of immigration from Austria were in chronological sequence. First, the more developed Bohemia. Second, the relatively backward Carinthia and Tyrol, and then, after 1900, Galicia, especially Poles and Jews. Only in the last stages did the movement include substantial numbers of Ukrainians from remote eastern Galicia. Migration from Hungary and other East European countries was first composed of the minorities most in touch with the West. The distinctive feature of the emigration from Russia, which was the last major country of European emigration, was its non-Russian ethnic character. Emigration from Russia was firstly made up of peoples culturally most closely in contact with the West, that is, the Jews of the towns, the Baltic peoples, the Poles, and finally the Ukrainians. Thus, by the time of the First World War, the area of Europe from which migrants were drawn had spread to include almost the whole of the continent. The sources of heaviest migration have moved across Europe in a widened circle, from the center of first migration in northwest Europe to the latest in southern and southeastern Europe. Table 1. Leading sources of immigration at different periods of United States history. Period. Colonial, 1820 to 1860. Country and area. Great Britain and Northern Ireland. 1. Ireland. 2. Germany, mainly West and Southwest Germany, 1820 to 1830, Palatinate to Rhine hinterland. 1830 to 1840, Weser hinterland. 1840 to 1850, Elbe hinterland, Westphalia, etc. Period of largest volume of immigration, 1851 to 1855. Period 1861 to 1890. 1. Germany, mainly Eastern Germany. 2. Ireland. Period of largest volume of immigration, 1881 to 1885. 3. Scandinavia. Period of largest volume of immigration, 1886 to 1890. Period 1891 to 1920. 1. Italy. North up to 1890, south 1890 through. Period of largest volume of immigration, 1906 to 1910. 2. Austria-Hungary, Bohemia, Carinthia, Tyrol, up to 1900, Galicia, Hungary, 1900 through. Period of largest volume of immigration, 1906 through 1910. 3. Russia, chiefly non-ethnic Russians, Jews, Baltic peoples, Poles, Ukrainians. Period of largest volume of immigration, 1911 to 1915. Period, 1921 to 1930. Canada. Period of largest volume of immigration, 1921 through 1925. 2. Mexico. Period of largest volume of immigration, 1921 through 1925. 3. Italy, 1921 through 1924. 4. Germany. Period, 1931 through 1951. 1. Germany, primarily refugees. 2. Canada. End of Table 1. In the 145 years of unrestricted immigration into the United States, from 1776 to 1921, immigrants generally came when and where they were needed. There is no evidence that their arrival caused either unemployment or impoverishment. The contrary view was generally held by the Founding Fathers. James Madison, at the Constitutional Convention of 1787, said, quote, "That part of America which has encouraged them, the foreigners, has advanced most rapidly in population, agriculture, and the arts." End quote. Whether immigration was cause or effect, it is true today, as it was in Revolutionary times, that the richest regions are those with the highest proportion of recent immigrants. The Commission found a striking correspondence between per capita income and percentage of popular foreign-born, as illustrated by Figure 1. The per capita incomes are highest in regions with a high percentage of recent foreign stock, lowest where immigrants are few. Immigrants went to the regions where there was demand for labor, as expressed in high wages. In turn, their industry, their skills, and their enterprise were major factors in the economic development that has made these regions prosperous. Immigration has made a positive contribution to our economic life. Reliable evidence indicates that immigration neither contributes to nor aggravates unemployment. A careful study by the late Professor Harry Jerome, Migration and the Business Cycle, prepared for the National Bureau of Economic Research in 1926, discovered a clear correlation between immigration and economic conditions in the United States. In the period of unrestricted immigration, the volume of immigration rose during prosperity, but rapidly disappeared in times of depression when it would have contributed to unemployment. Figure 1. Immigration and income. A. Northeast. Percent foreign-born, 13.1. Per capita income, $1,690. B. West. Percent foreign-born, 7.6. Per capita income, $1,620. C. North Central. Percent foreign-born, 6.1. Per capita income, $1,540. D. Southeast. Percent foreign-born, 1.8. Per capita income, $1,140. E. South Central. Percent foreign-born, 1.5. per capita income, $1,030. Source, U.S. Department of Commerce. End Figure 1. The relation of immigrants and employment is presented in Figure 2, which shows that, in general, immigrants came when they were needed and stayed away when they were not. Before quota restrictions were imposed, immigration was large in periods of full employment, small in times of unemployment. The Great Depression of the 1930s began almost a decade after the passage of restrictive immigration legislation. The unemployment of the 1930s, therefore, could hardly be attributed to immigration. On the contrary, a number of distinguished economists believe the restriction of immigration to have been one cause of the Depression. Throughout American history, rapid increase of population had provided a constantly expanding market for our products. The decline in population growth incident to reduction of immigration and to the declining birth rate in the 1920s removed one factor contributing to our expanding economy. During the Depression, quota restrictions were of no significance. Even the small quotas for Southern and Eastern Europe were unfilled. As in the earlier periods, with or without quotas and restrictive devices, prospective immigrants had no incentive or desire to come to this country in time of depression. In fact, in the Depression years from 1931 through 1936, a total of 240,000 more aliens left than were admitted. The Commission finds no evidence that immigration either caused or aggravated the Depression. Historically speaking, therefore, immigration has supplied much of the brain and sinew, the human resources that have created our nation. It has come when and where manpower was in demand to build up America and to raise its standard of living, but it has not, of itself, caused depression and unemployment. The new immigrant has helped to enrich the native descendants of earlier immigration. Quota restrictions ignored the continuing need for immigration. In reviewing the history of debates on the problem of immigration, the Commission was impressed by the fact that those opposing immigration appear to have been influenced in this view by a pessimistic outlook regarding the future economic growth of the United States. The nation was barely founded before a congressman rose to say on the floor of the House of Representatives in 1797 that while a liberal immigration policy was satisfactory when the country was new and unsettled, now that the United States had reached maturity and was fully populated, further immigration should be stopped. However, such views have continued throughout our history. In 1921, the Immigration Committee of the House of Representatives again recommended complete termination of all immigration. By the 1920s, there was widespread fear that the country could not profitably absorb immigration in the volume received before World War I. The territorial frontier was gone. The country was filled up in the sense that good agricultural land was almost fully occupied and under cultivation. The economy was rapidly becoming industrialized, a mature economy was emerging, and therefore, it was argued, immigration had to be drastically curtailed. With the 1921 Quota Act, originally designed for a one-year emergency, there began a wholly new departure in American law. A limitation on the number of immigrants that could be admitted into the United States. The Immigration Act of 1924 not only carried into permanent law the concept of a limitation on numbers, but also initiated the formula of selection on the basis of race and nationality. The Immigration and Nationality Act of 1952 continued and strengthened the same principles. The onset of the Depression in 1929 seemed to validate the views of those who feared that economic maturity meant the end of economic growth in the United States. This did not prove to be the case. Our economy has expanded by leaps and bounds. Our gross national product in 1924 of $140 billion in 1951 dollars grew to $329 billion in 1951. Foreign exports of goods expanded from $6.5 billion, 1951 dollars, in 1924 to $15 billion in 1951. Manufacturing production increased by 140%, and agricultural output by 51% between 1924 and 1951. Our farmers had an average per capita income from farming of only $302 in 1924, in terms of 1951 purchasing power, which rose to $760 per capita in 1951. These are but a few examples of growth since the 1920s and of the dynamic nature of our economy. This economic expansion required an expanding labor force. The demands were met, as in the past, partly through natural growth and partly from migration. The labor force increased from 41.2 million in 1920 to 66 million in 1951. When the normal sources of European immigration were substantially cut off by our legislation of the 1920s, our industries had to seek other sources of labor. This they found in three ways. 1. By enormous migration from our own rural areas in the United States. 2. By increased immigration from Puerto Rico, the West Indies, and the non-quota countries of the Western Hemisphere. And 3. By special legislation providing for temporary immigration from neighboring countries. During World War II and after, many hundreds of thousands of workers were drawn from the farms to man the factories and other establishments of our urban centers. Since 1940, over 1.5 million Southern Negroes moved to the cities of the North and West to fill the manpower shortages. The Negro population of the North and West more than doubled through this migration. But this was not enough. This source of manpower had to be supplemented by some 200,000 Puerto Ricans and other West Indians. Quite aside from the movements of native white people in the United States, there were nearly 2 million total migrants who moved into the northern and western states from these internal sources in the decade 1940 to 1950, and the movement continues unabated. During the same period, there was a net foreign immigration of 1.5 million people that went chiefly to the industrial areas of the country. Thus, the total migration to the North and West, from the South and from abroad during the 40s was at least as large as the net immigration in the decade 1890 to 1900, the third largest decade of European immigration in our history. In other words, the northern cities continued to need immigrants, but had to get them mainly from elsewhere than Europe. But even this was not enough to meet the demands of our growing economy. Congress also found it necessary to enact special immigration legislation, admitting certain groups of immigrants temporarily to meet the manpower shortages, both in agricultural and non-agricultural employment. As a result of acute labor shortages in agriculture during World War II, special programs for recruitment of seasonal and temporary workers from Western Hemisphere countries were undertaken by intergovernmental agreements. Large number of aliens were involved in these programs, both during the war and after. The greatest number of Mexican farm workers legally in the United States for this purpose at any one time during World War II was 67,860 around August 1st, 1944. As many as 21,000 Jamaicans and 6,000 Bahamans, as well as small numbers of Canadians and other North Americans, entered the United States under similar programs from time to time during this period. After the war, and under a law enacted in 1948, this recruitment of immigrant agricultural workers was continued on a peacetime basis. During the year 1951, some 191,000 Mexican nationals were admitted temporarily for agricultural work. Even this movement of immigrants, authorized by Congress, is overshadowed by the illegal entry each year of over 500,000 Mexican wetbacks. Specific agricultural activities have sometimes received explicit congressional exemption from restrictive immigration provisions. Two enactments have authorized the granting of special quota immigration visas to skilled sheep herders to be charged against future quotas. Under 1950 legislation, 250 were permitted to enter, of whom 125 were admitted during the fiscal year 1951. Another statute in 1952 authorized the admission of 500 more sheep herders. In the original 1948 Displaced Persons Act, Congress provided a 40% preference for agricultural labor, a further indication of congressional recognition of immigration as a potential source of agricultural manpower. During the war, a manpower gap also appeared in the non-agricultural occupations. A total of 135,283 Mexican nationals worked on railroads in the United States from May 1943 to August 1945. More might have been used, but the Mexican government imposed a maximum ceiling of 75,000 who could be permitted in this country at any particular time. During the fiscal year 1951, some 10,000 Canadian woodsmen were permitted entry into Maine, Vermont, New Hampshire, and New York to fill a need for manpower not otherwise available. Another example of the use of immigration to meet labor shortages can be seen in the United States Department of Labor's certifications for waiver of the contract labor provisions of the pre-1952 Immigration Act. Such waivers were based on the unavailability of similar domestic labor. In the 7-year period from 1946 to 1952, there were 11,028 certifications, in addition to Canadian woodsmen. These certifications covered a total of 448 different occupations, many of which appeared year after year in this 7-year period. In the light of this experience, under the restrictive limitations on immigration under the laws in effect since 1924, the Commission finds that immigration continues to be what it has always been in our history, a source of necessary manpower. Despite the efforts to change this situation by shutting off immigration from its customary sources, the American economy still continues to demand some form of immigration to meet the manpower demands of a growing and vigorous nation. The United States needs more immigration. The United States needs more manpower. We need it to meet current labor shortages. We need it to meet the demands of an expanding civilian as well as military economy. And we need it to meet the requirements of national defense and security. Immigration is a normal and historic source of additional manpower. Manpower in an expanding economy. During the Commission's hearings, there was convincing testimony for the need of additional workers. In almost every section of the United States, both in industry and agriculture, labor unions, industry, economists, public officials, religious leaders, job placement officials, civic workers, and others all testified that there were labor shortages ranging from temporary to permanent, from reasonably necessary to critical. Agriculture. A need for more agricultural labor was voiced from many quarters. Knox T. Hutchinson, Assistant Secretary of Agriculture, testifying for the United States Department of Agriculture, told the Commission that we have a great need for farm manpower. He advised the Commission as follows, quote, "Our goals and sights for the future must encourage progressively higher levels of agricultural output. There are within this picture of future food and fiber requirements both the need and absorptive capacity of American agriculture for some augmentation of the supply of labor which a carefully liberalized policy of immigration would make available." End quote. The Department of Agriculture pointed out that although our population has been increasing, there has been a decline of almost 2 million farm workers in the last 40 years, from 1910 to 1950, and that a further decline of another 1.25 million can be expected by 1975. In 1951, our farm employment was 300,000 under 1950 and 700,000 under 1949. It is estimated that by the end of 1952, we may average 250,000 fewer than in 1951. These declines in farm workers took place despite the importation of farm labor from Mexico, the British West Indies, and Canada for seasonal farm work. The Department of Agriculture warned that if the present rate and trend continue, by 1975, only 10% of our population will be farm population. The United States Department of Agriculture also informed the Commission of the results of its survey of current agricultural manpower. Reports of farm manpower difficulties came from all sections of the United States. Almost 1/3 of the states report that the greatest difficulty is in the short supply of regular year-round hands. Farm shortages were especially serious in dairy, livestock, poultry, sheep ranches, and some other types of farming. The Department of Agriculture indicated that permanent immigration could be a source of regular farm workers and would contribute, quote, to meeting the needs of the moderate-sized commercial family farm that required year-round hired labor, end quote. Through immigration, quote, an important contribution can be made to our agricultural economy, end quote, it asserted. Major farm organizations presented similar views. The National Grange declared in a statement to the Commission that, quote, it has been increasingly difficult for farm operators to find competent and reliable hired men, and if the present trend away from the farm continues, the American people might have to reduce the quality and level of their present diet. This would be undesirable from the standpoint of the American people as a whole, and also from the standpoint of farmers who need and can use extra labor if it is of high quality." End quote. The National Farmers Union testified that it, quote, believes that this nation could readily welcome and assimilate more than 154,000 immigrants each year. End quote. The Commission noted, however, that those who urge the need for more people to meet manpower shortages have also insisted that if immigration is to help meet this need, there must be careful selection of competent farmer immigrants if they are to meet the rather specialized requirements of American agriculture. In connection with the needs of agricultural manpower, it is important to note that a basic change is taking place in our agricultural economy. In some cases due to labor shortages, in other instances because of economy of operations and greater profit yield, farming is becoming mechanized. To the degree that mechanization and technological advances are applied to farming, experience has shown the possibility of a greater agricultural output with less manpower. This factor has variable application in different areas of the country and to different kinds of farming. It seems to have reached its greatest development on the wide grain fields of the Great Plains, with an increasing size of the farm and an industrialization of agriculture. In such areas and for such farming, the Commission heard far less of need for more manpower. On the other hand, as has been indicated, the Commission's hearings disclosed a consistent and responsible claim of labor shortages for dairy, vegetable, livestock, poultry, and other such farming. The Commission found that the agricultural manpower situation was spotty. In some areas, there is a surplus of agricultural labor as judged by wage rates, per capita output, and other measures of underemployment. In some areas, there is a relative balance of supply and demand. But in many other areas of the country, there is both a need for agricultural labor and a demand that it be satisfied through immigration. Industry. The need for manpower is more general and acute in non-agricultural occupations, as evidenced by the fact that these occupations have attracted many hundreds of thousands of workers from farming in the past few years. The Commission received convincing testimony that the country is enjoying a condition of full employment, with ample opportunities and needs for additional workers in many quarters. The New York State Industrial Commissioner, Edward Coursey, testified that, quote, "We are suffering from a very great labor shortage in this state, both on the farm and in the factory." End quote. He stated that there are 350,366 unfilled non-agricultural jobs and 4,500 unfilled farm jobs in New York State alone. The Commission found that witnesses were convinced of the continued needs for more manpower in the future. The Secretary of Labor of the United States, Maurice J. Tobin, testified as follows, quote, "As an overall conclusion, I would say that the future holds for us a continuing fairly tight situation, so far as manpower resources are concerned, and that we may safely gauge our immigration policies accordingly." End quote. The United States Commissioner of Labor Statistics, Ewan Clegg, testified in a similar vein. Quote, Although we cannot rule out the strong possibility of short-term fluctuations in employment conditions, we may confidently look forward to a continued uptrend in our nation's manpower needs. This sustained demand for manpower for national defense will be superimposed on our expanding normal peacetime requirements." End quote. He also pointed out that despite the continuing need for more manpower, the immediate future labor supply may well be declining. This is due to the fact that the number in the age group which would normally provide the main addition to the nation's workforce during the next decade has actually declined. In 1950, there were 2 million fewer young people in the age group 10 to 19 years than in 1940, or a decrease of 8%. As a result, the annual inflow of young workers into the labor force is currently at the lowest point in many years, and will continue low until the larger numbers of children born after 1940 reach working age. Thus, the best evidence available to the Commission shows that the United States will continue to need more manpower, both in agriculture and in industry. Our expanding economy needs an expanding labor force. The needs of our industries especially have proved to be and are likely to continue to be enormous. In view of the shortages of young adults over the next few years, the American economy will have to look, even more than in the recent past, to other domestic sources of labor supply. The Commission's study brings it to the conviction not only that the United States needs more manpower, but that the United States needs more immigration to fill this demand. End of Section 4. Section 5, Of Whom We Shall Welcome. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Recording by PhyllisV. Whom We Shall Welcome. Report of the President's Commission on Immigration and Naturalization. Section 5. National Defense. Lack of manpower reserves. Our potential needs for immigration should not be judged in terms of peacetime civilian requirements alone. We must also consider our human resources for our national defense and security. This consideration is quite aside from the significance of immigration in terms of the current ideological war between the forces of totalitarianism and the forces of democracy. The significance of immigration in the latter connection will be considered in Chapter 3. Our present manpower position in relation to potential enemies has drastically changed since World War II. In that war, we and our allies had an impressive superiority in numbers over the smaller populations of Germany, Italy, and Japan. Today, the situation is reversed. It is our potential enemies that have a preponderance of manpower, and it is we that would have to husband our manpower resources in a general war. The United States Commissioner of Labor Statistics testified before the Commission that the facts of our population growth and structure, quote, emphasize the frequently reiterated statement that, in comparison with countries found within the Soviet orbit, our greatest relative shortage is in manpower resources. Our national self-interest requires that every consideration of our situation, including immigration policies, recognize this paramount fact. End quote. expert testimony to the Commission revealed that the labor force of the Soviet Union, estimated to be some 108 million in 1951, very substantially exceeds ours, which is given by the Bureau of the Census as 66 million in 1951. In addition, the Soviet labor force will increase much more rapidly than ours, owing to the high birth rates in Russia before World War II. The strain of war on our manpower would be greater than during World War II, not only because of greater need, but also because the possibilities for rapid expansion of the labor force are much more limited than in 1941. For one thing, we are working longer hours. The average work week in manufacturing was 41.5 hours in October 1951, as compared with 39.4 hours in October 1940. At the outbreak of World War II, we had major reserves that are now either unavailable or available in much smaller quantities. A, the unemployed. B, women not now in the labor force. C, underemployment in agriculture. And D, young workers. Unemployment. In April 1940, at the time of the decennial census, there were 8,360,000 unemployed. By October 1941, some of this reserve had been absorbed in defense effort, but there remained 3,840,000 unemployed. Today, the reserve is almost non-existent. The number of unemployed has sunk to 1,284,000, which is little more than that involved in the normal job turnover. Today, we have almost full employment and no substantial reserve with which to meet a sudden crisis demanding both military and industrial manpower. Woman in the labor force. A substantial part of manpower needs in World War II were met by bringing some 5 million additional women into the labor force. In October 1952, there were 1.5 million more women in the labor force than at the peak of war employment in 1944, and the percentage of all women who held jobs was almost as high. In other words, we are now using the potential female labor force almost as fully as we did at the height of World War II. A fact all the more remarkable since the baby boom of the past few years has greatly increased the number of young mothers who must stay home to care for small children. The potential labor reserves among women not in the labor force are thus much smaller than in 1941. Underemployment in agriculture. A careful study on underemployment of rural families, prepared for the Joint Committee on the Economic Report in the 82nd Congress, arrived at the conclusion that there were 2 million underemployed farm operator families in 1945, located primarily on small, unproductive farms in the southeastern states. 7 years ago, these families included a potential addition to the labor force equivalent to 2.5 million workers. As indicated, this underemployment in agriculture provided a partial substitute for immigration in meeting the war and post-war needs of industry. Due to mechanization and more efficient farming methods, additional farm workers are being freed in some areas for other employment. But experience shows that they do not become available to meet agricultural manpower shortages in other parts of the country. Potential further gains to the industrial labor force are becoming more limited, however, as the farm population declines and the reserves are progressively tapped by movement from the farms to the cities. It is a question how much further we could go in wartime without crippling essential agricultural production. Young workers. Young adults are the most flexible part of our labor force, whether in terms of geographical mobility or in terms of training for new jobs. This section of the labor force is of crucial importance from the standpoint of defense, whether it is employed in the armed forces or to provide a fluid labor force adaptable to rapidly changing needs. However, our supply of young people is smaller and shrinking, owing to the low birth rates of the Depression years. The number of young people of the forthcoming military ages is declining in the United States. In the 10-year period between 1940 and 1950, there was a drop of 2 million people in the age group 10 to 19 years of age. This and other basic changes in our population structure are adversely affecting human resources at a time when security needs are increasing. Population structure. Certain unfavorable trends in our population structure may adversely affect our national welfare and security. Growing older. The American population is growing older. Since 1900, the median age has risen from 23 to over 30. Several factors have caused this aging of our people in the last 50 years. We live longer, we have fewer children, and our restrictive immigration policies have cut off a former plentiful source of young adults. Not only has the restriction of immigration reduced the number of immigrants, but in addition, its preferences and categories favor older persons. Normal immigration is heavily concentrated in the young adult ages. Prior to immigration restrictions, over 3/4 of our immigrants were in the highly productive age group 16 to 44. And they were particularly concentrated in the age group 16 to 29. As a result, immigration brought us more producers than consumers, and more workers than dependents. It brought us a ready-made labor force that cost us nothing in terms of rearing and education. Because of this concentration in the young adult ages, even a comparatively small increase in immigration could bring about an important increase in the young labor force. This fact is illustrated even by the recent Displaced Persons Program, in which a special effort was made to move whole families. The roughly 400,000 persons admitted were a young and growing addition to our population. Over half, 51%, were in the prime working ages of 20 to 44, as compared with only 37% in the United States population as a whole. Less than a fifth, 19%, were over 45, as compared with 28% in the total United States population. An aging population means that we have more older people, retired persons, and disabled, who must be supported by persons in the working ages. As the average age of a population goes up, the burden of old age dependency grows, and the taxes necessary to support the aged increase. At the same time, the labor force is more and more made up of older workers who lack the adaptability required to meet many essential economic needs. Finally, the baby boom of the last few years has meant a great increase in child dependency at a time when our young labor force is shrinking, thus further increasing the burden on the people in the working ages. These developments would not be serious in a peacetime economy as productive as ours. The older worker and older citizen has much to contribute to the nation in stability, judgment, and experience. But the effect of our present dearth of young adults is of serious consequences to our national defense and security. Changes in the age structure of the United States are shown in Figure 3. In the next few years, the United States will have a deficit of young men and women, chiefly as a result of the low birth rate in the Depression decade of 1930 to 1940. Without more immigration, only 20% of the United States population in 1955 will be in the ages 15 to 29. Larger immigration would tend to fill this important gap in our population structure. In 1925 to 1929, the last period of normal immigration in the United States, 55% of the immigrants were in the ages 15 to 29. The crucial age group for military service, the people in the age bracket of 18 to 24, is declining and will be declining during the next few years. The number of men annually reaching the military age of 18 is now 200,000 less than in 1940. The number of men available for induction in military service under present laws will be comparatively low during most of the decade. If we will let it, immigration in the next few years could provide a valuable supplement to this shrinking manpower at the critical ages of prime military importance. More women than men. During our entire history, until 1944, the United States had more men than women. This is no longer true. In 1900, there were 105 men to every 100 women. By 1944, the balance had changed, and by 1950, there were only 98 men to every 100 women. By 1950, we had 1,030,000 more women than men. Much of this excess is in the normal marriageable ages of 20 to 44, where we have 900,000 more women than men. Restrictive immigration laws have played a major part in this fundamental change in our population. Since 1820, immigration has contributed a very high percentage of men to this country. In the period of free immigration, from 1820 to 1921, there were 150 men to 100 women among those admitted to the United States. This same pattern of more men than women prevailed among persons admitted under the Displaced Persons Program, even though there was a conscious and deliberate effort to move families as a whole. Under the Displaced Persons Act, over 119 men were admitted for each 100 women. The effect of restrictive immigration are evident in the following table, which shows the percentages of male and female immigrants in the 5 decades of this century. Table 2. Proportion of males and of females among immigrants, 1901 to 1950. Years, 1901 to 1910. Percent males, 69.8. Percent females, 30.2. Years, 1911 to 1920. Percent males, 63.5. Percent females, 36.5. Years, 1921 to 1930. Percent males, 55.6. Percent females, 44.4. Years, 1931 to 1940. Percent males, 43.4. Percent females, 56.6. Years, 1941 to 1950. Percent males, 33.8. Percent females, 66.2. End of Table 2. The effects of restrictions in the 1921 and 1924 Quota Acts were already observable in the 20s. When the restrictive national origins quota law took effect in 1929, the number of men entering the United States as immigrants dropped very considerably below the number of women. This was due to the fact that small quotas tend to be filled by wives and relatives of earlier immigrants who have quota preferences, as opposed to new male immigrants who predominate in normal overseas immigration. Whereas previously as much as 2/3 of the immigrants were men, now as much as 2/3 are women. Thus, immigration played an important part prior to the Restrictive Act of 1924, which went into effect in 1929, in maintaining a numerical superiority of men over women in the United States. Since 1929, it has contributed to a changed pattern. The changing sex ratios in our population and the growing surplus of women can have serious repercussions. The effect upon our labor force, upon the number of wage earners supporting families, and upon our available military reserves is obvious. The social and moral effects of reduced marriage possibilities for American women can be of the greatest significance. A renewal of a more substantial volume of normal immigration would tend to redress this growing imbalance in the American population. Larger immigration would tend to fill gaps in our population structure. Absorptive capacity. The Commission does not believe that it is advisable to base our immigration policy wholly on the specific needs of the United States for more manpower. Other considerations are equally, if not primarily, compelling, such as our humanitarian traditions, our foreign policy, our security needs. However, our manpower needs do have important relevance to what American immigration policy ought to be, and the Commission's studies indicate that our present immigration policies are a serious barrier to the fulfillment of those needs. The restriction of immigration in the 1920s was due largely to a pessimistic view of America's future. The Commission's belief, from the testimony at its hearings and from other information available to it, is that the United States now has and will continue to have a dynamic, expanding, and flexible economy needing more people, and will be fully capable of absorbing a reasonable increase in our present maximum immigration quota. In the past, immigration gave us our most important resource, our people. There is every indication that we have not reached, nor are we likely in the foreseeable future to reach, the point at which new immigration will no longer contribute to our further growth, strength, and prosperity. The United States is not overpopulated. We are now a nation of 157 million people. The productive capacity of our country is rising rapidly today, perhaps as rapidly as at any time in our history. Our average level of living is the highest in the world, higher than it has ever been before, and it is moving forward despite the effects of war, of a massive defense effort, and of our continued population growth. This is not a picture of overpopulation. A report of the Immigration Section of the Commonwealth Club of San Francisco stated as follows, quote, "During the past 6 decades, production has increased by nearly 8 times. We nearly doubled our annual production every 2 decades. In other words, our production has risen nearly 100% in 20 years, whereas our population has risen only about 20%. Our production growth has always exceeded our population growth." End quote. And the future looks bright. Our resources and our food production are adequate to meet any reasonable increase in population. All indications are that our material standards will continue to rise. The President's Materials Policy Commission reached its conclusion as to the adequacy of our national resources in the light of an anticipated population increase of 27% from 1950 to 1975, a doubling of the gross national product in that 25-year period, a decrease of 15% in hours worked, and an increase in the material standard of life. These assumptions would mean, for example, a 62.5% rise in the number of passenger cars in use, an increase of from 62.5% to 87.5% in the number of telephones in use, and other increases in like measure. As for the nation's ability to feed its population, there is no reasonable doubt that in the foreseeable future we can have food for all our people. The Assistant Secretary of Agriculture testifying before the Commission said, quote, "I have no fear that the American population will run short of food." End quote. Separate studies by the Department of Agriculture, the Land Grant Colleges, and the President's Materials Policy Commission all indicate that with the full use of the best known and already proven farm practices, farm production can be raised sufficiently to meet all demands likely to be made by the American population of 1975. Therefore, on the basis of reliable evidence, the Commission has no misgivings of the ability of the American farmer to provide in the foreseeable future an adequate food supply for a well-fed nation. The United States can absorb more than the present maximum quota. Ours is a healthy, and at present, a rapidly growing population. Since the war's end in 1945, we have already added 17 million people, 9/10 as a result of the excess of births over deaths, only 1/10 from immigration. Estimates of future population by the United States Bureau of the Census suggest continued growth, although not necessarily at the present rates. The medium estimate indicates a United States population of 171 million in 1960 and 190 million in 1975, assuming immigration at the present levels and a considerable drop-off from the present baby boom. Of the 14 million prospective growth between 1952 and 1960, less than 1/8 would be due to foreign immigration in its present volume. The population is growing at a rate of over 2.5 million per year. Obviously, in this circumstance, the effect of immigration under a quota ceiling of either 154,000 or 250,000 will be a minor factor in the general population growth. Other countries have shown that a far higher proportion of immigrants can be absorbed. Australia, whose total population is about that of New York City, has been absorbing immigration at an average of 134,000 per year. This is a rate of immigration in relation to population 20 times that provided by our present quota ceilings. In Chapter 4, the Commission recommends a maximum ceiling of some 250,000 quota immigrants each year, based upon 1/6 of 1% of the 1950 population of the United States. The evidence before the Commission indicates that such figure is well within the present safe limits of absorption into the American economy for the foreseeable future. The attitude of organized labor is significant in this regard. In testimony before the House Committee on Immigration and Naturalization in 1946, the Congress of Industrial Organizations, CIO, stated, quote, "Naturally, a labor organization representing 6 million American workers would not be inclined to support measures which would threaten the job security of its own members. However, the CIO realizes from past experience that immigration is automatically checked in periods of unemployment while it rises in periods of prosperity. That in the past, immigrants have contributed in innumerable ways to the wealth and well-being of this country. That a large proportion of immigrants are not potential job seekers, but women and children. That new blood in industry, agriculture, business, and the professions enriches our national life, and that the best and most enlightened thought on this subject opposes arbitrary, prejudiced, and superficial legislation to curtail immigration into the United States." End quote. During legislative discussions on the Displaced Persons Act, labor leaders indicated that an annual immigration of 250,000 could have no adverse effect on our economy. The late William Green, then president of the American Federation of Labor, AFL, testified, quote, "We do not believe that the admission of as small a number as 400,000 over a period of 4 years, in addition to the quota's 154,000 annually, will seriously affect our employment or unemployment problem." End quote. The late Philip Murray, then president of the CIO, presented a statement which said in part, quote, "Let me say for the record that we in the CIO can find absolutely no basis in fact or reason for the fear that admitting 100,000 immigrants a year for 4 years, in addition to the quota's 154,000, would jeopardize the jobs of American citizens. I do not think it is the true friends of labor who will argue that our economy cannot stand the addition of less than 1/10 of 1% of the number of our population annually for 4 years without creating unemployment." End quote. A factor that must be borne in mind is that our immigration laws have a built-in brake, so to speak, which can protect the United States against such difficulties. The provision which authorizes the denial of a visa to a person likely to become a public charge has in past experience, particularly in the Depression of the 1930s, proved to be an effective protective device in this regard. Furthermore, the experience of the Displaced Persons Commission indicates that a sensitive resettlement program could bring 400,000 people into the United States, keep them out of areas of labor surplus, and direct or route them to areas of labor shortages. In February 1950, that commission reported as follows, quote, "The impact of displaced persons on aggregate unemployment in this country has been insignificant. Even in critical unemployment areas, displaced persons have been a negligible factor in the degree of unemployment." End quote. Normal experience has shown that only about half of the immigrants coming to the United States go into the labor force. Since the total population grew 2/3 between 1920 and 1950, an increase of immigration from 154,000 to 250,000 per year could scarcely present serious problems of absorption. On the other hand, it could, 1. Provide by 1960 an addition of 500,000 to 1 million in our manpower of military age, 2. Relieve special manpower shortages of importance both for the needs of defense and of an expanding peacetime economy, and 3. Continue to supply us with the talents and skills from abroad that have so strengthened and enriched our civilization. End of Section 5. Section 6, Of Whom We Shall Welcome. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Recording by PhyllisV. Whom We Shall Welcome. Report of the President's Commission on Immigration and Naturalization. Section 6. Part 2, Chapter 3A, Immigration and Our Foreign Policy. In the executive order which established it, the Commission was given the task of considering, quote, the effect of our immigration laws and their administration, including the national origin quota system, on the conduct of the foreign policies of the United States, and the need for authority to meet emergency conditions such as the present overpopulation of parts of Western Europe and the serious refugee and escapee problems in such areas. End quote. Lessons of History. None can truthfully say that the Japanese attack on Pearl Harbor was a direct result of the Immigration Act of 1924. However, responsible experts have assured the Commission that the Japanese exclusion clause of the 1924 Immigration Act contributed to the growth of the nationalistic, militaristic, an anti-American movement in Japan which culminated in war against the United States. While the 1924 bill was under consideration, the Japanese ambassador pointed out that the exclusion clause would be a serious blow to Japanese self-esteem. His counselor of embassy warned that it would undercut the pro-democratic forces in Japan and strengthen the militarists. Secretary of State Hughes urged Congress not to, quote, affront a friendly nation, end quote, by placing a legislative stigma upon its people. But the bill became law, and the consequences predicted for it came to pass. Ultra-nationalist and militarist elements in Japan gained strength and fervor in their efforts to whip up hatred of America and to spread the doctrine of, quote, Asia for the Asiatics, end quote. One of Hitler's excuses for taking Czechoslovakia and attacking Poland was the need for, quote, living space, end quote, for Germany's growing population. Mussolini used Italy's overpopulation to excuse his attack on Ethiopia. The Japanese government attempted to justify its invasion of Manchuria on similar grounds. Without in any way justifying the wrong done, the Commission believes these examples demonstrate the vital role that migration or lack of migration plays in world affairs. American immigration law, unfortunately, has not always been formulated with an eye to its effects on our international relationships. But there have been instances of recognition, particularly in recent years. The repeal of the Chinese Exclusion Act in 1943 and the repeal in 1946 of exclusion directed against India in favor of quotas for both countries were themselves implementations of foreign policy. The repeal of Japanese exclusion in 1952 further demonstrated a growing American realization that immigration policy can be a positive as well as a negative factor in foreign policy. The present non-quota status of immigrants from the Western Hemisphere is another recognition of the foreign policy aspects of immigration law. Theoretically and practically, the national origins formula could have been applied to these nations too. But here our, quote, good neighbor, end quote, policy and considerations of hemispheric foreign relations seems to have prevailed. The Displaced Persons Act is another recent recognition of the relationship between immigration and international stability. Our whole national history illustrates a point which has only recently come to be recognized in its own light. American immigration policy and law must be formulated in awareness of their international impact and must be designed to advance our foreign policy. Responsibilities of leadership. Our present immigration policy dates from the period following the First World War. That was only some 30 years ago, but it was a different era of world and of American history. Then the United States was seeking to avoid the international responsibilities which its power and stature placed upon it. Our present immigration laws are rooted in the period of America's blindest isolationism. Today, the United States is in a different position. For good or ill, this country now occupies a position of leadership among the nations of the free world. We cannot avoid the responsibilities that fall on the shoulders of a leader. The United States can never again turn its back on the facts of international relations. Although the United States is a world leader, its leadership is effective in only part of the world. This means, among other things, that our responsibilities toward those peoples who share our outlook are sharper and clearer. In the struggle against communist totalitarianism today, as against other totalitarianisms yesterday, it is obvious that for our own well-being we must have genuine friends and firm partners. In this situation, any action the United States takes or fails to take inevitably affects the partnership we speak of as the community of free nations. And because it affects the partnership, it also reacts upon our own position of leadership. This is especially true in connection with actions which relate directly to the nationals of other countries. This is not to say that our immigration laws should be determined by what other countries or people want, but it is to say that what the United States itself should want in its immigration laws should be tremendously affected in our own welfare and security by the effect such laws have on foreign countries and peoples. The responsibilities of leadership include and require, quote, a decent respect to the opinions of mankind, end quote. Immigration is part of foreign policy. If any view presented to the Commission can be said to be substantially unanimous, it is that our immigration law is part of our foreign policy. It came to the Commission from diplomats, businessmen, scholars, clergymen, labor and farm leaders, civic leaders, club women, in fact, from almost every walk of life. Officials dealing with American foreign policy feel this very strongly, as is shown in their testimony before the Commission. The Secretary of State of the United States, Dean Acheson, advised, quote, "Immigration, like most important facets of our national life in these times, is closely linked with our foreign policy and objectives. Our immigration policy with respect to particular national or racial groups will inevitably be taken as an indication of our general attitude toward them, especially as an indication of our appraisal of their standing in the world. It will, therefore, shape their attitude toward us and toward many of our other policies." End quote. The Director of Mutual Security, W. Averill Harriman, stated, quote, "The kind of immigration policy we adopt is a factor in the world struggle between democracy and totalitarianism." End quote. William H. Draper, United States Special Representative in Europe and formerly Under Secretary of the Army, stated to the Commission, quote, "Whether we like it or not, we are part of the world, and we can no longer disassociate ourselves from what happens elsewhere. In endeavoring to strengthen the economic and military defense of the free world, and particularly of the North Atlantic community, we should recognize immigration policy as one of the elements in achieving economic and political stability as well as social equilibrium." End quote. The Psychological Strategy Board's consultant, Edward M. O'Connor, told the Commission of his conviction that, quote, "Our immigration law, together with its enlightened administration, is a fundamental instrument in the conduct of our relations with other nations and must at all times, and particularly in times of international crisis, be geared to a dynamic, purposeful, and far-sighted policy of world leadership." End quote. Similar concern for the relationship between immigration and foreign affairs was expressed by outstanding private citizens. Russell W. Davenport, former editor of the magazine Fortune, testified, quote, "Nothing perhaps has affected the world standing of the United States so deeply, in so many ways, over so long a period as its immigration policy. The United States has always stood forth before the nations as a haven of refuge from tyranny and disorder, and this fact has profoundly affected the traditions of our country and of our free way of life. Moreover, as we look toward the future, our immigration policy appears to become more important rather than less. We are a symbol of freedom, and the world looks to us to define in concrete ways how freedom can be achieved. Our immigration policy is vital to that definition." End quote. Miss Anna Lord Strauss, past president of the League of Women Voters and former member of the American delegation to the United Nations General Assembly, stated to the Commission, quote, "I had the opportunity to learn something of that when I was over in Paris at the General Assembly at meetings with representatives formerly from countries that are behind the Iron Curtain who were living in Paris. We had discussions at that time as to what the United States might do to be more helpful. In these discussions, which were very frequent, very frank, and quite unfavorable as to some of the actions of the United States, There was an underlying friendliness to us, but a difficulty in being able to interpret to their people our country. And time again, it was an immigration problem that was at the root of it. Because, as they kept saying, no matter what you say, if you don't act according to your professions of faith and your statements, they will discount entirely what you say. And the immigration question came up very frequently in quite a variety of discussions that I had with those people." End quote. Mrs. Z. W. Schroeder of the General Federation of Women's Clubs declared, quote, "I would like to particularly add emphasis as to the question of the co-relationship between immigration laws and restrictions in our entire foreign policy. So my plea is this: your immigration laws in this country, our immigration laws, should be a flexible instrument of our foreign policy." End quote. J. D. Zellerbach, San Francisco industrialist, wrote the commission, quote, "My strong conviction is that the present immigration laws are in direct conflict with United States philosophy and policy on foreign affairs and are unrealistic in facing up to world conditions." End quote. The president of the American Farm Bureau Federation, A. B. Klein, wrote to the commission, quote, "United States immigration policy should be made to serve and support the overall national policy on international relations." End quote. The late Philip Murray, president of the CIO, stated to the commission through Alan Haywood, executive vice president, quote, "Our immigration policy is a part of our overall national policy. For us, at the very time when we are striving to build a mutual security system in cooperation with our allies abroad, to make our immigration and naturalization laws ever more virulently isolationist and anti-foreign, not only makes very little sense, it embarrasses us in the pursuit of the wider objectives of our foreign policy. Both our national interest and the deep humanitarianism which has always characterized Americans as a nation require that we reverse this trend of the last 2 years and establish a new policy on immigration and naturalization which will be consistent with 20th century conditions and ideals." End quote. Many of the country's religious leaders expressed the same view, that American immigration law is as much a part of our foreign policy as a foreign treaty. The National Council of Churches of Christ, in a resolution of March 1952 presented to the Commission, stated, quote, "We believe it is of the utmost importance that legislation be enacted that will conform with our democratic tradition and with our heritage as a defender of human rights. The adoption by Congress of enlightened immigration and naturalization laws would add immeasurably to the moral stature of the United States and would hearten those nations with which we are associated in a common effort to establish the conditions of a just and durable peace." End quote. In discussing this resolution, Mrs. Mildred McHaffie Horton, officer of the National Council of Churches of Christ and formerly president of Wellesley College and director of the Waves, stated, quote, "Our immigration policies, or their administration, have alienated us from parts of the world whose goodwill is important. I want the Commission to know that there are people, and many of them, who are more afraid of losing the friendship of our friends and potential friends than we are of the threats of our enemies. There are people, and many of them, who believe that America is safest when she generalizes the principles she accepts for herself and takes seriously the idea that all men are endowed by their Creator with certain unalienable rights, including life, liberty, and the pursuit of happiness. Immigration and naturalization policies which thwart those rights for the rest of the world will not permanently strengthen or safeguard the United States of America." End quote. Dr. Paul C. MP, Executive Director of the National Lutheran Council, called the Commission's attention to the fact that, quote, "the new immigration law is not geared to current world needs, but rather is related to historical circumstances of many decades past. The refusal to open our doors to refugees would be a staggering blow to the strength of our moral leadership in the current ideological world struggle." End quote. The Missouri Synod Lutheran Church was represented at one of the Commission's hearings by Reverend Werner Kuntz, who said, quote, "Some of the things which I read in Public Law 414 seem more akin to the superiority complex that was spawned out of the foulness of Nazism than to the humanitarian attitude which our fathers taught us. It is not the kind of thinking that one should expect of a nation that has been thrust into a position of world leadership and whose example can shape a better destiny for a disordered world." End quote. The Archbishop of Boston, the Most Reverend Richard J. Cushing, submitted a statement to the Commission which included the following observations, quote, "The above indicated discriminatory and undemocratic features of the McCarran-Walter Law are to my mind a grave potential threat to our domestic development and our international leadership." End quote. Monsignor Edward E. Swanstrom, Executive Director of War Relief Services, National Catholic Welfare Conference, testified as follows, quote, "We need an immigration program that is sufficiently elastic to enable whatever administration may be in office to face up squarely to a domestic and foreign policy which is in keeping with the position of world leadership which the United States enjoys today. It is foolhardy to lose sight of the fact that our immigration policy has a foreign as well as domestic impact. Our immigration policy has as great an effect on our neighbors as the technical and economic assistance we are extending abroad. Our immigration policy has an economic, psychological, and political character of an extent that would be difficult to measure. In light of these considerations, I think it is most fortunate that the creation of your commission has given us an opportunity to reassess our entire immigration and naturalization structure and policy. We have today an American policy on immigration which is completely outmoded, out of harmony with our ideas and actions, and completely at variance with the foreign policy which we are pursuing in accordance with such ideals." End quote. Bruce M. Moeller, Director of the Bureau of Immigration of the National Catholic Welfare Conference, urged that, quote, "The immigration and nationality law of the United States should reflect, or at least be adaptable to, the foreign policy of the country." End quote. Rabbi Abba Hillel Silver of Cleveland, Ohio, stated before the Commission, quote, "Racial discrimination creates disunity at home and resentment abroad. It interferes with our foreign relations and the role of international leadership which destiny has thrust upon us in recent years. It is one of the fundamentals of our political philosophy and an essential part of our foreign policy to treat all peoples alike, regardless of race or origin. We stand committed to the principle of fundamental human rights for all men alike. We cannot press for international acceptance of these principles, and at the same time offend nations and races by discriminating against them in our own immigration laws." End quote. Lester Gutterman, speaking for the American Jewish Committee and the Anti-Defamation League of B'nai B'rith, declared that, quote, "Our immigration policies and practices are of vital importance in preserving the health of our democratic American society and play a major role in our country's leadership in the maintenance of a stable world order." End quote. It is significant that during 1952, the governments of Canada, the United Kingdom, and the Philippine Republic have, through diplomatic channels, called attention to certain irritating inequities and administrative complexities of the Immigration and Nationality Act of 1952. Programs of action. Testimony before the Commission that America's immigration policy is inextricably bound up in our foreign relations is fully corroborated by the actions of our government. Through the United Nations, through other international organs, and through programs of its own, the United States has participated, often as a leader, in every important post-war attack upon the problems of international population pressure, migration, and resettlement. Almost every part of the United Nations organization comes into contact, in one way or another, with some aspect of the problem of people moving across borders. In most instances, that contact is limited or incidental. In quite a number, however, it is direct and even exclusive. UNRRA, from 1944 to mid-1947, had a displaced persons program to which the United States contributed some $58 million, not counting the supplies and transportation granted by the Army. From 1947 to January 1952, the International Refugee Organization, IRO, which was solely concerned with refugees, received $237 million, nearly 60% of its budget, from the United States. The United Nations High Commissioner for Refugees is getting about $250,000 from the United States in 1952 to 1953, and is seeking to raise more funds. Congress has authorized, in the Mutual Security Act of 1952, up to $50 million for Arab refugees in the Near East, and up to $45 million for Korean relief, both to be administered by UN organizations. The Intergovernmental Committee for European Migration, formerly the Provisional Intergovernmental Committee for the Movement of Migrants from Europe, formed in 1951 by 15 governments at the instance of the United States and now comprising 20 countries, has received nearly $20 million in the last 2 years from this country. The Organization for European Economic Cooperation, the European Coordinating Agency for the Marshall Plan, and later for the Mutual Security Agency, is concerned with migration as a method of balancing manpower needs for higher production. So also is the North Atlantic Treaty Organization, NATO, whose concern with manpower is more pressing as an aspect of Western defense. Independently, the United States operated a 4-year program that brought nearly 400,000 displaced persons to this country. A total of about $19 million of United States appropriated funds went into this program, for the President's Escapee Program to assist Iron Curtain refugees, $4.3 million in appropriations and $1.9 million in counterpart funds have been made available. The leading role the United States has played in most of these activities and our financial support give conclusive proof that this country recognizes the importance of relieving population and refugee pressures and of facilitating the movement of persons. In practice, however, we are faced with the fact that our immigration laws are discriminatory, obsolete, and fail to measure up to the needs of our foreign policy. End of Section 6. Section 7. Of Whom We Shall Welcome. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Recording by PhyllisV. Whom We Shall Welcome. Report of the President's Commission on Immigration and Naturalization. Part 2, Chapter 3b. Discriminatory Immigration Laws. American immigration policies have frustrated and handicapped the aims and programs of American foreign policy throughout the period since 1924. The interference is acute today. The contradictions are sharper now, in part because the 1952 law is more restrictive than before. The major factor, however, is the new circumstance of American leadership in the world rivalry between democratic freedom and communist tyranny. The major disruptive influence in our immigration law is the racial and national discrimination caused by the national origins system. Reference has been made to Japan's reaction to the Exclusion Act of 1924 and the generally held view among informed people that our discriminatory immigration law was a contributory factor to Japan's attack upon the United States in World War II. However, even now, with the removal of all outright Oriental exclusions, the evil seeds of our former policy remain. It seems quite likely that current Chinese attitudes reflect to some extent the damage done earlier. Certainly, Japanese propaganda during the war, both in China and in the rest of Southeast Asia, was effective, particularly among intellectuals who were sensitive to the immigration law's implication of racial inferiority. There is every reason to expect that the Chinese communists will continue to exploit the anti-foreignism latent in most of Southeastern Asia for decades, implanted there, in some part, by the Oriental exclusion features of past American immigration law. An example of communist efforts to use our immigration laws to encourage this anti-Americanism is Radio Moscow programs beamed to South and East Asia, in which the communists have called attention to the color line drawn in United States immigration law. Such a program, on July 5, 1952, in Korean, contained the following paragraphs, quote, "The United States Congress on June 27th passed the McCarran-Walter Bill, which calls for drastic discrimination and restrictions against the nations of China, India, Southeast Asia, and other Asiatic countries who enter or reside in the United States. The nature of the new law was thoroughly unmasked by the congressmen in their debates on the bill. They stressed that the new immigration restriction bill is very similar to the Nazi theory of racial superiority. The McCarran-Walter Law places those nationals of Asian countries who enter or immigrate into the United States in a far more inferior category. It is too well known how the American government authorities have treated Chinese, Korean, or Indian nations. The McCarran-Walter Law, which has been adopted by the United States Congress, provides further discrimination and restrictions on foreign nationals who enter the United States. However, the law is only one of many things which show the contempt of the American ruling circles, and which spread racial prejudice among the people of the United States against the Asian people." End quote. A large number of witnesses in the Commission's hearings stressed the continuing harm to our foreign relations caused by the discriminations of the national origins law against the non-white people of the world who constitute between 2/3 and 3/4 of the world's population. Asia. The Secretary of State advised the Commission that, quote, "The lifting of the bar of exclusion caused deep gratification in Asia when the 1952 Act was passed, but the racial discrimination apparent in the Triangle provision can be expected to keep alive some feelings of resentment. The combination of very small quotas for Asia and the Asia-Pacific Triangle provisions still furnish ground for Asian suspicion of United States motives." End quote. This testimony was corroborated by that of a recent eyewitness. Philip M. Hauser, professor of sociology at the University of Chicago and former acting director of the United States Bureau of the Census, made the following observations to the Commission. Quote, "The existence of such legislation as the present quota system in the statute books of the United States is to be particularly deplored in view of the position of world leadership which the United States has assumed in the almost 3 decades which have elapsed since the passing of the Immigration Act of 1924. It embodies a vicious and self-incriminating doctrine inconsistent with our position as a leader in the cause of world freedom and democracy. It is among the greatest barriers to our gaining the confidence and trust of many of the peoples of the world. I can document this assertion with what I have seen and heard in my own experience in many parts of the world. Less than 3 weeks ago, I returned from my 4th trip abroad. It was an extended trip of over 14 months, most of which I spent in the Orient, and during which I completely circumnavigated the globe. I can assure this Commission that Public Law 414 is well known to the peoples of the world and that it is not favorably known. It does untold damage to the United States in creating attitudes of distrust and hostility. For example, I have on a number of occasions been embarrassed by Asiatic people who have questioned me about the quota system as one aspect of what they regard as our racial and ethnic prejudices. Few discussions of world or United States problems failed to elicit some question about United States racial prejudices in policy or deed, and some manifestation of puzzlement about or hostility to it. It is absurd to think that we can retain our position as the world leader in the fight for freedom and democracy with the peoples whom we explicitly and openly brand in our legislation as undesirable and inferior. furthermore, in reenacting the quota system of 1924 into the Immigration and Nationality Act of 1952, we have unwittingly placed into the hands of the ruthless, adroit, and unscrupulous propagandists of the USSR a major weapon with which to attack us. As a resident of Southeastern Asia for about a year, I had occasion to listen to Radio Moscow and to read the local news reports of the activities of Russian agents and propagandists. In this critical area, the fate of which may well determine the fate of the world, the USSR is skillfully and continuously making the most of our ethnic and racist doctrines as promulgated in Public Law 414. I have heard on numerous occasions the propaganda blasts of Radio Moscow. Much of its content was so distorted, fabricated, and patently absurd that I am sure it fooled nobody, except possibly its perpetrators. Some of it, however, met high standards of effective propaganda technique, particularly that which, in even small part, could be documented as in the case of their on the whole wild and exaggerated depictions of our racial and ethnic prejudices and animosities. I am sure it was not the intention of the drafters of Public Law 414 or of the Congress to place a powerful weapon into the hands of the USSR in their propaganda war against the United States. But I can assure the members of this commission that its enactment has had just such an effect." End quote. Caribbean area. As a result of the 1952 Act, we have suffered a serious deterioration of our foreign relations in the Caribbean, an area close to America, close to the Panama Canal, and the site of important wartime bases. The provision, which gives each colonial area of the West Indies a limited quota within the motherland's quota, a new device to limit such immigration to 100 a colony, has been keenly felt in those colonies as a racial discrimination, since the population of all of them is predominantly Negro. This situation is serious enough to have led the Secretary of State to discuss it at some length in his statement to the Commission. Quote, "In the colonial and other dependent areas, an even less satisfactory situation has come into being. The new Act provides that colonies shall have quotas of 100 each, instead of unlimited use of the quota of the governing country. The difficulties are most clearly evident in the important strategic area of the Caribbean. The fact that this area has been the only part of the Western Hemisphere subject to quotas has always been an unpleasant irritant to these colonial peoples. In the case of the British West Indies, the large and always undersubscribed British quota was open to them. They have not, therefore, felt the practical effects of the discrimination implicit in their unique status in the hemisphere. No more than 2,500 immigrants have entered the United States from the British West Indies in any one year. Henceforth, however, no more than 800, 100 for each of the 8 British territories, may enter each year. Already, months before the effective date of the Act, various British West Indian legislatures have passed resolutions denouncing these provisions. This is even less to be wondered at when it is remembered that Cuba, Haiti, and the Dominican Republic, all near neighbors of the British territories and equally parts of the Caribbean area, have non-quota status like the rest of the Western Hemisphere. Prominent West Indian leaders and newspapers have protested the obvious discrimination, and both West Indian and British government officials have informally brought the seriousness of the matter to the department's attention. Further, the United States members of the Caribbean Commission, a body formed by executive agreement between the United States, the United Kingdom, France, and the Netherlands to plan for the economic and social development of the Caribbean area, have formally protested to the Department against the colonial quota provisions as being a threat to the work of the Commission itself, as well as to the work of the Department in its relations to the Commission." End quote. This view was substantiated by the testimony from another eyewitness, Walter White, Secretary of the National Association for the Advancement of Colored People, who declared, quote, "I encountered in the West Indies this summer many examples of anger mixed with shock at both the sharp reduction of immigration from certain West Indian islands and the racial implications of that action. I submit that the McCarran-Walter Act, because of its racial implications against colored peoples from Asia, the Caribbean, and other areas, may well prove equally harmful to the United States, not only in Asia, but in Latin America." End quote. The Secretary of State summed it up thus, quote, "In view of all this, it is clear that United States immigration policy not only causes resentment, weakening the friendship of some of our neighbors, but also causes or emphasizes economic dislocations that weaken those neighbors whom we need as strong partners and who can furnish us with sites for military bases and strategic raw materials." End quote. Africa. Another problem may be in Africa. The Secretary of State raised this issue in his statement, quote, "Other colonial areas that will be of increasing importance to the West are those in Africa. Although there has as yet been no problem there, it should not be assumed that there never will be. Nationalism is growing rapidly in Africa, and Africans are, of course, extremely sensitive to racial discrimination. Again, one of the chief problems now facing the United States information offices in Africa is how to combat the anti-American racial propaganda published in local nationalist papers. While with one hand we spend time and money to fight that propaganda, with the other hand we feed the propaganda mill with our discriminatory policies." End quote. Europe. The Secretary of State sees the same situation in Europe. Quote, "In Europe, the difficulties facing us result in part from the national origins quota system, which is based squarely on the theory that the best Americans are those of particular national or racial origins. This theory, always derogatory to our friends, is increasingly at variance with our protestations of equality and with our efforts to work fruitfully with all peoples, especially where it strikes countries like Italy and Greece, which are much concerned with emigration as a solution to their population problems. It has engendered soreness and doubt that inhibit progress toward mutual trust." End quote. Similar statements have been made to the Commission over and over again by informed and observant witnesses. The facts available to the Commission bear out the general conclusion that the United States incurs resentment abroad because of the nationality and race discriminations of our immigration law. The most obvious indications of this general resentment can be seen in the countries hit hardest, such as Italy and Greece. The national origins system has been a constant source of irritation in these and other countries, and a smoldering cause of official and unofficial disaffection toward the United States. Resentment has been growing more bitter in recent years. Although the United States talks much in Europe about unification and the lowering of barriers, about equality and the mutual interest of the United States and Western Europe, at the same time it continues and further restricts its own immigration laws. The Commission does not wish to leave the impression that failure to remove discrimination from our immigration laws will necessarily hamper the conduct of affairs at the diplomatic level. There is no evidence that it has done so in the past. However, the weight of evidence is that fundamental relations between the United States and certain other countries are definitely impaired by our present immigration laws. National origins law thwarts refugee and escapee programs. Among the great humanitarian problems facing the world today are the care and future of the refugees, expellees, escapees, and remaining displaced persons who constitute, quote, unfinished business, end quote, in the aftermath of World War II. Refugees, expellees, displaced persons. There are today some 10 million refugees and expellees of German ethnic origin in West Germany. Over 600,000 persons of Italian ethnic origin are in Italy and Trieste, refugees from Italy's former territories or other areas lost as a result of the war. Greece has some 40,000 to 45,000 refugees of Greek and foreign nationality from the countries of Southeast Europe. The number of refugees in West Germany is increasing by some 15,000 arrivals monthly from East Germany, exclusive of the escapees of other than German ethnic background. This situation is especially critical in West Berlin. The flow of refugees also still continues into Trieste, mostly from Yugoslavia. After the conclusion of operations under the Displaced Persons Act, some 7,500 displaced persons still remained as likely eligibles for a visa when all visas were exhausted on December 31, 1951. In the Far East, the situation of 15,000 Chinese intellectuals in Hong Kong and of 7,500 European refugees in communist China is particularly desperate. The refugee situation is potentially explosive. Western Germany is an example of this situation. The refugees constitute 20% of its population. 1/3 of the total unemployed in Germany in the spring of 1952 were refugees. Over 340,000 expellees still lived in mass camps. Only 30% of the expellees then had permanent employment. Over a year ago, the United Nations High Commissioner for Refugees stated, quote, "The refugee population in Germany shows increasing inclination towards political adventure. The younger generation of the refugee populations faces the future with little confidence in the effectiveness of democracy and its capacity to solve their problems." End quote. Discussing the work of the International Refugee Organization, a subcommittee of the Senate Committee on Expenditures in 1949 reported, quote, "Because of economic unrest and instability throughout Europe and Asia, The presence of refugees is generally a disturbing factor, both economically and politically. Accordingly, the problem is clearly one of international concern." End quote. A great deal of international effort has gone into various attempts to solve the refugee problem. The United States, as we have seen, has participated actively in most of them, and has contributed a substantial part of the funds for all of them. With such conclusive evidence at hand, it seems superfluous here to labor the proposition that solution of the refugee question has been and continues to be of the greatest importance to this country. Attention can be more usefully directed to the question of whether the United States has done enough in accepting refugees as well as in planning, administering, and paying for the programs. The same Senate committee report quoted above contains this significant conclusion. Quote, "The accomplishment of its, the International Refugee Organization's, mission has been substantially hampered by the failure of the nations of the world to assume their full responsibility for the solution of the displaced persons and refugee problems created by World War II. With respect to the United States, the problem is particularly acute. If our government is to maintain leadership in this vital matter, it must carry out its declared policy by effective measures aimed at liberalizing the admission of displaced persons. Until the nations of the world, including the United States, are ready and willing to meet these problems, in the only manner in which they can be met, by eliminating certain restrictions with respect to immigration, this problem will never be solved." End quote. This conclusion is as true today as when first announced by the Senate Committee in 1949. The basic need for the refugee, expellee, escapee, displaced person problem is opportunity to migrate to another country. This does not mean that all of the 10 million German refugees want or need to emigrate. Most of them are finding homes in Germany. However, the chance to emigrate is vitally necessary for some of these and other refugees, both as a real and as a psychological safety valve in a situation of tension and frustration. Needless to say, this is not a problem for the United States alone, but for all the nations of the free world together. The International Refugee Organization resettled 1,038,750 refugees in 4.5 years in 48 countries and an equal number of other areas. Of this total number, the United States took less than 1/3 through the Displaced Persons Commission. The Displaced Persons Act, as amended, also brought to the United States some 55,000 German expellees and 2,000 Italian refugees. When the Displaced Persons Commission's work ended in the summer of 1952, all visas authorized under the Displaced Persons Act had been issued to displaced persons, German expellees, and Italian refugees, and some 400,000 people had entered the United States under the Act. Yet the Displaced Persons Commission reported that there were still under consideration, likely to receive visas if more were available, 32,000 German expellees, 1,500 Italian refugees, and 7,500 displaced persons. These are the so-called, quote, pipeline cases, end quote. This is clearly, quote, unfinished business, end quote. The refugee problem is much smaller now. It has bounds. It can be solved within a fairly short space of time. The United Nations High Commissioner for Refugees and the Intergovernmental Committee for European Migration, formerly PICMME, are handling it as best they can. The Commission is convinced that these international agencies should be given the strongest support by the United States and the rest of the free world. But the obstacle that faces them is the closing of doors to immigrants in the United States, Canada, Australia, and elsewhere. The refugee problem cannot be solved by closed doors. And as long as the problem continues, the United States will have to continue helping, in one way or another, to support the refugees. The United States will continue to spend more money and effort to bolster the Western European economies. Yet it will continue losing goodwill because of its restrictive immigration policy. And most important of all, the United States will continue to pay the much larger price that results from the progress that communism and neo-Nazism and neo-fascism make when frustration overtakes the people and countries whose refugee and expellee problems remain unsolved. Where the United States has taken the lead, as in the Displaced Persons Program, the other countries have followed our example. Escapees from Iron Curtain countries. The escapee situation is even more critical at the present time. There are 20,000 to 25,000 persons housed in camps in Germany, Austria, Italy, Trieste, Greece, and Turkey, who have escaped from behind the Iron Curtain since January 1st, 1948. These escapees are non-Germans. They are, in general, the people from behind the Iron Curtain, who have most recently arrived, risking life and limb, leaving behind everything but the clothes on their backs in order to live in freedom. Some of them have come because of the enticements held out to them by the Voice of America or by other Western propaganda for democracy. Now that the communists have tightened up the border watch, the flow has dropped to about 500 a month. How many try and fail? Paying for the attempt with their lives is anyone's guess. But at one point, the mortality rate was estimated to be over 80%. Unfortunately, escapees are not likely to find the welcome and freedom they thought would await them. They arrive in countries already surfeited with refugees. They cannot, for the most part, continue on to the United States because of restrictions in our immigration law. And so most of them are put in camps, without work, with none of the comforts and few of the privileges or rights of free men. The United States has a special responsibility toward these people and a special interest in them. At least some of them have come because our propaganda lured them. If sacrifice earns the right to liberty, they have earned it. We cannot turn them away and expect those still behind the Iron Curtain to believe us ever again. Furthermore, they are, generally speaking, convinced opponents of communist tyranny. They have experienced it, and they want no more of it. They can be helpful to us, and yet we have done very little for them and nothing to welcome them to our shores. Out of the current mutual security appropriation, a fund of $4,300,000 has been set aside to help the resettlement of escapees. The announcement caused hopes to rise among those escapees in camps in Europe. It brought a short-lived increase in the rate of escape through the Iron Curtain. Its results have been negligible because the fund is too small and because the United States and the other free nations have formulated no adequate programs for their care and resettlement. The Commission believes that effective measures should be taken and adequate appropriations made to provide reasonable reception, care, and migration opportunities for escapees from communism. The escapee problem is not a partisan political issue. It is generally agreed that something should be done immediately. President Truman said in his special message to the Congress on March 24, 1952, quote, "Specific aid and assistance should be provided for the people who are fleeing at the risk of their lives from Southern and Eastern Europe. These peoples are Balts, Poles, Czechs, Slovaks, Hungarians, Bulgarians, Romanians, Albanians, Ukrainians, and Russians. These people face a desperate situation. Not only do they arrive destitute, with only what they can carry on their backs, but they find themselves in totally strange lands among strange peoples speaking strange languages. The local authorities do not have adequate resources to care for them properly. These people need better care when they first arrive, and they need assistance if they are to move on and resettle elsewhere. The miserable conditions in which these fugitives from communism find themselves and their present inability to emigrate to new homes and start new lives lead inevitably to despair. Their disillusionment is being effectively exploited by communist propaganda. These men and women are friends of freedom. They include able and courageous fighters against communism. They ask only for an opportunity to play a useful role in the fight for freedom. It is the responsibility of the free world to afford them this opportunity." End quote. He recommended a program authorizing 21,000 escapees to migrate to the United States over a 3-year period, plus supplemental reception, care, payment of cost of ocean transportation, and a program of education for leadership for those who choose to remain in Europe. President-elect Eisenhower said in a speech on October 17, 1952, quote, "A contest for world leadership, in fact for survival, exists between the communist idea and the American ideal. That contest is being waged in the minds and hearts of human beings. We say, and we sincerely believe, that we are on the side of freedom, that we are on the side of humanity. We say, and we know, that the communists are on the side of slavery, the side of inhumanity. Yet to the Czech, the Pole, the Hungarian who takes his life in his hands and crosses the frontier tonight, or to the Italian who goes to some American consulate, this ideal that beckoned him can be a mirage because of the McCarran Act." End quote. Secretary of State Acheson said in his statement to the Commission, quote, "Another special problem of equal importance is that of the escapees from communist countries. These people arrive in the border countries destitute. They have lost their homes, their property, and often their families. They have a deep hatred for communism. They know from experience what it means. They have a deep love of freedom, having been so long without it. If they are left to shift for themselves in lands already burdened with surplus population, they will not be able to find work and will be disillusioned about the meaning of Western democracy. As their disillusion grows and word of it spreads, it will be difficult for us to convince the captive populations behind the Iron Curtain that the free world is interested in their fate. With our aid, other countries are trying to make possible a new life for these escapees. But these efforts do not by themselves meet the need. To welcome escapees to the United States on a scale impossible under the present quota restrictions would be a vital step in making our policy toward the satellite peoples effective." End quote. Professor Philip E. Mosley, president of the East European Fund set up by the Ford Foundation and member of the Russian Institute of Columbia University, testified, quote, "I feel that we will strengthen our own country and the free world if we will open a door, or rather, if we will reopen a door to the people who, under intolerable pressure, are escaping every day and every week from the Iron Curtain countries." End quote. American foreign policy toward the countries behind the Iron Curtain, particularly the satellites, is to emphasize that their people would be better off on our side. But in connection with escapees, a most vital aspect of the, quote, Cold War, end quote, American immigration law lies directly athwart our foreign policy. End of Section 7. Section 8, Of Whom We Shall Welcome. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Recording by PhyllisV. Whom We Shall Welcome. Report of the President's Commission on Immigration and Naturalization. Part 2, Chapter 3C. Rigid immigration law prevents meeting special needs. The foreign relations of the United States reflect not only our needs and desires, but also those of other nations. One of the most acute special needs of some key foreign countries today is for relief of overpopulation. At present, they cannot make constructive use of all their population. Serious overpopulation problems exist in two separate areas of the world. 1. Certain countries of Western Europe, and 2. Southern and Eastern Asia. However, the problems and needs of these areas differ widely. The needs of the overpopulated European countries are for migration as well as economic development. The needs of the overpopulated Asiatic countries, except perhaps Japan, are not for migration, but rather for economic development. Europe. 7 years after the end of hostilities in World War II, Western Europe is still beset with a serious problem of excess population, concentrated principally in the Netherlands, West Germany, Italy, and Greece. Hugh Gibson, director of the Intergovernmental Committee for European Migration, gave the Commission an estimate of some 3,500,000 people, including refugees, who cannot be absorbed into the economies of the countries in which they find themselves. The Netherlands. The overpopulation of this country has become so serious that in September 1951, Queen Juliana wrote to the President of the United States to urge his initiative in finding international means to deal with the whole European overpopulation problem. With the highest birth rate in northwestern Europe, the Netherlands needs migration opportunities for its young people at least to the amount of 25,000 per year in addition to the current emigration program. West Germany. The overpopulation problem is indistinguishable from the refugee, expellee, escapee, displaced persons problem. According to the Bonn government, some 1,350,000 of its people are potential emigrants. Italy. This nation's situation is the most acute of all in Europe. Its already overburdened population has been augmented by some 480,000 Italians repatriated from former colonies and other areas in the Mediterranean not presently open to Italian emigrants. Another 125,000 Italians fled to Italy from land ceded to Yugoslavia in the peace treaty. Italy's excess population is concentrated primarily in the agricultural southern part of the peninsula and in Sicily. It is in those areas that the neo-fascists have their greatest strength. In the same areas, the communists are currently making a strong bid for adherence. In the same areas, one finds also the most frequent and general expression of popular demand for emigration as the only hope for betterment. Prime Minister De Gasperi made a special plea to the United States government in 1951 for cooperation in providing migration opportunities for Italy. The failure of our immigration law to accord such cooperation has, in the judgment of competent and objective observers, weakened the pro-democratic forces in Italy. The critical nature of this matter can be seen from the reports of competent American observers in Italy to the effect that the population problem and its consequences may be crucial in elections to be held in the spring of 1953. Italy's geographic position in the Mediterranean makes it of the greatest importance to our security and to world peace. It is not without significance that the NATO conference in Lisbon, early in 1952, adopted a resolution concerning the importance of emigration, particularly for Italy, but also for other countries. Nor is it an accident that the country with the most serious overpopulation problem, Italy, has the largest communist party in Western Europe. Overpopulation, in addition to its political effect of stimulating unrest and the search for radical remedies, has clear economic consequences, most of them stemming from unemployment. Our immigration restrictions work against our foreign policy in Italy. Unemployment in Italy has been high ever since the war and remains today at about 2 million totally unemployed. These people are a burden on the public economy, since the state pays unemployment benefits which might otherwise be productively invested or used to build stronger military defenses. In addition to unemployment, underemployment in Italy is estimated in the neighborhood of 2 to 2.5 million people. Underemployment constitutes an obstacle to the private economy, and that an excess of hands reduces the impetus to raise farm and factory productivity. As long as the United States continues to support the Italian economy, a significant part of our effort will be nullified by these factors. Relief of the overpopulation and of the consequent underemployment and unemployment would permit more efficient and effective use of United States economic and military aid to Italy. A frequent issue in connection with Italian overpopulation is the mistaken belief that the country has an unduly high birth rate. Actually, Italy's birth rate is lower than that of the Netherlands. It is lower than that of France, the traditional example of a country whose birth rate is alarmingly low. Surprisingly, but nevertheless true, the Italian birth rate is now lower than that of the United States. Italy's birth rate has been declining for several generations, and if this decline continues for the next 15 years, it will no longer exceed the death rate. Italy's population growth will then cease, but its overpopulation crisis is now. Italy needs migration opportunities for another 170,000 people a year as a supplement to the even greater additional number for whom resettlement opportunities are already in prospect. Greece. Greece has a triple problem of internal refugees uprooted during the recent civil war, refugees from abroad, and native population growth. The Greek government believes that emigration opportunities must be provided for 30,000 of its surplus population a year. The situation in Western Europe has been described by Hugh Gibson, director of the Intergovernmental Committee for European Migration, as follows, quote, "While the refugee and surplus population problem faced by individual countries of Western Europe varies in its nature, the situation as a whole presents certain common features. For all the countries, it is a problem which causes deep concern to the governments by reason of its damaging effect upon political, economic, and social conditions. The situation as a whole is one of the most serious obstacles to the stability of Western Europe in general." End quote. The refugee overpopulation situation in Western Europe has the following general characteristics. 1. Overpopulation exists in certain countries and causes unemployment and underemployment. 2. Unemployment provides a fertile field for extremist agitation of right and left. 3. It constitutes a drain on the economy of these countries in a variety of ways. 4. The objectives of American programs of aid to these countries, whether economic or military, are hampered by the consequent political and economic instability. 5. A small amount of emigration can have lasting and successful effect in resolving the difficulties that arise from overpopulation in all these European countries. Asia. Except for Japan, which resembles the European countries in this respect, the situation in Asia is completely different. The problem of refugees, where it exists, is predominantly internal and cannot be distinguished from the problems of overpopulation. The structure and birth rate of the Asian populations and the stage of economic development of their countries are all quite different from those of the European countries. Only in Japan, with its rapidly declining birth rate, can migration offer real relief for population pressures in the next few years. The best scientific and professional advice available to the Commission is to the effect that migration offers no solution to overpopulation on the Asiatic mainland. No conceivable migratory movement could provide substantial relief for present Asian surplus population, much less for the annual growth of some 10 million a year in non-communist Asia. For the Asian mainland, the need is for better use of resources and economic development where the people now live. On the other hand, for Western Germany, Greece, Italy, the Netherlands, and perhaps Japan, the need is different. Emigration can serve as a safety valve for transitory problems of critical population pressures. These countries have reached a stage of economic development and population structure at which both the need and desire for migration is most acute, and where its result would be soon effective. This is not to say, of course, that economic development is not also equally important in these particular countries. However, a concerted international effort to deal with the burden of present overpopulation would serve to bring about a relatively manageable situation in which the natural population increase of such countries can be readily absorbed for productive use within their own economies. These countries need and can have substantial results from immediate international efforts to move some of their surplus population. All reliable scientific evidence indicates that effective international migration programs can and will have a lasting and successful effect for these countries. The contrary is true for the Asian mainland. The same general situation prevails as to refugees. In Europe, the problems of refugees, expellees, escapees, and displaced persons are now finite. With a coordinated international effort in which the United States would play its part, the end of these European refugee and related problems is in sight. Unfortunately, the same cannot be said for the refugee situation in Asia, where the dislocations of World War II have been equaled, if not exceeded, by the dislocations of the post-war period. Apart from the Arab refugee situation in the Near East, the refugee problem in Asia is not distinct from the general problem of overpopulation in those areas. For example, the partition of India set in motion 18 million refugees, an exchange of Hindu and Muslim. This occurred principally in the Punjab and in Bengal. However, the acute political, social, and economic problem in India is not in the Punjab, but in South India, especially Madras, where there is no refugee problem. The problems of overpopulation and refugees in Asia are of vital importance to world peace. Their solution, however, cannot, as it can in Europe, find major relief through migration. The remedy. No one has suggested that emigration is the only or whole solution of these population problems. Nor has anyone suggested that the United States alone should try to meet them. They are international problems. However, the Commission is convinced that the inflexibility of our present immigration law prevents the United States from making any special contribution to the solution of these issues. Anything which has the effect of weakening our partners, as overpopulation certainly does, has also the effect of weakening the security of the United States. Since our foreign economic and military policies are devoted in large measure to building the strength of these very countries, failure to help them solve the problem of overpopulation quickly works against their strength and our safety. Each of the 4 European countries mentioned is part of NATO, or involved in plans for Western defense, and therefore is essential to our own security protection. And Japan occupies a critical role in Asian problems. The Secretary of State advised the Commission, quote, "A special effort to reduce the overpopulation problem to manageable proportions would be a most effective step toward our foreign policy goals." End quote. In a joint declaration of May 1950, the foreign ministers of France and the United Kingdom and our Secretary of State said, quote, "In the course of their discussions, the foreign ministers have recognized that the excess of population from which several countries in Western Europe are suffering is one of the most important elements in the difficulties and disequilibrium of the world." End quote. In a special statement to the Commission, Hugh Gibson, Director, Intergovernmental Committee on European Migration, wrote, quote, "The establishment of the committee, as a result of American initiative based on broad-mindedness and imagination, was the first attempt to approach on an international basis a problem which has been one of the most serious causes of insecurity and conflict in Europe for some years past, and has driven certain countries, for lack of international understanding, to seek purely national solutions and to adopt policies, the international implications of which were highly dangerous. International cooperation and the solutions to this problem, thereby made possible, are essential for mutual understanding between the members of the Atlantic community as well as between the members of the European community. In that connection, the refugee problem, while it has economic, demographic, and social aspects, is obviously related to the defenses of freedom and therefore highly political in character." End quote. 3 facts are obvious in this situation. 1. The United States alone cannot solve the problem of European overpopulation. 2. The problem is one of international concern in whose settlement the United States is deeply involved. And 3. The present United States immigration law impedes our participation in international migration efforts, and thus prevents us from exercising the kind of leadership that would encourage other countries to admit a larger number of European immigrants. Temporary visitors. Many applicants for visas desire to visit the United States for only a short time. They may be students, teachers, writers, scholars, businessmen, lecturers, concert musicians, tourists, or other visitors. They may plan to visit for a day or so, for example, in the case of a scientist to address a meeting, or stay a few weeks or as much as a year, or even just to pass through the United States on the way to a destination in Canada, Mexico, or another country. In any event, they must have a visa from a United States consular officer abroad before leaving on their trip. And even if they are to be in the United States only for several hours, they must satisfy substantially all the health, financial, security, and other requirements that apply to permanent immigrants. In recent years, an increasing number of visitors have been subjected to denials, difficulties, and delays in getting visas. In practically every case, the problem is one of security clearance. The process of security investigation has become more rigorous and time-consuming. And even where the visa is finally issued, the nature of the process may diminish international goodwill toward the United States. From testimony before the Commission, it would appear that the greatest number of current cases involve foreign scientists, although businessmen, journalists, technical assistance team members, artists, and writers have also been affected. It should be remembered that, as to foreign authorities in the arts and sciences, many of the applications for visas are prompted by urgent invitations from distinguished American institutions. The number of people involved in the problem is probably small, although no definite statistics have been made available to the Commission. The international repercussions, however, are disproportionate to the number for the simple reason that the persons affected generally occupy prominent places in the social, commercial, or intellectual life of their countries. Their opinions carry more than ordinary weight, and their prejudices are likely to be more widely reflected in the views of the country's press and official documents. If it becomes known that any of them has been denied a visa to visit the United States, the fact makes the headlines in both the communist and non-communist press. If the individual concerned believes the denial to be mistaken or unjust, and chooses to complain about it, he wields a good deal of influence on the attitudes of his friends and associates. In the light of our desire to exercise leadership among free nations, It is especially important to the United States that the favorable impression these people have of America be not unnecessarily diminished, and that they be not subjected to petty annoyances, irritations, and embarrassment. Among scientific groups abroad, particularly in the United Kingdom and France, comparisons have been voiced between the Soviet Iron Curtain and the American, quote, uranium curtain, end quote. This reaction is reflected, to a certain extent, in some of the most influential foreign newspapers. The Manchester Guardian of England, in particular, has commented on at least 2 occasions, concluding one editorial with the statement that, quote, this visa business is doing the United States incalculable harm and is undoing all the lavish propaganda about its noble leadership of the free world, end quote. Jean-Jacques Servan-Schreiber, an influential French journalist who is usually friendly toward this country, last September wrote that the new immigration law, quote, is stupid, inefficacious, and does more harm to United States prestige than all the Soviet propaganda, end quote. Another consequence is that international scientific congresses are beginning to avoid the United States. The International Congress of Psychology, for example, was originally scheduled to meet in this country in 1954. It has been shifted to Montreal, Canada, specifically in order to avoid embarrassment to members who might be denied visas to this country or whose visas might be delayed until months after the meeting was over. Similar reasons governed the decision of the International Congress of Genetics to meet in Italy in 1953, and probably in Canada the following year, rather than in the United States. The International Astronomical Union declined an invitation to hold its next meeting in this country because of the visa situation. Although the International Federation of Documentation and the International Physiological Congress gave other reasons for declining invitations to meet here, it is understood, the Commission was told, that similar considerations figured in their decisions. A third consequence, more important for national security than foreign relations, but not unrelated to the strength of the Western world, flows from the denial of visas to foreign scientific visitors. For example, Enrico Fermi, the refugee Italian scientist who played a crucial role in the development of atomic energy during the war, would probably have great difficulty entering this country today. Some of America's most distinguished scientists warned the Commission that such intellectual strangulation was dangerous for our own national security. Dr. Vannevar Bush, president of the Carnegie Institution of Washington and former director of the Wartime Office of Scientific Research and Development, testified as follows, quote, my principal criticism of our law in regard to immigration and naturalization, as far as the scientist is concerned, is that the shoe has always seemed to be on the wrong foot. Instead of placing our emphasis on the desirability of attracting the right individuals, most of our emphasis has been on the problem of keeping the wrong ones out. I am quite sure that this has given a bad impression throughout the world of our attitude in this country toward scientists generally. Even where there has been no exclusion, the impression has been very bad indeed. End quote. Dr. Alan T. Waterman, director of the National Science Foundation, advised the Commission as follows, quote, I would like, Mr. Chairman, to submit for the record the written statements on this subject by the Department of Defense, the Atomic Energy Commission, and the Department of Agriculture. Upon the basis of information available to the Foundation through these channels, it is clear that the provisions of the present immigration laws governing the temporary admission of aliens to this country and the administration of these laws have created a problem. If the solution to this problem is long delayed, a seriously detrimental effect on the strength of science in this country may be expected. Any such handicap to our progress in science will in turn unquestionably react adversely on our welfare and security in the years ahead. A further consequence would be a weakening of cooperative relationships with friendly countries in an important component of our common defense, namely scientific research and development." End quote. The statement from the Atomic Energy Commission read in part as follows, quote, "The Commission has always encouraged visits by foreign scientists to the United States when such visits would make a constructive contribution to the atomic energy program insofar as they were consistent with security requirements. We are particularly aware that the development of atomic energy is based in large part on discoveries which took place in foreign laboratories, and we still have need for the many fundamental contributions which foreign science can make. Nuclear physics and chemistry, for example, are fields where more basic knowledge is urgently needed, and where the traditionally free exchange of basic scientific information is essential to maximum progress. Foreign science can and does make really significant contributions to these fields. It is important, therefore, that this source of help not be denied the United States. Certainly, any legislation which denies to the United States the free exchange of basic scientific information may impede the research and development programs of the Commission and its contractors." End quote. Howard A. Meyerhoff, representing the American Association for the Advancement of Science, advised the Commission, quote, "I have no wish to leave with the Commission the impression that scientists have a distorted perspective on the visa question. The colleagues who have supplied me with information have mentioned as many cases in which foreign scientists have entered this country without trouble or delay, as they have cases where unwarranted difficulty or outright refusal was experienced. They are rightly concerned, however, with the imperfections of the law and its administration, because these imperfections are creating ill will that is being reflected in the increasing number of decisions on the part of international scientific bodies not to schedule meetings in the United States. If this trend continues, American science faces the threat not merely of becoming provincial, but also of becoming atrophied to the point where the national welfare and national security will suffer. Security and welfare are founded on knowledge, only part of which originates within the confines of the United States." End quote. The Federation of Atomic Scientists made similar representation to the Commission in several of its hearings. Professor Edward A. Shills of the University of Chicago, who edited a special edition of the Bulletin of the Atomic Scientists for October 1952, devoted to visa policy, testified that the subject had, quote, "very great import for the United States and America's foreign relations," end quote. He said of our present visa policy, quote, "Now this is not only injurious to American science, and injurious, therefore, to American development and welfare, and to American intellectual achievement. It is injurious to the achievement of the ends of foreign policy. Every time a visa is refused to an eminent European scientist or scholar, and many times when it isn't, it gets into the communist press. Of course, communists believe what they believe, and we can't do much about that. But there are a large number of people in Europe who are not communists, who are pro-American and want to be. And they find it difficult to defend the American policy when America behaves in this way." End quote. The situation is broader than the admission of scientists. The American Academy of Arts and Sciences took formal action through its council as follows in part, quote, "The American Academy of Arts and Sciences is gravely concerned by the formidable barriers which now exist to the entry of our foreign colleagues in the arts and sciences into this country. These barriers are a serious threat to the progress of American science and learning. The present restrictions on the entry of foreign scholars to this country are actually dangerous even from the point of view of national security. Moreover, the obstacles to the admission of distinguished foreign visitors to this country have results that are often extremely damaging to American prestige abroad. They diminish, among some of our best friends in foreign countries, the trust and respect in which we are held, and thereby tend to nullify some of the major aims of our foreign policy." End quote. This same embarrassment to our foreign relations was called to the Commission's attention by Dudley T. Easby, Secretary of the Metropolitan Museum of Art, Dr. Henry Allen Moe, Secretary of the John Simon Guggenheim Memorial Foundation, and Professor Sidney Painter, Director of the American Council of Learned Societies, among others. Conclusions. The Commission is convinced that our present immigration law has a detrimental effect upon our foreign relations in a variety of ways. Discriminatory racial and national restrictions in immigration law have made enemies for the United States in the past and will continue to lose us friends as long as they remain in the law. In this respect, our immigration law conflicts with American propaganda abroad, an important arm of our foreign policy, which emphasizes equality and mutual interests among the free nations. Present immigration law causes large areas of the world of greatest importance to our own national security and welfare to resent us and view us with growing distrust. The immigration laws of the United States frustrate our foreign policy by hindering our efforts in friendly and allied countries to encourage their political stability and unity, rebuild their economies, and strengthen their military power. Rigidity in the national origins quota system prevents the United States from acting quickly and effectively in helping to relieve refugee and overpopulation problems when and where they arise. Population pressure gives rise to economic and political instability, and thus augments the very conditions which foreign aid programs of the United States are designed to ameliorate. Moreover, the inability of the United States to deal flexibly with refugee and overpopulation pressure reduces the influence this country might exert on other countries to help solve these problems. Our present national origins quota system prevents the United States from giving asylum to escapees from the Iron Curtain countries. Besides being contrary to American traditions, this barrier tends to disillusion the escapees and denies us the value of their help in organizing effective pro-democratic appeals. The present immigration law is inconsistent with the aim of our foreign policy to uphold the values of freedom in contrast to the chains of communist dictatorship. The effect is to blunt one of our most important psychological weapons in the Cold War. Our immigration law and procedures have had the effect, in some instances, of keeping out temporary visitors who should be welcomed to this country. The testimony has shown that important circles in friendly foreign countries are growing resentful of American immigration policy and are losing confidence in the sincerity of American professions of devotion to democracy. The Commission's study of the effect of the present immigration laws upon our foreign relations leads to this conclusion. In order to advance our national interests, strengthen our security, and contribute to the achievement of our foreign aims, American immigration policy should be free from discrimination on the basis of nationality, race, creed, or color, and should be flexible enough to permit the United States to engage fully in such special migration efforts as may be important to the security of the free world. End of Section 8.
Section 9 of Whom We Shall Welcome. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Whom We Shall Welcome. Report of the President's Commission on Immigration and Naturalization. Part 3. A Unified Quota System. Chapter 4. The Annual Immigration Quota. Until 1921, there was no numerical limitation of immigration into this country. The first national census in 1790 recorded a population of slightly under 4 million. Immigration continued to mount gradually. Some have estimated that between 1790 and 1820, approximately 250,000 immigrants entered the United States. From 1841 through 1920, immigration into the United States averaged some 411,000 persons per year. The largest annual number of immigrants to enter the United States was 1,285,349 in 1907. The 1921 Act placed the first maximum ceiling upon immigration. It limited the number to 357,800 a year, of which 198,000 were to come from Northern and Western Europe, and 156,000 from Southern and Eastern Europe. Each country's quota was limited to 3% of the number of people born in that country who were reported in the United States Census of 1910. The 1924 Act further restricted the number of immigrants and had two separate formulas. The first and temporary formula authorized the admission of 165,000 a year. Of this number, 141,000 a year were to be from Northern and Western Europe, 20,000 from Southern and Eastern Europe, and 4,000 were non-Europeans. In this formula, the 3% of the 1921 Act was reduced to 2%, and the 1910 census was changed to the 1890 census. The second formula of the 1924 Act became effective in 1929, and with slight changes continues to the present time. This authorized the admission of 153,714 immigrants, based on a total of 150,000 plus minimum quotas of 100 for all countries. By 1952, this figure had become 154,277 by virtue of minor changes. The total approximated 1/6% of the white population in the 1920 census, the last available at the time the 1924 Act was passed. Ever since the Act of 1924 became effective, immigration for permanent residence in this country has been divided into two classes, quota and non-quota. Quota immigration is that which, under existing law, is limited by the total number assigned annually to each nationality, area, or country. The practice in such cases is to admit an alien by assigning a number to him from the quota allotted to his nationality, area, or country, and no quota visa is issued unless a number is available. In addition to the quotas, both the 1924 and 1952 Acts authorize the admission without numerical limitation of non-quota immigrants for permanent residence. These principally include alien spouses and children of American citizens and natives of the independent nations of the Western Hemisphere. Under the Immigration Act of 1924, ministers and teachers were also permitted to immigrate to the United States as non-quota immigrants. However, under the 1952 Act, teachers are required to obtain a quota number and to wait until that number is reached. The most recent step in the legislative declaration of a maximum quota was in the Act of 1952, which set a maximum authorization of 154,657. This figure was based on a flat 1/6% of the white population in the 1920 census, excluding Negroes, American Indians, and other non-white persons in the population. A comparison of the quotas allotted to individual countries under the 4 different versions of the quota system is indicated in the following table. Table 3. Annual immigration quotas by country under successive immigration laws 1921 to 1952. 1921 Act, 3% of the 1910 census. Total 357,803. Asia 492. Africa and Oceania 359. Europe 356,952. Northern and Western Europe. Belgium 1,563. Denmark 5,619. France 5,729. Germany 67,607. Great Britain and Northern Ireland 77,342. Irish Free State, none. Netherlands, 3,607. Norway, 12,202. Sweden, 20,042. Switzerland, 3,752. Total, Northern and Western Europe, 197,630. Southern and Eastern Europe. Austria 7,342, Czechoslovakia 14,357, Greece 3,063, Hungary 5,747, Italy 42,057, Poland 30,977, Portugal 2,465, Romania 7,419, Union of Soviet Socialist Republics 24,405, Turkey 2,654, Yugoslavia 6,426. Total Southern and Eastern Europe 155,585. 1924 Act, 2% of 1890 census. Total 164,667. Asia, 1,424. Africa and Oceania, 1,821. Europe, 161,422. Northern and Western Europe: Belgium, 512. Denmark, 2,789. France, 3,954. Germany, 51,227. Great Britain and Northern Ireland, 34,007. Irish Free State, 28,567. Netherlands, 1,648. Norway, 6,453. Sweden, 9,561. Switzerland, 2,081. Total, Northern and Western Europe, 140,999. Southern and Eastern Europe: Austria, 785. Czechoslovakia, 3,073. Greece, 100. Hungary, 473. Italy, 3,845. Poland, 5,982. Portugal, 503. Romania, 603. Union of Soviet Socialist Republics, 2,248. Turkey, 100. Yugoslavia, 671. Total Southern and Eastern Europe, 20,423. 1929 National Origins. Total 153,714. Asia, 1,423. Africa and Oceania, 1,800. Europe, 150,491. Northern and Western Europe: Belgium, 1,304. Denmark, 1,181. France, 3,086. Germany, 25,957. Great Britain and Northern Ireland, 65,721. Irish Free State, 17,853. Netherlands, 3,153. Norway, 2,377. Sweden, 3,314. Switzerland, 1,707. Total Northern and Western Europe, 127,266. Southern and Eastern Europe: Austria, 1,413. Czechoslovakia, 2,874. Greece, 307. Hungary, 869. Italy, 5,802. Poland, 6,524. Portugal, 440. Romania, 295. Union of Soviet Socialist Republics, 2,784. Turkey, 226. Yugoslavia, 845. Total Southern and Eastern Europe, 23,235. 1952 Immigration and Nationality Act. Total 154,657. Asia, 2,990. Africa and Oceania, 2,000. Europe, 149,667. Northern and Western Europe: Belgium, 1,297. Denmark, 1,175. France, 3,069. Germany, 25,814. Great Britain and Northern Ireland, 65,361. Irish Free State, 17,756. Netherlands, 3,136. Norway, 2,364. Sweden 3,295, Switzerland 1,698. Total Northern and Western Europe 126,131. Southern and Eastern Europe: Austria 1,405, Czechoslovakia 2,859, Greece 308, Hungary 865, Italy 5,645, Poland 6,488, Portugal 438, Romania 289, Union of Soviet Socialist Republics 2,697, Turkey 225, Yugoslavia 933. Total Southern and Eastern Europe 23,536. The Commission's recommendations. The Commission believes that there should be a maximum ceiling on the number of quota immigrants who should be admitted into the United States each year. The Commission recommends continuation of use on a non-discriminatory and current basis of the formula in the 1952 Act. The maximum quota to be authorized for admission into the United States in any year thus would be 0.1% of the total population in the last available census. Specifically, this means for the present the use of the 1950 census instead of the 1920 census, and it means that the population base to which the 0.1% ratio is applied shall include Negroes, American Indians, and other non-white peoples. The last total population of the United States and its distribution by white and non-white is shown in Table 4. 1950 enumerated population of the United States by race. All races 150,697,361. White 134,941,622. Negro 15,042,692. American Indian 343,410. Other Asiatics 369,637. 0.1% of the total 1950 population of the United States is 251,162. Since the proposed percentage indicates a relationship between an annual maximum volume of immigration and the population of the United States, that percentage should apply to the latest available population data. The House Judiciary Committee in 1952 stated that it recognized the fact that revision of immigration quotas might be necessary on the basis of a later census, and requested the United States Bureau of the Census to undertake the necessary studies. A fixed volume of immigration each year means a constantly declining ratio of immigrants to the total population because of the natural increase in the population. On the other hand, if the immigration quota is a fixed percentage of the population, then the amount of immigration would increase proportionate with the growth of the total population. The Commission finds no justification for the elimination of Negroes, American Indians, and other non-white residents from the population base to which the 0.1% is to be applied. It is a discriminatory and unwarranted provision which should be eliminated from the law. The Commission recommends that the population base include the total number of people in the United States without regard to color, race, or national origin. The United States can absorb 250,000 quota immigrants annually. The capacity of the United States to absorb and profit by substantial migration is discussed in Chapter 2. Many expert witnesses address themselves to the question of the number of immigrants the country can safely receive. The Secretary of Labor, in his testimony before the Commission, stated, we could safely absorb substantially more than the 155,000 quota immigrants that are authorized by Public Law 414. The peak immigration in recent years was approximately 250,000 in 1950. I am not aware that it caused any economic or social dislocations, or that American workers were adversely affected. Subsequent to the Commission's hearing, the Secretary of Labor stated in a public speech, "Our experts in the Department of Labor have tried to estimate the effects on our population of a larger number of immigrants in the years immediately ahead. I want you to know that their figures and their analysis show this nation could absorb several 100,000 every year under present conditions, adding only the most negligible percentage to our population and placing no burden on our economy." The Assistant Secretary of Agriculture, testifying for the United States Department of Agriculture, noted that the department had supported legislation which would admit 100,000 persons a year for 3 years, in addition to the normal 154,000 allowed under the quotas. He informed the Commission that benefits would result from such additional immigrants to our country as a whole and to agriculture in particular. Some of the leading population experts of this country testified before the Commission. The director of the Office of Population Research of Princeton University, Professor Frank Wallace Notestein, advised the Commission as follows: "Within the scope of a reasonably small migration, one of the general order of 5 million within 10 years, it is possible that a program might be designed that would work to our own advantage as well as to the advantage of selected regions of origin." He stated that there was no proof that it would do the slightest harm to our economy. The former acting director of the Bureau of the Census, Professor Philip Hauser of the University of Chicago, testified, "The present numerical limitation is absurdly low and is unrelated to the needs of the United States. This figure of 250,000 by no means represents the upper limit of immigrants which we could safely absorb." Organized labor testified before the Commission in its various hearings around the country. Labor's views are especially significant in this regard, not only because of its obvious desire to protect the interests of American labor, but because of its historical attitude of opposition to liberal immigration legislation. But its views are different now. Philip Murray, late president of the Congress of Industrial Organizations, submitted his views to the Commission. After pointing out that until 1924 immigration amounted to 1% of the current population, he stated, "I do not believe that any evidence has ever been adduced that immigration on that scale adversely affected wage scales in this country or the economy of the country. If anything, the evidence seems to be directly to the contrary. Hence, it appears that this country could, without danger to its wage scales or economy, absorb each year a substantial number of immigrants." The American Federation of Labor also testified before the Commission. It pointed to its earlier espousal of legislation which would have increased the total authorized quota and special immigration to over 250,000 a year for 3 years, and then stated, "At best, we can only say that under the prevailing economic conditions, a total annual rate of normal as well as emergency immigration of between 200,000 and 250,000 a year would not be excessive or lead to serious dislocations." Professor Arnold C. Harberger, staff member for the President's Materials Policy Commission, testified that an authorized immigration of even 400,000 a year could easily be absorbed without any lowering of our standard of living. Dr. Harold G. Moulton, retired president of the Brookings Institution, published in 1949 a book entitled Controlling Factors in Economic Development, in which he reached the conclusion that so far as natural resources and productive capacity are concerned, the United States could double its population within the next 100 years, and that we could enjoy a standard of living 8 times as high as that prevailing in 1949. Of particular interest in the Commission's hearings was the unanimous view of the major religious faiths of America, Protestant, Jewish, and Catholic, that the United States could safely absorb some 250,000 immigrants a year. These church groups had vigorously supported the now terminated Displaced Persons Program, with its authorization of some 100,000 persons annually for 4 years, over and above the regular immigration quota of 154,000. Some of these church groups testified that a 250,000 annual ceiling was a desirable one for permanent legislation. Others testified that at least for the next 3 years, if not permanently, an annual rate of 250,000 should be established by law. For example, Dr. Walter W. Van Kirk, testifying on behalf of the National Council of Churches of Christ in the United States of America, recommended an annual admission rate of approximately 250,000 immigrants a year for the next 3 years, including regular immigrants and refugees of various categories. This view was specifically supported by Dr. Joseph M. Dawson, representing the Baptist World Alliance, Reverend Harold H. Henderson, representing the Presbyterian Church USA, and the Very Reverend Francis B. Sayre, Jr., Dean of the Washington Episcopal Cathedral. A similar view was expressed by Miss Cordelia Cox of the National Lutheran Council. The experience in immigration under the Displaced Persons Act gives evidence that there is room in the United States. We admitted somewhat more than 250,000 in 1951, and so far we haven't felt any ill effects. What we have been doing up until 1951 was a mere trickle. She went on to describe the situation in her own organization. Comparatively, these numbers were so small that they neither disturbed the balance of the labor market nor met the existing need for labor. In our national office and in our 36 area offices, there are thousands of requests for farm and domestic workers. We can place any number of precision workers, engineers, doctors, and nurses. The need for more workers is documented daily in agencies like ours, which are known to be interested in immigration. These sample experiences of one agency indicate something of the possible total needs of the United States. Monsignor Edward E. Swanstrom, Executive Director, War Relief Services, National Catholic Welfare Conference, testified that instead of the present law, a figure of more than 300,000 per year would be reasonable. We might well establish an annual admission figure in ratio to our population. For example, 1 new immigrant to every 500 people in our country. Various Jewish organizations advocated this same general figure as a minimum annual quota for permanent legislation. The United States Commissioner of Labor Statistics indicated to the Commission that a net annual immigration of 250,000 persons would result in an increase in the labor force by 1955 of less than 0.5%. And this increase, it should be added, would be distributed throughout the entire area and among all the approximately 30,000 occupations of the United States. The Commission recommends an annual immigration quota ceiling of 251,162 based on the 1950 census, which, on the evidence presented, is fully within the capacity of the United States in the foreseeable future. End of Section 9. Recording by Maria Kasper. Section 10 of Whom We Shall Welcome. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Whom We Shall Welcome. Report of the President's Commission on Immigration and Naturalization. Part 3, Chapter 5, National Origins System, Background. The immigration laws can limit the number of immigrants who may enter the United States each year, without reliance upon national origins as the method of selecting such immigrants. The total number and the method of selection within that number are two separate issues. The quota, or ceiling, was introduced into our law in 1921. The concept of the national origins as a means of selection within a quota was introduced in the Immigration Act of 1924, which became effective on July 1, 1929. Each of these devices had its own unique objective. The national origins system has been justified as an attempt to guarantee that particular ethnic, racial, or nationality groups would have preference for entry into the United States, on the assumption that they were more adaptable to American culture. The avowed purpose of the national origins system, therefore, was a qualitative one. It was concerned with the kind of persons coming into the United States rather than with their number. The test it applied was not the individual worth of an immigrant, but rather the presumed superiority of people from certain areas of the world. Place of birth, not individual capacity or actual cultural background, was the test. This concern with the caliber and quality of immigrants is naturally not new to our people. However, in most of our history, qualitative selection was designed to keep out the obviously undesirable individual and not to distinguish between peoples or races. There have been 5 historical stages in the development of our immigration policies. Colonial period. In colonial times, there were no national immigration policies, but only those of the individual colonies and of the mother country. These policies differed from colony to colony and accounted for major differences in regional development, as, for example, between the northern states, which early encouraged free labor from Europe, and the South, where a plantation economy encouraged the importation of slaves rather than of free workers. The general problem of the colonial period was that of peopling an empty land. The population of the colonies was small, and the continent was a vast, unexplored, and unsettled domain. Yet even in those early days, the antagonists of new immigration asserted that there was no room for more immigrants, and that the new arrivals were introducing an alien element and philosophy into the established communities. What may be new immigration to some is old immigration to others. For example, of the 56 signers of the Declaration of Independence, 8 were first-generation immigrants. The earliest colonists were predominantly British, although the Dutch, Swedes, French Huguenots, and some Spanish and Portuguese Jews were settled in certain areas. When the Scotch-Irish came, shortly after 1714, they aroused considerable uneasiness. They were followed by a migration of Germans, whose arrival was resented and feared by many. During these early years, arguments which seem strikingly familiar today were developed against immigration. There was a fear that the new immigrants' differences in speech, customs, and antecedents would disturb the cultural unity of the American people. Many objected to the caliber of the immigrants, particularly to those who were paupers and criminals. Other opposition grew out of religious prejudices. In general, however, immigration was encouraged during the colonial period, and some 750,000 people came to these shores from 1600 to 1770. The charters of Virginia, 1609, and Massachusetts, 1629, granted the right to abide and live not only to our loving subjects, but to any other strangers that will become our loving subjects. In the Declaration of Independence, the colonists declared that one of their chief grievances was that the government of the mother country had hindered the free flow of people into the colonies. The Founding Fathers continued the tradition of encouraging immigration. The Continental Congress, for example, invited the Hessian mercenaries of George III to leave his service and settle in the Americas. The Constitution states that Congress shall have the power to establish a uniform rule of naturalization, necessarily implying that newcomers would join the community. In 1783, George Washington declared, "The bosom of America is open to receive not only the opulent and respectable stranger, but the oppressed and persecuted of all nations and religions, whom we shall welcome to a participation of all our rights and privileges, if by decency and propriety of conduct they appear to merit the enjoyment." The federal government used the principle of religious freedom to stimulate immigration, as the guarantee of religious freedom in the Northwest Ordinance of 1787 exemplifies. Alexander Hamilton, who was born in the British West Indies, wrote in his Report of Manufactures in 1792, "A perfect equality of religious privileges will probably cause immigrants to flock from Europe to the United States." Tench Coxe, Assistant Secretary of State in 1790, compiled Notes for the Information of the Immigrant, in which he listed all religious faiths in the United States and definitely offered assurance of religious liberty as an inducement for immigration. Early 19th century. The second stage of our immigration history occurred approximately from 1800 to 1875. Immigrants were still welcome and sought for, but concern was beginning to be expressed for the qualitative aspects of immigration. As early as 1819, legislation was passed to improve the condition of immigrants on vessels bound for the United States. Although the policy of the nation was to encourage and welcome newcomers, efforts were made to bar paupers, criminals, and others clearly undesirable. The restrictionist sentiments of those who opposed free immigration were sharpened by the steady rise in the tide of immigration. This so-called Native American movement was first crystallized in the Native American Party, launched about 1835. About 1850, this group became known as the Know-Nothings, and in later years it emerged as the American Protective Association. With the expansion of this faction's support and influence, there were recurrent manifestations of anti-alien feeling, some of which were accompanied by acts of violence against foreigners. Yet an 1841 message from President Tyler to Congress stated, "We hold out to the peoples of other countries an invitation to come and settle among us as members of our rapidly growing family." The platform of the Republican Party, then called the Union Party, which Abraham Lincoln helped to write in 1864, stated, "Foreign immigration should be fostered and encouraged by a liberal and just policy." Through World War I. The third stage of immigration in America was in the period of 1875 to 1920. There was a sharp rise in the volume of immigration commencing in the 1880s, with immigrants coming from every country in Europe. This period saw the first general federal immigration statute, which barred convicts, lunatics, and persons likely to become a public charge. The Chinese Exclusion Act, which virtually shut the gates of entry to Chinese, the Contract Labor Act, designed to end wholesale importation of cheap labor, and other acts providing for the exclusion and deportation of aliens. In this period, Congress set up the Immigration Commission of 1907. This commission submitted a voluminous report in 1911, which discussed the desirability of limiting immigration and favored a literacy test as the most feasible single method of restricting undesirable immigration. Bills prescribing a literacy test for immigrants were passed at various times by Congress, but were vetoed by Presidents Cleveland, Taft, and Wilson. A fourth bill was vetoed by President Wilson, but his veto was overridden by Congress in enacting the Immigration Act of 1917. In addition to establishing the literacy requirement, the 1917 Act codified and extended previous restrictions. In addition, it established a so-called Asiatic Barred Zone, which was intended to bar Orientals. There were numerous other statutes which imposed supplementary restrictions on immigration. In general, all the legislation during this period concerned itself with improving the quality of individual immigrants and with shutting out Orientals. Since World War I. The fourth major stage of our immigration history was the period from 1920 to 1950. The United States had emerged from the First World War anxious to return to normalcy, but now the United States, with some 106 million people, was filled up, and the prevailing doctrine of the open door to European migration was challenged from several directions. Politically, the nation was suffering a sharp revulsion against the war. Implicit in much of the thinking was the desire to forget the conflict and all it meant in terms of United States responsibilities in Europe and the world. The country turned its back on President Wilson, on the Internationalists, and on the League of Nations. It indulged in reaction against foreign influences. Fear of the Bolshevist menace resulted in various forms of legislative and administrative suppressions. There were strong undercurrents of racial and religious prejudices, most dangerously expressed in the Ku Klux Klan, which ultimately gained millions of members. Ideologically, the more extreme rationale of this dramatic nationalist revival was the gospel of Nordic white supremacy. These views did not go unchallenged, but they had a marked influence on American attitudes toward immigration. Economically, there were more immediate causes for concern in the situation after World War I. The country entered a prosperous period in late 1915, mainly as a result of the war in Europe. The economy hesitated briefly in the first few months after the armistice, then boomed in earnest. The labor market was very tight, and prices soared to a peak in mid-1920. Strikes became numerous as workers were affected by inflation. The collapse was swift. Wholesale prices dropped and manufacturing production fell. Unemployment mounted rapidly. Labor saw immigration as a potential threat to its standards of living. Socially, the crowding of immigrants in the cities and the slums had created serious concerns about housing, health, crime, and assimilation, problems undoubtedly accentuated by the large number of immigrants in the pre-war era. Many bills prohibiting or restricting immigration were introduced in the House and Senate of the United States Congress in the years from 1918 to 1921. Rumors were afloat that a flood of European immigrants, including many alleged undesirables, were getting ready to engulf the country. This reported prospective invasion was said to number millions. The sheer physical limitation of steamship facilities and of financial means, not to mention political and legal restrictions at home, seemed to play little part in reducing these rumors to a reasonable perspective of the actual conditions. The House Committee on Immigration and Naturalization reported favorably on December 6, 1920, a bill to prohibit all immigration, with very limited exemptions, for a period of 2 years. Finally, out of all this came the 1921 Act, which limited the aliens of any nationality who might be admitted each year to 3% of that nationality resident in the United States in accordance with the 1910 census. This was the beginning of a legislative theory that people themselves were not as important as their ancestry. The 1921 Act was intended as emergency legislation for 1 year, but in due course was extended for 3 years. In the meantime, discussions continued on proposals which ultimately became the Immigration Act of 1924. This act not only established a ceiling quota or a maximum of 150,000, subject to certain minimum quotas, but also established the basic present pattern of the national origin system. It sought to establish a rigid racial and nationality formula for immigration. The curious part of this development was that the major controversy leading up to the national origins system was not on that system itself, but on the literacy test. As has already been stated, 3 presidents vetoed this test for admission. There is considerable mystery shrouding the development of the national origins plan. There was no extended debate in the Congress on it. It seemed to come in as an afterthought, without any major public discussion. Of the some 500 pages of the congressional record devoted to debate on the Immigration Act of 1924, a total of approximately 14 pages were given over, in both the House and the Senate, to the consideration of the national origins system. Only a small minority of the senators and congressmen participated in this discussion. What started out as a debate on a literacy requirement developed into a move to end all immigration, became a temporary emergency measure, and ended up without much discussion as the national origins system. Present law. The 5th and current stage of American immigration dates from the discussions in 1950, culminating in the enactment of the Immigration and Nationality Act of 1952. The 1952 Act retains essentially the national origins quota system, which was introduced by the 1924 Act. However, it does add some important racist provisions, which in fact depart from the basic theory of the national origins system itself. The 1952 Act requires the establishment of separate sub-quotas for colonial dependencies in the Western Hemisphere, a provision which has generally been regarded as discriminatory against the colored people of the Caribbean area. The 1952 Act likewise defines a special geographic area known as the Asia-Pacific Triangle. The people of that area are given a special limited racial or Oriental quota, regardless of the place of their birth, a departure from the origins principle. A discriminatory law. The United States is the only major English-speaking country in the world which has written discrimination into its national immigration laws. Great Britain, Canada, Australia, and New Zealand, the other great English-speaking countries, all of them immigrant-receiving countries, have neither a national origin system nor an inflexible quota limitation. The national origin system is also unique among the laws of English-speaking nations in the candor of its purpose. The legislative history, the statements by its sponsors, and the nature of its operation all point to the fact that the 1924 national origin system was designed and intended to discriminate on the basis of national origin, race, color, and, in effect, religion. It was designed to favor immigrants from Northern and Western Europe and to discriminate against those from Southern and Eastern Europe and against Orientals. 3 groups were set up in the 1924 National Origins Law. 1. The people of the Western Hemisphere, who were granted non-quota status and permitted to enter the United States without regard to any numerical limitation. 2. Orientals, who were completely excluded. And 3. Europeans and others from the rest of the world, for whom some 154,000 quota numbers were allocated for distribution on the basis of place of birth. Some deny that the intent of the national origin system is to discriminate against particular nationalities and races. Perhaps the best answer is the view held by the senator who in 1924 proposed and succeeded in enacting the national origin system. Senator David A. Reed introduced the National Origin System Amendment on the floor of the Senate. His views are clearly stated in the following quotation from a colloquy occurring in hearings before the Senate Committee in 1924. I think most of us are reconciled to the idea of discrimination. I think the American people want us to discriminate, and I don't think discrimination in itself is unfair. We have got to discriminate. The only question that I think worries the committee is whether the use of the 1890 census or the use of the method based on naturalization is the more plausible method of attaining that discrimination, which is the object we are all seeking. The question we are tackling is which is the more plausible, the more reasonable, and the more defensible method of attaining that end. Practically all of us are agreed that that is an end that should be attained. The Senate Judiciary Committee, which conducted the study and submitted the bill, which is now the Immigration and Nationality Act of 1952, specifically considered this same question. That committee rejected proposals seeking to ameliorate the discriminatory provisions of the national origin system in the following terms. It is obvious, therefore, that the plan would disrupt the national origin system, since the quotas for Southern and Eastern Europe have a higher percentage of usage than the quotas for Northern and Western Europe. To distribute the unused quotas on the basis of the registered demand would shift more quota numbers to the countries of Southern and Eastern Europe. In its conclusions, the committee states, "Without giving credence to any theory of Nordic superiority, the subcommittee believes that the adoption of the national origins formula was a rational and logical method of numerically restricting immigration in such a manner as to best preserve the sociological and cultural balance in the population of the United States. There is no doubt that it favored the peoples of the countries of Northern and Western Europe over those of Southern and Eastern Europe, but the subcommittee holds that the peoples who had made the greatest contribution to the development of this country were fully justified in determining that the country was no longer a field for further colonization, and henceforth further immigration would not only be restricted, but directed to admit immigrants considered to be more readily assimilable because of the similarity of their cultural background to those of the principal components of our population." Many of the considerations which lay behind the passage of the national origins quota law have now become of little significance. The fact remains, however, that the national origins system has established a rigid formula for allocating the overall number of quotas determined by Congress to be the maximum number to be admitted annually. Quotas thus established by law are definite and automatically resist the pressures of special groups. It is the rigidity of the formula, however, which also causes much concern, since it eliminates the selection of the immigrants on the basis of their potential worth to the United States. The 1952 Act intentionally perpetuates the national origin system, principally to preserve what the committee stated was the sociological and cultural balance in the population of the United States. This is merely a gentle way of saying that its purpose was to continue racial and national discrimination. That racial and national discrimination is the essence of the Immigration and Nationality Act of 1952 is shown in several other ways. For the first time in American history, a sub-quota is created for immigrants born in colonies or dependent areas of the Western Hemisphere. This substantially reduces immigration of Negroes from the Caribbean area. For example, it shrinks immigration from Jamaica from an average of 1,000 annually to a statutory maximum of 100 annually. A second indication of the intentionally discriminatory character of the Act of 1952 is the fact that although the law repeals the Japanese Exclusion Act and sets up a minimum quota for Japanese, it establishes a racial quota under which Orientals are to be charged to the Asia-Pacific Triangle on the basis not of place of birth, as is true in all other cases, but of their own racial background. This is the national origin system. Until 1921, the United States followed its great tradition of regarding all peoples as being equal and of examining the intrinsic worth of immigrants in terms of their prospective individual contributions to the American scene. In 1921, in 1924, and even more emphatically in 1952, our immigration laws abandoned our traditional faith in the individual human being. End of Section 10. Recording by Maria Kasper. Section 11 of Whom We Shall Welcome. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Whom We Shall Welcome. Report of the President's Commission on Immigration and Naturalization. Part 3, Chapter 6. National Origins System, Assumptions. There is a great deal of official documentation as to the assumptions and basic philosophies which motivated adoption of the National Origins System by Congress in 1924. In particular, the Congress relied upon the findings of the Immigration Commission of 1907, which reported its conclusions in 1911, and upon a report prepared by Dr. Harry Laughlin of the Carnegie Institution for the House Committee on Immigration in 1922. These studies were conducted without public hearings, and it is clear that some of their conclusions ran counter to the evidence they themselves include. In the Commission's hearings, the people of America, the scientists, the scholars, the social workers, the clergy, leaders of business, labor, and agriculture, and others, have for the first time had a substantial opportunity to present evidence and views on the validity of the National Origins System. The preponderant testimony is that the underlying assumptions of the system are wrong. Scientific and other studies, and an enormous amount of additional research completed since the 1924 Act was passed, corroborate this conclusion. Assumptions behind the National Origins System. The fundamental assumption of the National Origins System is that the place of birth of prospective immigrants is a reliable indication of their possible contribution to the United States, and the likelihood of their becoming good citizens. To those holding this theory, the so-called old immigrants from Northern and Western Europe are better than the so-called new immigrants from Southern and Eastern Europe. There are three large areas of assumption behind the National Origins System. 1. That there are inferior and superior races. 2. That immigration is harmful, particularly to the economic life of America. And 3. That the so-called new immigrants have inferior personal qualities. The theory of superior races. The Immigration Commission's report of 1911 sought to classify races in a pseudo-scientific manner as having group and defined characteristics. Its theory was that all races can be combined into two clear-cut categories: the superior, those that were predominant in immigration prior to 1880, and the inferior, all others. An interesting contrast between scientific viewpoints then and now is available. The whole argument behind the National Origins System was given forceful expression by a former anthropologist of the American Museum of Natural History, Madison Grant, in a book published more than 35 years ago. He said, "These new immigrants were no longer exclusively members of the Nordic race, as were the earlier ones. The new immigration contained a large and increasing number of the weak, the broken, and the mentally crippled of all races drawn from the lowest stratum of the Mediterranean basin and the Balkans, together with hordes of the wretched, submerged populations of the Polish ghettos. Our jails, insane asylums, and almshouses are filled with this human flotsam, and the whole tone of American life, social, moral, and political, has been lowered and vulgarized by them." Compare this with the views of a present distinguished anthropologist of the same institution, Margaret Mead. In her testimony before the Commission, she said, "All human beings from all groups of people have the same potentialities. Our best anthropological evidence today suggests that the people of every group have about the same distribution of potentialities. When you add to that it is, on the whole, the enterprising who immigrate, and those who care more about freedom and are willing to risk their skins for freedom in many parts of Eastern Europe, you realize that any such point of view is artificial and cuts off good ancestors for our great-great-grandchildren. We want that ancestry in good human stocks from wherever it comes in the world. Another comparison of scientific evidence in 1924 and 1952 is also illuminating. In 1920, Dr. Harry Laughlin was asked by the House Immigration Committee to study the relation of biology to immigration, particularly as it bore on the problems of social degeneracy. His report, submitted in November 1922, includes the following comment. "We in this country have been so imbued with the idea of democracy, or the equality of all men, that we have left out of consideration the matter of blood or natural inborn hereditary mental and moral differences. No man who breeds pedigreed plants and animals can afford to neglect this thing." Congressman Albert Johnson, then chairman of the House Judiciary Committee, examined this report and stated, "I have examined Dr. Laughlin's data and charts and find that they are both biologically and statistically thorough and apparently sound." However, the presently accepted scientific views appear in testimony before the Commission by Professor Ralph L. Beals, Professor of Anthropology, University of California, and formerly president of the American Anthropological Association. He said, "All scientific evidence indicates that all peoples are inherently capable of acquiring or adapting to our civilization. Upon this point, the American Anthropological Association has unanimously endorsed an official statement by its executive board. But the peoples who have grown up in and been adapted to a quite different way of life, that is, a different culture, to use anthropological language, may find it difficult as adults to adjust to new conditions. The degree of difficulty will vary according to the way of life in which people have developed. To put it in simple terms, because of their training and experience, some people may find it slightly easier to adapt to American civilization than do others, but this difference does not lie in any inherent qualities attaching to a particular group." He informed the Commission that there is no scientific verification for any belief in inherited difference in the ability of different peoples to be assimilated into the United States. He stated that there were individual differences in this regard, but no demonstrable scientific differences in the group. Other expert witnesses testified to the same conclusion. Professor Albert Grazia, Executive Officer for the Committee of Research in Social Sciences at Stanford University, stated, "The fact is that the doctrines that were rather widespread about ethnic superiority and inferiority in the early 20s have been systematically refuted by every branch of science that concerns itself with those presumed inherent superiorities of different ethnic groups. Now, the surprising thing is that it is rather difficult to put one's finger on this literature, because the fact is so well assumed by anyone of any competency in the field that we haven't bothered to build up a great literature dispelling these myths." Professor Philip M. Hauser, Department of Sociology, University of Chicago, and former acting director of the United States Bureau of the Census, testified of the 1952 Act that 3. It perpetuates a doctrine of racism based on unwarranted assumptions in respect to the differential quality and potentials of various ethnic and national groups. 4. It is blind to the historic example afforded by the experience of the United States of the capacity for any people to rise to positions of high social, economic, and political level when provided with the opportunity to do so. In attempting to support its distinctions between races and its belief that some races are inferior to others, the 1907 Immigration Commission looked to individual motives for immigration. First, it argued, The new immigrants came here only temporarily and not to stay permanently. However, it presented no evidence that the new immigrants were less likely to become citizens than the so-called old immigrants. On the contrary, its data proved only what the Displaced Persons Commission has since found, that the percentage of immigrants becoming citizens increased with the length of their residence in the United States. The participation of aliens in the armed forces of the United States in 3 wars since the 1911 report is evidence enough of the invalidity of the report's conclusions. The 1911 report also contended that the new immigrants came here for a less worthy reason than the old immigrants. There is no evidence in its report to justify this conclusion. The motives which have brought people to the United States have been much the same since the discovery of the New World: political and religious persecution in their homelands, economic opportunity and freedom's call in the New World. History shows that much the same motives and hopes brought the English and Scots in the 17th and 18th centuries, the Irish, Germans, Scandinavians, Orientals, and French Canadians in the 19th century, the Italians, Jews, and Poles in the early 20th century, and the present refugees and escapees from communism and other forms of totalitarianism. The impulse to emigrate, which affected people, may have arisen in different countries at different times. The same desire for freedom which motivated the German refugees of 1848 seems now to be inspiring the Iron Curtain refugees of 1952. All the reliable evidence refutes this conclusion of the 1911 report. Perhaps Theodore Roosevelt best described this situation when, in his autobiography, he said that the term settler is a euphemistic name for an immigrant who came over in the steerage of a sailing ship in the 17th century instead of the steerage of a steamer in the 19th century. National policy should be formulated on the basis of accurate and reliable information. The best scientific evidence available today is that there is no evidence of any inborn differences of personality, character, intelligence, or cultural and social traits among races. The basic racist assumption of the national origin system is scientifically invalid. The theory of economic harm. The earliest arguments for the national origins quotas relied heavily upon predictions of economic harm likely to develop from immigration. In Chapter 2, the Commission discusses the economic aspects of immigration. The evidence not only repudiates the theory of economic harm, but actually shows that immigration is economically desirable and necessary for the United States. In the arguments of 40 years ago, various reasons were adduced to support the 1911 report's conclusions. 1. That a larger percentage of the new immigrants were unskilled labor. This was not substantiated in the report. 2. That the new immigrants pushed the old immigrants out of the labor force by lowering the conditions of labor. This was not substantiated by evidence before the 1907 Commission. Perhaps the best proof of the continuing unsoundness of this reason is the present attitude of organized labor in urging an increase in the number of immigrants to be permitted to come into the United States, and in recommending the abolition of the national origins system. 3. That immigrants weakened labor unions. The history of organized labor in America proves that this was not true then or since. 4. That immigration increased the number of industrial accidents. There was no objective evidence to support this reason. 5. That the new immigrants created no new industries. This is clearly erroneous in the light of the contributions by immigrants to the development of the American economy. 6. That immigration caused or aggravated unemployment during Depression. The 1911 report contained no proof to support this reason. On the contrary, Chapter 2 of this report reviews evidence which indicates that there is no relationship between immigration and unemployment. Whatever may have been the situation caused by unrestricted immigration in 1911, immigration of the size contemplated by this commission cannot be a factor in aggravating unemployment or depressions. 7. That the new immigrants did not go into agriculture. To an extent, this was true, but it was an incident of the industrialization of the United States and of the demand for services in commerce and industry, rather than an indication of national and racial differences. Generally speaking, the evidence before this commission shows that a reasonably limited amount of immigration would have no adverse effect, and that, on the other hand, there would be considerable economic gains and advantages to be derived from such immigration. The theory of inferior personal qualities. In this area, several factors were constantly discussed by supporters of the national origins theory. 1. It was stated that illiteracy was greater among the new immigrants than among the old immigrants, and that this was due to inherent racial capacities. All reliable evidence shows that illiteracy is more closely related to opportunity than to any other single factor. The literacy of persons admitted under the Displaced Persons Act showed a surprising degree of similarity to that of the American people as a whole. The theory of inherent racial tendencies to illiteracy is completely disproved by the 100 years' experience of the American public school system, which shows that there are no substantial differences in the capacity of different groups to be educated and Americanized. 2. It was alleged that there was more criminality among the foreign-born than among the native-born. This is not true. When the 1907 Commission turned to the only existing source of information, the Census Report on Prisoners, it discovered that immigration has not increased the volume of crime to a distinguishable extent, if at all, that the percentage of immigrants among prisoners had actually fallen between 1890 and 1904, and that Native Americans exhibited in general a tendency to commit more serious crimes than did the immigrant. Similar conclusions emerge from the studies of criminality during the past 25 years. As to the total inclination to crime, President Hoover's National Commission on Law Observance and Enforcement, the so-called Wickersham Commission, found in 1931 that the foreign-born committed fewer crimes than the native-born in proportion to their respective numbers in the total population. The best available scientific information indicates that criminality has no direct relationship to racial or ethnic affiliations. 3. The 1907 Commission's data and conclusions relating to the evidence of insanity showed that no objection could be made to the new immigrants on that ground. In summary, it would appear that there was no reliable evidence that new immigrants were inferior to old immigrants in terms of personal qualities. Assimilation of immigrants. It is natural and proper to be concerned about the assimilability of new immigrants. The preponderant weight of testimony before the Commission was to the effect that immigrants have made a satisfactory adjustment to the American scene. Helen M. Harris testified on behalf of the National Federation of Settlements and Neighborhood Centers, a group of social institutions which has had first-hand experience for more than 65 years with immigrants from almost every country of the world. Ms. Harris testified that her organization has found no essential difference in the capacity of different groups to assimilate. The question of assimilability of new immigrants has arisen at every stage of our history. Even before our own revolution, some people already here were complaining about the strange newcomers from Scotland and Germany. And of course, during the Revolutionary War, there was serious complaint against the more recent immigrants from England who were loyal to that country. Before the Civil War, there were fears that Irish and Germans would never be assimilated. These complaints were similar to those before World War I, that the Southern and Eastern Europeans could not be assimilated. Each new group or category of immigrants evoked fear that they could not assimilate. But nonetheless, with the passage of time, each of the various succeeding groups became full participating members of the American community. Distinguished witnesses who testified before the Commission made this point on various occasions. Dr. Carl Whitkey, Dean of the Graduate School of Western Reserve University, Cleveland, Ohio, who is an eminent historian on American immigration, testified as follows. Now, the other point I want to make is that many of the things that were said in later years in criticism of the Italian, the Pole, the Czech, and so on the ground that they were an unassimilable group and represented a very foreign custom and ideology, they were all said 100 years ago about these so-called representatives of the older immigration group. Let me again pick the Irishman by way of example, because I think of no immigrants who more quickly became a 100% or 300% American than the Irishman. But in the 1850s and 1800s, if you read the newspaper comments and all the literature, you will find that the Irish immigration which came in such terrific volume alarmed the old-time Americans. The Irishman spoke a peculiar brogue, and he had a peculiar dress. He was forced to live in the slum tenements, in the garrets, and in the cellars, and the Irish shanty towns developed in all our big cities. He was charged with being intemperate and loving liquor too much, or being a kind of boisterous, riotous person. He was depressing the labor standards of the average American. A lot of the Americans said, here we have an unassimilable group here in America, more interested in its homeland, in its foreign church, and so on, than in becoming good Americans. I select this simply to indicate that within a short time these Irishmen who came out of the garrets and the cellars and the slums rose up in the scale socially, economically, politically, to become as enthusiastic and patriotic Americans as any native Yankee who had come over on the Mayflower. The whole political situation was introduced 100 years ago, much as you have heard it introduced today. My whole point in saying these things is to emphasize the fact that if you take the broad historical point of view, I have heard nothing said by way of criticism of more recent immigrants that cannot be duplicated from the record as to what has been said about older immigrants of more than a century ago, but who in due course and with a proper American attitude towards them became quickly assimilated and represented an excellent economic and social contribution to this developing America. The national origin system is based on false assumptions, unsubstantiated by physical science, history, sociology, economics, or anthropology. The Commission found substantial evidence to corroborate the Senate Judiciary Committee statement that many of the considerations which lay behind the passage of the National Origins Quota Law have now become of little significance. The Commission recommends, therefore, that since the basis of the national origins system is gone, the system itself should go. End of Section 11. Recording by Maria Kasper. Section 12 of Whom We Shall Welcome. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Whom We Shall Welcome. Report of the President's Commission on Immigration and Naturalization. Part 3, Chapter 7. National Origins System, Operation. The National Origins System has been in effect for more than 23 years, and some of its results are clearly discernible. It achieved its restrictive purpose of drastically cutting total immigration from quota countries. In particular, it discriminated against people from Southern and Eastern Europe and from Asia. It failed in its positive purpose of channeling immigration in accordance with a statistical pattern. Actual immigration from 1930 to 1952 bears little resemblance to the ethnic and racial ratios incorporated into the national origins quota system. The quotas. The individual country quotas under the national origins system are shown in Table 5. The quotas under the 1924 and 1952 Acts differ in only two regards. 1. The assignment of minimum quotas to certain Asian and African countries, and 2. a slight pro rata reduction of all other quotas other than the minimum as a result of a slight change in the method of computation. The principles and the net effect of the national origin system are retained in the 1952 Act. Table 5. Annual immigration quotas under the 1924 Act and the Immigration and Nationality Act of 1952. 1. Afghanistan. 1924 Act quota 100. 1952 Act quota 100. No loss or gain. 2. Albania. 1924 100. 1952 100. No loss or gain. 3. Andorra. 1924 100. 1952 100. No loss or gain. 4. Arabian Peninsula. 1924 100. 1952 100. No loss or gain. 5. Asia Pacific Triangle. 1924 quota none. 1952 quota 100. Gain of 100. 6. Australia. 1924 100. 1952 100. No loss or gain. 7. Austria. 1924 1413. 1952 1405. Loss of 8. 8. Belgium. 1924 1304. 1952 1297. Loss of 7. 9. Bhutan. 1924 100. 1952 100. No loss or gain. 10. Bulgaria. 1924 100. 1952 100. No loss or gain. 11. Burma. 1924 none. 1952 100. Gain of 100. 12. Cambodia. 1924 none. 1952 100. Gain of 100. 13. Cameroons. Trust Territory, United Kingdom. 1924 100. 1952 100. No loss or gain. 14. Cameroon. Trust Territory, France. 1924 100. 1952 100. No loss or gain. 15. Ceylon. 1924 none. 1952 100. Gain 100. 16. China. 1924 100. 1952 100. No loss or gain. 17. Chinese. Racial. 1924 105. 1952 105. No loss or gain. 18. Czechoslovakia. 1924 2874. 1952 2859. Loss of 15. 19. Danzig, Free City of. 1924 100. 1952 100. No loss or gain. 20. Denmark. 1924 1181. 1952 1175. Loss of 6. 21. Egypt. 1924 100. 1952 100. No loss or gain. 22. Estonia. 1924 116. 1952 115. Loss 1. 23. Ethiopia. 1924 100. 1952 100. No loss or gain. 24. Finland. 1924 569. 1952 566. Loss of 3. 25. France. 1924, 3,086, 1952, 3,069, loss of 17. 26. Germany. 1924, 25,957, 1952, 25,814, loss of 143. 27. Great Britain and Northern Ireland. 1924, 65,721, 1952, 65,361, loss 360. 28. Greece. 1924, 310, 1952, 308, loss 2. 29. Hungary. 1924, 869, 1952, 865, loss 4. 30. Iceland. 1924, 100, 1952, 100, no gain or loss. 31. India. 1924, 100, 1952, 100, no gain or loss. 32. Indonesia. 1924, none, 1952, 100, gain of 100. 33. Iran, Persia. 1924, 100, 1952, 100, no gain or loss. 34. Iraq. 1924, 100, 1952, 100, no gain or loss. 35. Ireland. 1924, 17,853, 1952, 17,756, loss of 97. 36. Israel. 1924, 100, 1952, 100, no gain or loss. 38. Japan, racial and non-racial. 1924, 100, 1952, 185, gain of 85. 39. Jordan. 1924, 100, 1952, 100, no gain or loss. 40. Korea. 1924, none, 1952, 100, gain of 100. 41. Laos. 1924, none, 1952, 100, gain of 100. 42. Latvia. 1924, 236, 1952, 235, loss of 1. 43. Lebanon. 1924, 100, 1952, 100, no gain or loss. 44. Liberia. 1924, 100, 1952, 100, no gain or loss. 45. Libya. 1924, none, 1952, 100, gain of 100. 46. Liechtenstein. 1924, 100, 1952, 100, no gain or loss. 47. Lithuania. 1924, 386, 1952, 384, loss of 2. 48. Luxembourg. 1924, 100, 1952, 100, no gain or loss. 49. Monaco. 1924, 100, 1952, 100, no gain or loss. 50. Morocco. 1924, 100, 1952, 100, no gain or loss. 51. Muscat, Oman. 1924, 100, 1952, 100, no gain or loss. 52. Nauru, Trust Territory, Australia. 1924, 100, 1952, 100, no gain or loss. 53. Nepal, 1924 100, 1952 100, no gain or loss. 54. Netherlands, 1924 3,153, 1952 3,136, loss of 17. 55. New Guinea, Trust Territory, Australia, 1924 100, 1952 100, no gain or loss. 56. New Zealand, 1924 100, 1952 100, no gain or loss. 57. Norway, 1924 2,377, 1952 2,364, loss of 13. 58. Pacific Islands Trust Territory, United States, 1924 none, 1952 100, gain of 100. 59. Pakistan, 1924 none, 1952 100, gain 100. 60. Palestine, Arab Palestine, 1924 100, 1952 100, no gain or loss. 61. Philippines, 1924 100, 1952 100, no gain or loss. 62. Poland, 1924 6,524, 1952 6,488, loss of 36. 63. Portugal, 1924 440, 1952 438, loss of 2. 64. Rwanda-Urundi Trust Territory, Belgium, 1924 100, 1952 100, no gain or loss. 65. Romania, 1924 291, 1952 289, loss of 2. 66. Samoa, Western Trust Territory, New Zealand, 1924 100, 1952 100, no gain or loss. 67. San Marino, 1924 100, 1952 100, no gain or loss. 68. Saudi Arabia, 1924 100, 1952 100, no gain or loss. 69. Somaliland, Trust Territory, Italy, 1924 none, 1952 100, gain of 100. 70. Southwest Africa Mandate, 1924 100, 1952 100, no gain or loss. 71. Spain, 1924 252, 1952 250, loss of 2. 72. Sweden, 1924 3,314, 1952 3,295, loss of 19. 73. Switzerland, 1924 1,707, 1952 1,698, loss of 9. 74. Syria, 1924 100, 1952 100, no gain or loss. 75. Tanganyika, Trust Territory, United Kingdom, 1924 100, 1952 100, no gain or loss. 76. Thailand, Siam, 1924 100, 1952 100, no gain or loss. 77. Togo, Trust Territory, France, 1924 100, 1952 100, no gain or loss. 78. Togoland, Trust Territory, United Kingdom, 1924 100, 1952 100, no gain or loss. 79. Trieste, free territory of, 1924 100, 1952 100, no gain or loss. 80. Turkey, 1924 226, 1952 225, loss of 1. 81. Union of South Africa, 1924 100, 1952 100, no gain or loss. 82. Union of Soviet Socialist Republics, 1924 2798, 1952 2697, loss of 101. 83. Vietnam, 1924 none, 1952 100, gain of 100. Yap and other Pacific Islands, 1924 100, 1952 none, loss of 100. 84. Yemen, 1924 none, 1952 100, gain of 100. 85. Yugoslavia, 1924 938, 1952 933, loss of 5. Total: 1924 154,277, 1952 154,657. Losses 1,005, gains 1,385, net gain 380. That the quota system discriminates against Southern and Eastern European countries is evidenced by the fact that 81.6% of the quotas are allocated to the Northern and Western European countries, while only 16% are allocated to Southern and Eastern European countries. Results of the national origin system. It reduced immigration from Southern and Eastern Europe. From 1900 to 1919, immigration from Northern and Western Europe averaged some 145,000 persons annually, and from Southern and Eastern Europe some 488,000. The 1921 and 1924 Acts cut back particularly the quota immigration from Southern and Eastern Europe. After 1929, quota immigration from this area became a mere trickle compared to the flow immediately after the turn of the century. The following table shows what happened. Table 6. Immigrants admitted by area 1900 to 1951. Period 1900 to 1909. Northern and Western Europe, yearly average 181,156. Index, with 1900 to 1909 set as 100%, 100%. Southern and Eastern Europe, 1900 to 1909, yearly average 582,287, index 100%. Period 1910 to 1919. Northern and Western Europe, yearly average 111,264, index of 61% compared to the previous decade. Southern and Eastern Europe, yearly average 394,392, index of 68% compared to previous decade. Period 1920 to 1929. Northern and Western Europe, yearly average 127,390, index of 70% of the first decade. Southern and Eastern Europe, yearly average 130,281, index 22% of first decade. Period 1930 to 1939. Northern and Western Europe, 25,815, index 14%. Southern and Eastern Europe, yearly average 18,712, index 3%. Period 1940 to 1949, Northern and Western Europe, yearly average 37,270, index 21%. Southern and Eastern Europe, yearly average 10,035, index 2%. Single year 1950, Northern and Western Europe, yearly average 75,909, index 42%. Single year 1950, Southern and Eastern Europe, yearly average 135,603, index 23%. Single year 1951, Northern and Western Europe, yearly average 51,481, index 28%. Southern and Eastern Europe, yearly average 114,600, index 20%. The rise of immigration from Southern and Eastern Europe in 1950-1951 reflects the operation of the Displaced Persons Program. Through mortgaging of future quotas, the Displaced Persons Act permitted immigrants chargeable to small quotas to enter without regard to quota availability in any given year. Further effects of the national origin system. It reduced the immigration of Asiatics. The official statistics also show a sharp cutback in immigration of people of Asiatic origin after the National Origins Law went into effect in 1929. Table 7, Reductions in Immigration of Asiatics, Quota and Non-Quota, 1900 to 1951. 1900 to 1909. Chinese 19,182, Indians 3,989, Japanese 142,536, Korean 7,749. 1900 to 1919, Chinese 18,885, Indians 3,184, Japanese 77,257, Korean 996. 1920 to 1929, Chinese 25,523, Indians 1,286, Japanese 40,482, Korean 643. 1930 to 1939, Chinese 2,687, Indians 179, Japanese 2,367, Korean 85. Some single years from that decade. 1930, Chinese 970, Indians 51, Japanese 796, Korean 27. 1931, Chinese 748, Indians 65, Japanese 626, Korean 21. 1932, Chinese 545, Indians 50, Japanese 503, Korean 19. 1933, Chinese 44, Indians 1, Japanese 60, Korean 2. Decade 1940 to 49, Chinese 7,764, Indians 153, Japanese 904, Korean 86. Single years. 1947, Chinese 1,128, Indians 36, Japanese 9, Korean 1. 1948, Chinese 3,574, Indians 42, Japanese 316, Korean 36. 1949, Chinese 2,490, Indians 55, Japanese 492, Korean 39. 1950, Chinese 1,289, Indians 70, Japanese 45, Korean 6. 1951, Chinese 1,083, Indians 74, Japanese 206, Korean 24. Unused quotas. The 1924 Act established national quotas for immigration. The total authorized quota ceilings for the 28-year period since then, fiscal years 1925 to 1952, is 4,362,354 quota numbers. Of this, a total of only 1,923,509 was used. In other words, since the 1924 Act, 56% of the available quota was not used. Or, to summarize, total quota numbers available, fiscal years 1925 to 52, 4,362,354. Total quota numbers actually allotted for use, 1,923,509, 44%. Total quota numbers unused, 2,438,845, 56%. A picture of what happened to quotas in the two most recent years may be illuminating. Total quota numbers available fiscal year 1951, 154,285. Total quota numbers actually allotted for use fiscal year 1951, 76,730, includes 9,579 numbers allotted to displaced persons under the Displaced Persons Act as amended. Total quota numbers unused, 77,755. Total quota numbers available fiscal year 1952, 154,277. Total quota numbers actually allotted for use, 92,181, includes 16,021 numbers allotted to displaced persons under Displaced Persons Act as amended. Total quota numbers unused fiscal year 1952, 62,096. Waiting lists. Despite large quantities of unused quota numbers assigned to some countries, there are lengthy waiting lists of people in other countries who were not able to obtain quota numbers because their country's quota was oversubscribed. The following are the 5 largest quotas. Great Britain and Northern Ireland, 65,721. Germany, 25,957. Ireland, 17,853. Poland, 6,524. Italy, 5,677. Only the British and Irish quotas are undersubscribed or open. The other 3 are oversubscribed or closed in varying degree. Thus, as of August 26, 1952, only those applicants registered under the German quota prior to July 1, 1952, could have expected quota numbers for the quarter October 1 through December 31, 1952. So far as the Polish quota applicants were concerned, only those registered prior to October 1, 1948, could be allotted quota numbers for that quarter in 1952. Registrants under the Italian quota who were in non-preference categories and who registered prior to January 1, 1950, were eligible to receive numbers for that quarter, provided, as always, that preference demands did not intervene. The State Department has provided the Commission with the following list of oversubscribed quotas and the total registration thereunder, as reported by consular offices on August 1, 1952. There is also listed the year through which quotas were mortgaged under the Displaced Persons Act as amended. Table 8. Waiting lists for quota numbers. Albania. Present annual quota 100. Total registration 2,265. Year to which quota mortgaged 1956. Australia. Present quota 100. total registration 2,836, year to which quota mortgaged, not applicable under Displaced Persons Act. Austria, present annual quota 1,413, total registration 27,163, year to which quota mortgaged 1955. Bulgaria, present annual quota 100, total registration 1,665, year to which quota mortgaged 1964. China, white, quota 100, total annual registration 1,665, quota mortgaged to 1964. Chinese, racial, quota 105, total registration 2,495, quota mortgaged to 1964. Czechoslovakia, present quota 2,874, total registration 34,515, quota mortgaged through 1958. Danzig, quota 100, registration 4,842, quota mortgaged to 1961. Denmark, present quota 1,181, total registration 4,842, quota mortgage under Displaced Persons Act not applicable. Egypt, present quota 100, total registration 3,400, quota mortgage not applicable. Estonia, present quota 116, total registration 3,908, quota mortgaged to the year 2146. Finland, present quota 569, total registration 3,119, quota mortgage not applicable. France, present quota 3,086, total registration 4,716, quota mortgage not applicable. Germany, present quota 25,957, total registration 262,598, quota mortgage not applicable. Greece, present quota 310, total registration 24,227, quota mortgaged through the year 2014. Hungary, present quota 869, total registration 20,697, quota mortgaged through 1989. India, present quota 100, total registration in India 6,320, outside India 1,501, quota mortgage not applicable. Iran, present quota 100, total registration 4,730, quota mortgage through 1956. Iraq, present quota 100, total registration 7,008, quota mortgage not applicable. Israel, present quota 100, total registration 4,050, quota mortgage through 1954. Italy, present quota 5,677, total registration 32,107, quota mortgage not applicable. Latvia, present quota 236, total registration 9,104, quota mortgage through the year 2274. Lebanon, present quota 100, total registration 2,895, quota mortgage not applicable. Lithuania, present quota 386, total registration 11,946, quota mortgage through the year 2090. Netherlands, present quota 3,153, total registration 42,265, quota mortgage not applicable. New Zealand, present quota 100, total registration 710, quota mortgage not applicable. Norway, present quota 2,377, total registration 16,381, quota mortgage not applicable. Palestine, present quota 100, total registration 4,394, quota mortgage not applicable. Philippines, present quota 100, total registration 4,217, quota mortgage through 1954. Poland, present quota 6,524, total registration 166,244, quota mortgage through the year 2000. Portugal, present quota 440, total registration 14,871, quota mortgage not applicable. Romania, present quota 291, total registration 23,807, quota mortgage through the year 2019. Spain, present quota 252, total registration 6,208, quota mortgage through the year 1956. Syria, present quota 100, total registration 2,113, quota mortgage not applicable. Trieste, present quota 100, total registration 623, quota mortgage through 1958. Turkey, present quota 226, total registration 8,874, quota mortgage through 1964. Union of South Africa, present quota 100, total registration 697, quota mortgage not applicable. USSR, present quota 2,798, total registration 46,292, quota mortgage through 1980. Yugoslavia, present quota 938, total registration 56,068, quota mortgage through 2014. Reduction of quotas through special provisions. Quotas under the law are reduced by virtue of the effect of certain provisions of general or special laws, thereby further limiting the number who may immigrate to the United States. These reductions of the total quota came about by suspension of deportation. The general immigration law authorizes, under certain circumstances, the suspension of deportation of persons already in the United States. In each case, the quota for that person's country of origin is reduced by 1. By special acts, Congress may pass private bills for particular individuals. In each such case, the quota is reduced by 1. And by Section 4 of the Displaced Persons Act as amended. A special section of the Displaced Persons Act permits certain aliens already in the United States to convert their status to that of permanent resident. In each such case, the appropriate quota is reduced by 1. The total of all quotas affected by changes of status is indicated by the following figures, which show quota charges through the second session of the 82nd Congress. Table 9. Quota charges for adjustment of status. 1945, suspension of deportation, 5,429. 1946, suspension of deportation, 3,273. 1947, suspension of deportation, 2,981. Special Act, 26. Total charges, 3,007. Or 2% of total quota. 1948, suspension of deportation 1,652, Special Act 27, total charges 1,679, or 1.1% of total quota. 1949, suspension of deportation 1,392, Special Act 83, total charges 1,475, or 1% of total quota. 1950, suspension of deportation 833, Special Act 133, total charges 966, or 0.6% of total quota. 1951, suspension of deportation 1,506, Special Act 289, total charges 1,795, or 1.2% of total quota. 1952, suspension of deportation 1,780, Special Act 192, Displaced Persons Act Special 3, total charges 1,975, or 1.3% of total quota. 1953, suspension of deportation 1,360, Special Act 233, Displaced Persons Act Special 29, total charges 1,622, or 1% of total quota. Future years, suspension of deportation 1,781, Special Act 92, Displaced Persons Act Special 1,443, or total charges of 3,316. Failure of the national origin system. Racial and national pattern of immigration. The purpose of the national origin system is the selection and admission of immigrants in accordance with a basic racial and nationality ratio. In this regard, the national origin system has failed. For the period July 1, 1929 to June 30, 1951, during which the national origin system actually has been in effect, a total of 2,010,887 immigrants were admitted to the United States, or an average of 91,404 per year. The quota immigrants averaged 54,095 per year, and the annual average for non-quota immigrants was 37,309. Considering only the quota countries, the distribution of actual immigration, quota and non-quota, varies considerably from that of the quotas themselves. The quota pattern did not prevail. Under the quota allocation, 81.6% were to come from Northern and Western Europe. Actually, only 55.8% of the quota immigrants came from this area. Under the quota allocation, only 16% were to come from Southern and Eastern Europe. In fact, of all quota immigration in the 22-year period, 1930 to 51, some 42.4% came from Southern and Eastern Europe. The following table shows the picture of the failure of the national origins to accomplish its fundamental avowed purpose. Table 10, United States Immigration 1930 to 51 by regional origins. Quotas under 1924 Act. Northern and Western Europe 81.6%, Southern and Eastern Europe 16.0%, Asia 1.2%, Africa 0.8%, Pacific 0.5%, total 100%. Total immigration: Northern and Western Europe 38.7%, Southern and Eastern Europe 34.2%, Asia 1.7%, Africa 0.2%, Pacific 1%, non-quota Western Hemisphere 24%. Quota immigration: Northern and Western Europe 55.8%, Southern and Eastern Europe 42.4%, Asia 1.1%, Africa 0.3%, Pacific 0.4%. Mrs. Helen F. Eckerson, Chief of the Statistical Branch of the Immigration and Naturalization Service, wrote in the Immigration and Naturalization Service Monthly Review for October 1945, "The pattern set by the admission of immigrants during the period 1930 to 1944 did not at all resemble the national origins plan set up by Congress. Although the national origins system did not establish a prefixed flow of immigration, the limitation on numbers did maintain a racial status quo in the United States, both in terms of nationality and racial characteristics. In terms of nationality origin, the following table, from data provided by the Bureau of the Census, shows that the status quo was maintained. Table 11, White Population of the United States by Origin, 1920 and 1940. Northern and Western Europe, 1920, 79.1%, 1940, 77.9%, 20-year difference, a loss of 1.2%. Southern and Eastern Europe, 1920, 15.1%, 1940, 15.9%, 20-year difference, gain of 0.8%. Western Hemisphere, 1920, 5.6%, 1940, 5.9%, 20-year difference, gain of 0.3%. Other, 1920, 0.3%, 1940, 0.3%, 20-year difference, none. The maintenance of the general status quo is shown in the following table on the three major racial groups. Table 12, Population of the United States by race, 1920 and 1950. Numbers rounded to thousands. 1920, total, 105,711,000. 1950, 150,697,000. White, 1920, 94,821,000, 89.7%. 1950, 134,942,000, 89.5%. Negro, 1920, 10,463,000, 9.9%. 1950, 15,043,000, 10%. American Indians, 1920, 244,000, 0.2%. 1950, 343,000, 0.2%. Other non-whites including Orientals, 1920, 182,000, 0.2%. 1950, 370,000, 0.2%. Thus, what succeeded in maintaining a racial status quo was not the arbitrary and unsuccessful national origins formula, but the reduction in the total amount of immigration. This was done by the quota ceiling, which kept immigration so low that the resulting increment to our population could have no significant effect on the national origins and racial composition of a country of our size. Congressional recognition of failure. The inflexibility of the national origins system brought about its failure in another respect. This rigidity prevented the accomplishment of certain desired national objectives and required the Congress to bypass the national origins system on many occasions through special immigration legislation. Among such legislative bypassing of the national origins system are the following. War fiancés. Ancillary to the War Brides Program, legislation was enacted to permit the temporary entry of fiancés in order that they might marry veterans who were citizens of the United States. Upon the performance of the marriage, they were permitted to remain in the United States permanently. By June 30, 1950, a total of 8,538 aliens were admitted under this legislation, without regard to the established quotas. Displaced persons. As a result of special legislation enacted in 1948 and in 1950, the Congress authorized the entry of certain designated displaced persons and other refugees without regard to the current availability of quotas, and subject to charges made against future annual quotas. Some 393,542 persons were admitted under this program by June 30, 1952. Skilled sheep herders. Congress made special provision for the admission of skilled sheep herders by special quota arrangements, as noted in Chapter 2. Intelligence operatives. Under legislation enacted in 1949, entry is authorized each year outside of the established quotas under certain conditions for 100 aliens and members of their immediate families who are certified as useful in executing the intelligence mission of the Central Intelligence Agency. Overseas enlistees. Special legislation sanctions the admission into the United States outside of the established quotas under specified conditions of certain aliens who enlist in the armed forces of the United States in foreign countries. The 1950 enactment fixed the limit of such admissions at 2,500. This ceiling was increased in 1951 to 12,500. Private bills. In recent years, there has been a growing disposition on the part of Congress to enact private relief legislation exempting designated individuals from the requirements of the immigration laws. When granted, such relief is without regard to current availability of quotas. Eliminating the duplications resulting from introduction of the same bill in both houses of Congress, 2,465 private bills were introduced in the 81st Congress for the relief of 4,145 persons. Of these bills, 505 were enacted for the benefit of 835 persons. 5 bills were vetoed by the President, 3 of which were subsequently reintroduced and reenacted. In the last Congress, the 82nd, 3,302 bills were introduced for the relief of 5,784 persons, of which 732 bills were enacted affecting 1,364 persons. 2 bills which were vetoed were subsequently reintroduced and reenacted. Conclusions. The national origin system failed in its avowed purpose because it was arbitrary and did not conform to the facts. Immigrants do not come to the United States in the proportions set up by the national origins formula, and therefore it could not succeed in its purpose. The failure grows out of several factors, including the following. 1. The favored quota countries did not send immigrants in proportion to their quota ratio. 2. The national origin system did not apply to non-quota immigration, which was substantial. This included people from the Western Hemisphere and the families of citizens of any national origin. During the 22 fiscal year period from 1930 to 1951, immigration totaled 2,010,887. Of this total, more than 40%, or 820,795 persons, was non-quota. 3. Congressional recognition of the necessity for ignoring the national origin system through special legislation, such as the Displaced Persons and the War Fiancé programs and private bills, which together admitted almost 500,000 people since the war. End of Section 12. Recording by Maria Kasper. Section 13 of Whom We Shall Welcome. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Whom We Shall Welcome. Report of the President's Commission on Immigration and Naturalization. Part 3, Chapter 8, National Origin System, Suggestions to the Commission. In discussions of the national origins quota system over a period of years, many alternatives have been proposed. Following are some of the suggestions made to the Commission as to possible courses of action. Proposals concerning a total annual quota. To stop all further immigration to the United States. Such proposals have been advanced from time to time without success during our national history. In fact, the 1921 Act developed from just such a proposal. Some few urged this extreme measure during the Commission's hearings. To abandon any numerical limitations. This is the pattern of free immigration, subject to qualitative limitations, which prevailed in the United States before 1921. No one has seriously urged this position upon the Commission. To abandon numerical limitations, but to require assurance of financial responsibility. While this plan would not proclaim any specific maximum limitations, its sponsors argue that it would, in effect, operate as a self-limiting guarantee against excessive immigration. The qualitative restrictions in the present law would in substance be retained. In addition, each prospective immigrant would have to furnish firm and legally enforceable assurance that he would not become a burden on the community. This is a plan for qualified immigration similar to that in effect in some other countries. To allow free movement of peoples in designated areas of free trade. This proposal has been advanced by Fortune magazine and envisages specific identification of the immigration policy of the United States with revised economic and foreign policies. To adopt flexible annual quotas based on national need and capacity. The advocates of this plan argue that the present immutable annual maximum number that may be admitted makes no allowance for national needs and changing world conditions. They point out that the quotas have remained fixed despite alterations in the requirements of the United States and of the world situation. They favor periodic revisions in the immigration quota maximum based on an evaluation of current needs and the national capacity to absorb immigrants. This proposal could be combined with any formula for allocating visas within the annual numerical limitations, either the national origin system or any substitute plans. Some have suggested that an administrative agency be given authority under standards established by Congress to determine the number of immigrants who would be received in the United States each year within a designated range. Proponents say that flexible authority to determine the number of immigrants to be admitted annually is conferred upon administrative agencies in other countries. Proposals to retain the national origin system. To retain the national origin system without change. This course of action was followed by the Immigration and Nationality Act of 1952 and approved by some witnesses at the hearings. To retain the national origin system but make adjustments and revisions in its operations. Among those who urge this course are persons who support the national origin system in principle, but admit that some modifications in the current statutory design are desirable, and also persons who oppose the national origin system in principle, but who have not devised any workable substitute pattern, or who believe that legislative strategy dictates interim measures. A number of revisions have been suggested. Pooling of unused quotas. This plan has had strong support. It is predicated on the recognition that high proportions of certain quota allotments have not been utilized, particularly by Great Britain and Ireland. It proposes to assign such unused quotas to other countries. The supporters of this plan argue that it merely makes possible the full utilization of the quota numbers authorized by Congress, which have to a large extent been wasted in the past. The opponents contend, on the other hand, that Congress did not guarantee that the quotas would be fully used, but rather established a maximum authorization. They also assert that any pooling plan would unbalance the national origins pattern. A major problem is the determination as to how to apportion such unused quotas. Some would allocate the unused quota numbers solely on the basis of precedence in applications, or in proportion to registered demand for quota members. These suggestions have aroused the objection that the entire pool would, in effect, be appropriated by nationality groups with high demand for immigration. Another proposed plan would reserve such unused quotas for the countries with low quota allotments, and assign them in proportion to the original quotas. Another plan would assign the unused quotas to regional areas, the unused European quotas to Europeans, and the unused Asian quotas to Asiatics. Still another plan would apply the unused quotas to designated groups of immigrants selected on the basis of preferences, such as our national needs, family ties, and personal hardship of the applicants. Adjustment of the basis of computation. Many have suggested substituting the current census for that of 1920 as the basis for determining national origins quotas. Such a modification would increase the total quota and make possible the admission of a somewhat larger number of immigrants from Southern and Eastern Europe, where needs are great and quotas small. Another suggestion is to include Negroes, Indians, and other non-white persons in the population base on which the percentage is computed in order to arrive at the total quota. Under the present law, Negroes and American Indians have been excluded from the population base. Were they to be included, this modification alone would result in an increase in the quotas under the Act of 1952, based on the 1920 census, from approximately 155,000 to approximately 171,000. If both these suggestions were adopted, the aggregate quotas on the 1940 census basis would approximate 230,000, and on a 1950 basis, aggregate quotas would become 251,162. Eliminate special racial quotas for Asiatics and also special quotas for colonies in the Western Hemisphere. It is alleged that these limitations constitute a survival of racial discrimination and are unnecessary in achieving limitation of immigration. The proponents of such special racial quotas urge, however, that they must be retained in order to preclude excessive immigration of Asiatics from Western Hemisphere countries. Moreover, they contend that the inhabitants of dependencies should not be permitted to utilize the quotas of their mother countries. Rescind the mortgaging of quotas inaugurated under the Displaced Persons Act. Such mortgaging commitments are claimed to be an unwarranted burden on the future. In its final report, the DP story, the Displaced Persons Commission made this recommendation. Many witnesses at the hearings urged it strongly. Eliminate reductions in quotas through private bills, suspension of deportation, and adjustment of status. It is argued that by granting relief in such cases, Congress recognizes that they present special meritorious circumstances, and that such action should entitle the alien to admission outside the quotas. Assign future quotas on the basis of the proportionate use of quotas during any specified period. Such a plan would gear future quotas to the proportions of past immigration. Assign national quotas on basis of national origin percentage in military service of the United States rather than on percentage of total population. This suggestion is intended to reward services rendered to the people of the United States. To retain the national origin system, but substitute regional quotas for the present national quotas. Under this proposal, the quotas for all European countries would be pooled into a single quota for Europe. Likewise, the quotas for the countries of the Asiatic area could be pooled into a single quota for Asia. This plan bears some resemblance to the Asia-Pacific Triangle device introduced in the Act of 1952. It would afford greater flexibility in utilizing the quotas for Europe. The supporters of the national origins principle would probably object to the failure to reserve the major proportion of the suggested European quota for the countries of Northern and Western Europe. On the other hand, many of the opponents of the national origins system would probably argue that this new device would merely continue racial discriminations under another guise. However, this suggestion would accomplish a pooling of presently unused quotas. To retain the national origins system in principle, but bypass it in practice through emergency legislation to admit additional persons on a non-quota or quota mortgaging basis. The Displaced Persons Act was an example of such an approach. Quota mortgaging was used to evade the restrictions of the national origin system. Senator McCarran's special sheepherder law, the War Fiancés Act, Congressman Walter's bill for specialists, and President Truman's emergency proposal for 300,000 refugees and others during a 3-year period, as embodied in the bills of Senator Hendrickson and Congressman Seller, are additional examples. Some oppose this proposal, who may agree with the objectives of a specific program so advanced, but argue that the way to deal with such recurring emergencies is through enactment of a sufficiently flexible basic immigration law, rather than through crisis legislation. Others in opposition object to the specific program. Proposals to abolish national origin system. To repeal the national origins formula and substitute a flexible allocation within a maximum quota established by law. This proposal would establish a maximum annual quota and would authorize the selection of immigrants within that total quota without regard to their nationality, race, color, or religion. Several different proposals have been advanced for selection within the single quota maximum. A. Some urge a first-come, first-served basis. B. Others suggest a system of preferences for the selection of immigrants within the maximum quota. Various criteria have been suggested for such preferences. The following are some preferences that have been suggested to the Commission. 1. Relatives of American citizens and of alien residents of the United States. 2. Persons with special skills. 3. Refugees, escapees, expellees. 4. Immigrants from overpopulated areas. 5. Persons left in the displaced persons pipeline. 6. Immigrants to satisfy needs in the United States. Opponents of this plan claim that it would virtually preempt the entire quota for particular nationality groups. The proponents argue that this is the only formula that is morally defensible and completely fair. Furthermore, the proponents argue a proper system of preferences would prevent undue favoritism to any one nationality, and flexibility would permit adjustment to meet the domestic and foreign policy needs of the United States. End of Section 13. Recording by Maria Kasper. Section 14 of Whom We Shall Welcome. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Whom We Shall Welcome. Report of the President's Commission on Immigration and Naturalization. Part 3, Chapter 9. A Unified Quota System. The Commission's Recommendation. The Commission recommends the complete abolition of the national origins system. In its place, the Commission recommends a unified quota system. The Commission's recommendation contemplates a maximum annual number of quota immigrants to be determined by the Congress, and a flexible method of allocating visas within such annual maximum. Visas should be allocated on the basis of statutory categories best serving the interests of the United States, and without regard to national origin, race, color, or creed. This allocation should be made periodically by an administrative agency established for that and other purposes, and would be subject to review by the President and the Congress. The National Council of Churches of Christ testified before the Commission that the national origins system is an affront to the conscience of the American people. The Archbishop of the Catholic Archdiocese of Boston stated to the Commission, "The theory of national origins cannot be defended without recourse to the discredited and unchristian tenets of racism. The Synagogue Council of America testified that the national origins system flies arrogantly in the face of everything we know and have learned, and stands as a gratuitous affront to the peoples of many regions of the world. These representatives of the major religious faiths throughout the United States were joined by spokesmen from all walks of life in this country: the sciences, the arts, the professions, education, agriculture, business, labor, law, and social service, as well as by civic leaders and individual citizens. The Commission believes that its recommendation to abolish the national origin system accords with the convictions of the majority of informed people in the United States. The principal characteristic of the unified quota system is that it selects prospective immigrants without regard to national origin, race, color, or creed. In this regard, it is in line with the attitude expressed by George Washington in 1784. Writing to a former aide-de-camp, Washington asked assistance in getting several immigrants for his plantation and gave the following qualifications: if they are good workmen, they may be of Asia, Africa, or Europe. They may be Mohammedans, Jews, or Christians of any sect. The Commission recommends a ceiling on quota immigration into the United States based upon the formula figure used in the Immigration and Nationality Act of 1952, namely 1/6% of the population of the United States. However, that population base should be the latest available census figures and should include all persons in the United States without regard to national origin, race, color, or creed. On the basis of calculations shown in Chapter 4, under the 1950 census, this quota ceiling would total 251,162 visas annually. A unified quota system. Allocation of visas within annual maximum. The selection of immigrants who may enter the United States should be made on the basis of considerations which advance our national interest, strengthen our economy and culture, protect our security, and win and keep friends for us among other nations. The Commission's proposed substitute for the national origins system is a unified quota system. It is a unified or single quota of 1/6% of the total population of the United States, instead of the 85 national quotas required under the 1952 Act. The Commission recommends that within the annual maximum, the allocation of visas should be made in accordance with the following 5 categories, in the order determined by the proposed administrative agency. The right of asylum. One of our national traditions is that we have provided asylum and haven to the oppressed of other lands. This we were able to do until 1924 because our law was flexible enough to meet such situations. Asylum for the oppressed is thwarted by the national origins system. For example, Congress had to bypass that system by enacting the Displaced Persons Act of 1948. The United States is one of the few major democratic countries of the free world whose present laws impede and frequently prevent providing asylum. This is harmful not only to the cause of freedom and peace in the world, but to our own selfish best interests within our own borders. The Commission recommends that one of the categories should be based on the right of asylum, available for refugees, escapees, expellees, and other persons suffering from political, religious, and economic persecution. The Commission realizes that such problems are of international scope and responsibility, which the company of free nations must jointly assume. However, our present immigration law hinders the United States from playing its reasonable part in such efforts. The Commission believes that these categories normally should be subject to flexible application. However, in connection with this category, and as a temporary statutory priority to go into immediate effect, the Commission recommends that provision should be made for the annual admission over a 3-year period of 100,000 such refugees, escapees, expellees, and remaining displaced persons. Under this recommendation, the entire recommended increase in the annual number of visas would, for a period of 3 years, be used to help solve an existing emergency situation. In this way, a basic immigration policy can be established which would promptly help solve the existing emergency and still remain within a flexible immigration pattern, obviating the need for periodic emergency piecemeal legislation. Within the foreseeable future, this recommended category would apply principally to Europe rather than to Asia. The outstanding exception to this may be Japan. The Commission's recommendations are based on existing world conditions. As shown in Chapter 3, American participation in a coordinated international effort to provide migration opportunities for refugees, expellees, escapees, and the remaining displaced persons in Europe could bring substantial alleviation to the emergency problem there caused by World War II and its aftermath. Unfortunately, the same cannot be said for the refugee situation in Asia, where the number of persons affected by dislocations of World War II have been equaled, if not exceeded, in the post-war period. Reunion of families. The great American success story records that we are a nation of immigrants, and that a great part of our moral and spiritual fiber grows out of the sacred place of the family in American life. The Commission recommends that one of the categories should be for immigrants whose admission would result in reuniting families. Needs in the United States. Our immigration law should encourage entry into the United States of persons whose skills, aptitudes, knowledge, or experience are necessary or desirable for our economy, culture, defense, or security. The Commission recommends that one of the categories should be for persons of skills or occupations to fill needs certified by the Secretaries of Agriculture, Commerce, Defense, or Labor, or by other appropriate officials, to be necessary in or desirable for the national welfare. Special needs in the free world. The security and welfare of the United States are linked with the stability of other free nations in the world. The economic, political, and social conditions of other nations directly affect our capacity to preserve peace and freedom, develop international trade, and promote friendship among nations and peoples. An important problem facing the free world today is overpopulation. Wherever it exists, the stability of the nation affected is threatened, and that nation's contribution to the defense against the totalitarian menace is lessened. For that reason, among others, all free nations, and especially the United States, are deeply concerned with the existence of such conditions and with efforts to reach solutions. In the interest of world peace and security, there is an urgent need for a cooperative international effort to move surplus people to parts of the world where they can more effectively and constructively participate in the national economy. The Commission recommends that one of the categories should be for persons from countries of the free world where immigration to the United States can meet special needs and can provide substantial alleviation of hardships which threaten economic, political, or social stability in such countries. Obviously, the United States cannot solve the entire world's overpopulation problem. This category should meet special needs. 1. Where population pressure is causing hardship and political discontent dangerous to the peace and stability of the free world, and 2. Where a reasonable amount of emigration would be effective in providing relief and alleviating tensions. Since the application of this category should depend upon the existence of special needs which can effectively be dealt with by migration, the circumstances and special needs of the particular country are significant. For Western Germany, Greece, Italy, the Netherlands, and perhaps Japan, emigration can serve as a safety valve for transitory problems of critical population pressures. These countries have reached a stage of economic development and population structure where both the need and desire for migration is most acute, and where its result would be soon effective. A concerted international effort to deal with this situation would serve to bring about a relatively manageable situation, in which the natural population increase of such countries could be readily absorbed for productive use within their own economies. Consequently, the category would provide some migration possibility for overpopulated countries of Europe, but not at this time, except perhaps for Japan, for overpopulated countries of Asia, where the need is not for migration, but for improved use of resources and greater economic development. General immigration. There are aliens who may be desirable immigrants merely because they are good people whom we would be happy to welcome. These aliens may not be refugees or relatives of people in the United States or from overpopulated countries or possessed of special skills. They are the kind of immigrants the United States traditionally has received, and they can contribute substantially to our development. It is distinctly in our interest to keep alive the opportunity for enterprising immigrants to come here. The Commission recommends that one of the categories should be for general immigration of all other qualified persons, without regard to national origin, race, color, or creed. The Commission gave consideration to the desirability of applying this category on a first-come, first-served basis. Although in theory this might seem to avoid any taint of discrimination, the Commission believes that in practice it may bring about the kind of discrimination which should not result from our immigration laws. Conceivably, a few countries of the world, through early registration for visas, might monopolize this part of the quota. A better plan, the Commission believes, is to use this category for the allocation of visas among such areas or regions of the world as may be determined by the agency for the purpose. Within any area or region, as defined by the agency, the number of visas may vary from year to year and should be issued on a first-come, first-served basis. The Commission suggests that the considerations to guide the agency in the exercise of its judgment in prescribing areas or regions should include, but not be limited to, benefits to the United States from granting the desires of peoples who are anxious to become permanent residents and citizens, and the opportunity to satisfy general needs of the United States for immigrants who do not qualify under any of the other categories. The standards to be applied under this category should not be rigid. The agency charged with such a responsibility should have a reasonable latitude in reaching a fair, impartial, and workable result, and should safeguard this category so that no one country, group, or area would obtain unfair advantages under its operation. The Commission recommends that the allocation of visas within the proposed annual maximum quota, in accordance with the statutory standards, should be made by an independent administrative agency established by Congress for that purpose, among others, described in Chapter 10. The Commission recommends 1. That such agency be headed by a commission, 2. That the proposed agency be authorized to determine, in the first instance, the number of visas within the total maximum to be assigned to each of the categories, 3. That there be public hearings before these determinations are made, 4. That such determinations be submitted to the President, and thereafter sent, with any changes he deems proper, to the Congress, 5. That such determinations become effective unless, within a specified time, Congress should disapprove of them by joint action of both houses. 6. That categories so approved shall remain effective for a period of 3 years, provided that during the interim the proposed agency may, at the direction of the President, submit other allocations to meet emergencies, Such new interim allocations should be subject to the same procedure as those originally made. The Visa Division of the Department of State has advised the Commission that on the basis of present visa control experience, and from the point of view of administration, a unified quota system is practicable and can be operated. Other aspects of immigration policy. Other aspects of immigration policy are related to the national origin system and quota limitation. Non-quota immigrants. Neither the national origins quota system, nor the proposed unified quota system, nor numerical limitations upon immigrants to be admitted into the United States covers all immigrants. Immigrants admitted for permanent residence, to whom neither applies, are called non-quota immigrants. The Commission recommends non-quota status for all persons born in independent countries of the Western Hemisphere, regardless of race or color. The Commission recommends that all discriminations and restrictions against colonies in the Western Hemisphere as a special class should be eliminated. The Commission recommends reinstating the previously applicable non-quota status for professors, clergymen, and other persons, as such status was defined prior to the passage of the Act of 1952. The Commission recommends non-quota status for close relatives of citizens, with close relatives defined to include A. spouses, B. children, including adopted and stepchildren, C. parents and grandparents. Restrictions upon immigration. It is intended that the Commission's proposed unified quota system will include qualitative restrictions upon individual immigrants. Such grounds for exclusion relating to security, health, public charge, criminal record, and other personal qualifications are considered in Chapters 12 and 15. End of Section 14. Recording by Maria Kasper. Section 15 of Whom We Shall Welcome. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Whom We Shall Welcome. Report of the President's Commission on Immigration and Naturalization. Part 4. Administration of the Law. Chapter 10A. The Administrative Agency. The Commission recommends 1. That a Commission on Immigration and Naturalization be created, to be appointed by the President, subject to Senate confirmation, responsible for the administration of all immigration and naturalization laws. 2. That present duplication of functions between the consular officers in the Foreign Service of the Department of State and the immigrant inspectors in the Immigration and Naturalization Service of the Department of Justice be eliminated, and that a consolidated service under an administrator of immigration and naturalization responsible to the proposed commission be substituted. 3. That a Board of Immigration and Visa Appeals be created under the proposed commission, with final administrative appellate authority, except in cases involving the exercise of discretion, in all cases of visa denials, exclusions, deportations, and other related matters. Present administration of immigration activities. Under present law, the various functions relating to immigration and naturalization are committed to two separate departments of government, both administering and interpreting parts of the same law and applying them to the same persons. The Immigration and Naturalization Service, Department of Justice. The Immigration and Naturalization Service exercises its functions in connection with the law, principally within the United States, in the admission or exclusion of immigrants seeking to enter this country, the apprehension and removal of deportable aliens, the conduct of naturalization proceedings, and the preparation of denaturalization cases. Federal administration in the field of immigration began with the Act of 1864, which established a Commissioner of Immigration whose function was to encourage immigration. This law was passed in a period of manpower shortage during the Civil War, and it was repealed in 1868. Thereafter, there was no federal agency charged with the supervision of immigration until the first General Immigration Law of 1882 was enacted. The 1882 Act vested responsibility for its administration in the Secretary of the Treasury, but actual enforcement was entrusted to state boards or officers designated by him. Federal administrative enforcement began with the passage of the Act of 1891, when Congress provided that there should be in the Treasury Department a Superintendent of Immigration, whose title was later changed to that of Commissioner General of Immigration. The Bureau of Immigration was transferred from the Treasury Department to the Department of Commerce and Labor upon its establishment in February 1903. The Naturalization Act of 1906 inaugurated federal supervision of naturalization and established a consolidated agency known as the Bureau of Immigration and Naturalization. In 1913, the Consolidated Bureau was moved to the new Department of Labor and was divided into the Bureau of Immigration and the Bureau of Naturalization. At the head of the Bureau of Immigration was a Commissioner General of Immigration, while at the head of the Bureau of Naturalization was a Commissioner of Naturalization. Both bureaus were placed under the immediate direction of the Secretary of Labor. The two bureaus continued to function separately until 1933, when the President, acting pursuant to congressional authority, directed by executive order that they be merged as the Immigration and Naturalization Service, headed by the Commissioner of Immigration and Naturalization. From 1933 until 1940, the service functioned under the direction of the Secretary of Labor. In 1940, the President submitted to Congress a reorganization plan which proposed to transfer the Immigration and Naturalization Service from the Department of Labor to the Department of Justice. The plan was approved, and the transfer became effective June 14, 1940. Since then, the Immigration and Naturalization Service has functioned as part of the Department of Justice under the direction of the Attorney General of the United States. Foreign Service, Department of State. The Immigration Act of 1924 vests the performance of the visa function, which consists of the granting or denial of visas, in consular officers of the American Foreign Service abroad, which operates under the control and direction of the Department of State. Under the Act of 1952, the authority to issue or deny visas is clearly and exclusively vested in the consular officers, and the statute directs that they shall not be subject to the supervision of the Secretary of State in this regard. The requirement of a visa to enter this country is relatively new and dates only from World War I, when it was established essentially as a wartime security device. This requirement to obtain visas from American consular officers abroad was given statutory recognition in the Act of 1918. Under the Immigration Act of 1924, however, immigrant aliens seeking to come to the United States were required to establish in advance their eligibility under all the immigration laws and to obtain a visa from an American consul stationed abroad before embarkation. An immigrant was prohibited from entering the United States unless he was in possession of an unexpired immigration visa. However, the issuance of such a visa by an American consular officer does not guarantee his admission to the United States. Other statutes have given additional responsibility under the immigration laws to the Secretary of State. Thus, under the Passport Act of 1918 as amended, the Secretary of State, with the concurrence of the Attorney General, is authorized during the time of war or emergency to describe classes of aliens whose entry would be prejudicial to the United States. The Alien Registration Act of 1940 empowers the Secretary of State in emergency cases to waive documentary requirements for aliens seeking to enter this country. To aid in the performance of the visa functions abroad under the immigration laws, a visa division was created in the Department of State. The Visa Division provides technical guidance and assistance to consular officers, who themselves must determine initially the alien's admissibility to the United States. In the final report of the Senate Judiciary Committee following its recent study of the immigration system of the United States, the following recommendation was made. Because of the close relationship of the Visa and Passport Divisions of the Department of State and their importance in the control of immigration problems, the subcommittee recommends the establishment of a Bureau of Passports and Visas as an independent unit of the Department of State, headed by a director with the rank of Assistant Secretary of State and subject to general supervision by the Secretary. To meet objections of the Department of State, the bill was revised to establish a Bureau of Security and Consular Affairs responsible to the Secretary of State and closely integrated within the department's framework. It was enacted in this form in the Immigration and Nationality Act of 1952. Board of Immigration Appeals, Department of Justice. A third agency which functions in the immigration process is the Board of Immigration Appeals. During virtually all of the period when the Immigration and Naturalization Service was in the Department of Labor, there was no independent Board of Appeals. Originally, the Secretary of Labor was aided by an advisory committee in making his determinations under the immigration and naturalization laws. In 1922, a 5-man Board of Review was established in order to review all immigration cases and to make recommendations to the Secretary of Labor. The Board of Review had no power to make decisions and was responsible to the Secretary of Labor, whom it advised. The Board of Review offered an opportunity for oral argument, submission of briefs, and more careful consideration. Also, it relieved the Secretary of Labor of the burden of considering a large volume of appeals. When the Immigration and Naturalization Service was established as a consolidated agency in 1933, the Board of Review became responsible to the Commissioner, and its recommendations were reviewed by him before being transmitted to the Secretary of Labor. With the passage of time, the procedures and the anomalous position of the Board of Review were subjected to increasing criticism. In 1931, the Wickersham Commission, studying the enforcement of federal laws, advocated the creation of an independent tribunal so that the prosecuting and administrative functions in immigration matters would be completely separated from the judicial duties. The latter duties would be vested in an independent tribunal composed of men of judicial caliber to be appointed by the President. The Commission stated, "The creation of such an independent tribunal for the determination of deportation cases seems to be the logical development of the present system itself. The Department of Labor has found it advisable to create a Board of Review within its own organization. As has been shown, this board has developed certain embryonic judicial tendencies, although the growth of these tendencies has been hampered by the subordinate position in the department which the board occupies. The next step in development seems clear. The dichotomy should be made complete. The Board of Review should be lifted out of its place in the Department of Labor and should be made an independent tribunal." Perhaps the closest analogy in structure to such a proposed tribunal is the Board of Tax Appeals, an independent governmental agency created by Congress in 1924. The board neither initiates nor prosecutes the cases which are brought before it, but in effect sits as a court. Its hearings are public and its decisions are reported, It has some power of appointment and is working out an elastic organization. Appeals are allowed in the respective circuits. The independence of this board and the satisfactory nature of its decisions are generally conceded. There seems to be no good reason why we should not proceed at least as far in the establishment of a satisfactory system with respect to the important personal rights involved in deportation as we have with respect to the property rights involved in taxation. From 1938 to 1940, the Secretary of Labor's Committee on Administrative Procedure made an exhaustive study of the Immigration and Naturalization Service. Its report stressed the necessity of freeing the Board of Review from any other than quasi-judicial duties, stating that the agglomeration of duties placed on the members of the Board was indefensible, and that it is folly even to talk of fair hearing by individuals who are struggling under such a load. The several thousand of admissions and deportation cases which would be referred to the Board under the arrangements we are suggesting are as much as its members can possibly consider with any semblance of fairness. These recommendations were accepted and put into effect. In 1939, the Board of Review was removed from the control of the Commissioner and was made responsible only to the Secretary of Labor. When the Immigration and Naturalization Service was transferred to the Department of Justice in 1940, the Board of Review became the Board of Immigration Appeals and was placed under the immediate direction of the Attorney General. Unlike the Board of Review, which could only make recommendations, the Board of Immigration Appeals was empowered to make final decisions, subject to possible review by the Attorney General. Since 1940, it has continued to function as an arm of the Attorney General, independently of the Immigration and Naturalization Service, whose decisions it reviews. The Board of Immigration Appeals, composed now of a chairman and 4 associate members, never has been recognized by statute. It continues to function at the pleasure of the Attorney General and for his convenience. Its jurisdiction is defined in regulations which have been changed on a number of occasions during recent years. Its primary function is to hear and decide appeals in exclusion and deportation cases. However, since there is no statutory restraint, the Attorney General could at any time abolish the Board of Immigration Appeals or modify its jurisdiction in any regard he deems appropriate. Unnecessary duplication of functions. The requirements of the Immigration Act of 1924, that approval must be obtained overseas before the alien could embark for the United States, was an important improvement over earlier procedures. It enabled the alien to obtain an advance, but not final, determination of his eligibility before he pulled up his roots and undertook the long and expensive trip to the United States. While acknowledging the distinct advances in administration made possible by this improved procedure, many have pointed out the resulting disadvantages. There is an obvious duplication in function between the consular officer overseas and the immigration officer at the port of entry. The consul must determine the alien's admissibility to the United States before he can issue a visa. The immigration official, likewise, must determine the alien's admissibility before he can permit him to enter the United States. Both interpret and apply the same law. An additional consideration concerns the qualifications of consuls to make such determinations. The consular function is an old and important one in international relations. The consul's traditional duties have related primarily to protecting the property and personal interests of American citizens in foreign countries and to the promotion of trade and commerce. The function added after World War I of passing upon an alien's admissibility to the United States under the immigration laws has been regarded by some as a secondary one. The personnel to whom this function was assigned generally were insufficiently equipped, at first, by training and experience. Thus, the Department of State has reported to the Commission that only 3% of visa officers have had legal training, despite the fact that the visa-issuing officer is required to deal with a great body of complex laws and regulations. It is important to note that the consul's negative decision on a visa application is final and unreviewable. Soon after operations commenced under the Immigration Act of 1924, it became apparent that consular officers often lacked adequate training and background to discharge their new responsibilities under the immigration laws. These deficiencies resulted in a considerable volume of rejections at ports of arrival in the United States of aliens who had been granted visas. In order to aid the consuls, immigrant inspectors were sent abroad in 1925 under an agreement with the Department of State, and were attached as technical advisors to the consulates at London, Southampton, Liverpool, Glasgow, Belfast, Dublin, and Queenstown. Although the consular officer had final authority in determining whether a visa was to be issued, he was usually guided by the advice of the immigrant inspector. This system was successful in operation, and was extended to the Scandinavian countries, Poland, Czechoslovakia, the Netherlands, Belgium, Italy, Germany, and Austria. The reduced immigration during the Depression of the 1930s resulted in a decrease in the number of technical advisors. In 1934, for example, there were 9 immigration technical advisors stationed in Europe, each of whom was assigned to areas in Europe and traveled on a circuit between the different consulates in that area. The technical advisor system was terminated at the outbreak of World War II in Europe and has not since been reinstated. During the Displaced Persons Program, immigration inspectors were stationed overseas and in effect passed upon the immigrant's admissibility after documentation with a visa, just as is ordinarily done at American ports of entry. In 1949, the Hoover Commission on Organization of the Executive Branch of the Government recognized the deficiencies of the present system, under which there is a dual control of immigration, and recommended that the Visa Division of the Department of State be transferred to the Department of Justice. The Hoover Commission made 2 pertinent recommendations. 1. The State Department, as a general rule, should not be given responsibility for the operation of specific programs, whether overseas or at home. 2. The functions of visa control should be transferred from the State Department to the Justice Department. The Hoover Commission Task Force Report on Foreign Affairs elaborated in 2 statements. 1. All visa responsibility, therefore, except with respect to diplomatic visas, should be placed in the Justice Department. Visa work presently performed by the Foreign Service abroad should be continued, but in accordance with policies established by the Justice Department in consultation with the State Department. 2. The logical solution to the visa problem lies in the transfer of the Visa Division functions to the Department of Justice. Diplomatic visas, however, should remain under the jurisdiction of the Secretary of State. Following publication of the Hoover Report, the Department of State organized several committees to study the various recommendations. One of these committees was the Visa Task Force, which presented its findings in a report March 31, 1949, in answer to the Hoover Commission recommendations on location of the visa functions. This State Department report counseled against acceptance of the Hoover Commission's recommendation to consolidate immigration functions. The study of the Senate Judiciary Committee, which preceded the introduction and enactment of the Act of 1952, likewise took cognizance of this duplication. However, the committee declined to recommend any substantial changes and stated, "Among the principal points of criticism aimed at the present immigration structure has been the contention that the multiplicity of control by several agencies of various immigration activities should be eliminated. In general, the subcommittee has come to the conclusion that although there are some points in the mechanism where coordinated action is necessary and duplication must be eliminated, the overall structural pattern ought to be maintained. the subcommittee is persuaded to the position on the grounds that 1. The distribution of responsibility places additional barriers in the way of undesirable aliens, additional fences of protection which the alien must surmount, and 2. The present system operates satisfactorily, and the suggested modifications will eliminate most of the existing difficulties. The Senate Judiciary Committee likewise addressed itself specifically to the recommendations of the Hoover Commission and stated, "The subcommittee has given serious consideration to the proposal advanced by the Hoover Commission for a transfer of the Visa Division to the Department of Justice and its merger with the Immigration and Naturalization Service. As already pointed out, the subcommittee is persuaded to continue the visa process separate from the immigration procedure as an additional barrier to the entry of inadmissible aliens." The Act of 1952 made no appreciable change in the organizational setup, except to establish in the Department of State a Bureau of Security and Consular Affairs. Provision was made within that bureau for a General Counsel of the Visa Office, authorized to maintain liaison with the appropriate officers of the Immigration and Naturalization Service, with a view to securing uniform interpretations of the provisions of this Act. Feasibility of consolidating functions. All witnesses who addressed themselves to this problem in the Commission's public hearings urged that the functions of consular and immigration officers should be consolidated. The Commission agrees that this is a desirable goal. There is no reason why there should be two independent determinations on the same issue, except upon the basis of mistrust and fear. Every national purpose would be fully served by one thorough and trustworthy examination and determination. The best available information indicates that this costly, unwieldy, and unbusinesslike duplication serves no reasonable purpose. It is hardly more than a historical accident which has become to some a principle. An informal study in the Department of State a few years ago disclosed that in less than 0.5% of all cases where visas were issued by consular officers were the applicants rejected at ports of entry in the United States. The 1951 annual report of the Immigration and Naturalization Service supplied the following information concerning the number of aliens excluded at the border. Table 13, Aliens excluded from the United States by cause, year ending June 30th, 1951. For all causes, total number excluded 5,647. Of those, 1,868 border crossers, that is, aliens seeking admission at land borders for less than 30 days, and 3,784 other aliens. Broken down by cause. Without proper documents, total 3,963, 1,180 border crossers, 2,783 other aliens. Criminals, total 610, 273 border crossers, 337 other aliens. Mental or physical defectives, 434 total, 97 border crossers, 337 other aliens. Subversive or anarchistic, total 165, 136 border crossers, 29 other aliens. Stowaways, total 121, no border crossers, 121 other aliens. Had been previously excluded or deported, total 119, 72 border crossers, 47 other aliens. Likely to become public charge, total 116, 38 border crossers, 78 other aliens. Immoral classes, total 38, 23 border crossers, 15 other aliens. Previously departed to avoid military service, total 14, 10 border crossers, 4 other aliens. Unable to read, over 16 years of age, total 3, no border crossers, 3 other aliens. Contract laborers, total 1, no border crossers, 1 other alien. Other classes, 63 total, 34 border crossers, 29 other aliens. Excluding from consideration border crossers and aliens without proper documents, this table reveals that during 1951, approximately 1,000 aliens in possession of visas were excluded by immigration officers at the ports of arrival in the United States. The extent of unnecessary duplication is revealed when this is compared with some 206,000 immigrants admitted during that same period, in addition to visitors. In the Commission's opinion, this duplication in visa issuance and immigration examinations is wasteful and unjustifiable. The Commission cannot subscribe to the sentiment that this obstructive process is required as an additional barrier to the entry of inadmissible aliens. By the same token, such additional barriers can operate also to shut out desirable aliens. The relatively few inadmissible aliens it has stopped could be dealt with by a unified and more effective administration. Similarly, the Commission is not impressed with the State Department's suggestion that the conduct of foreign relations requires the issuance of non-diplomatic visas by consular officers. The consular function did not, until 1924, include the issuance of immigration visas. Nor is the State Department suggesting that foreign policy requires the determination of admissibility by consular officers at the port of entry in the United States. The time has come to terminate the unnecessary and costly obstructions established by the duplication of visa and immigration examinations. This could be accomplished by eliminating overlapping and duplication through unifying these functions in a single process. The result will be a more effective administration of the law, a saving of government expenditures, and a better location of administrative responsibility. Operation of the proposed system. The Commission agrees with the Hoover Commission that a large program of such an administrative operation as the immigration law has no place in the Department of State, whose primary responsibility is the conduct of foreign relations. The Commission recommends that the primary determination overseas of an alien's application for a visa to the United States should be made by officials of the same agency which determines admissibility at the ports of entry. Presentation of such a visa at a port of entry in the United States should entitle an alien to be admitted without further inquiry except as to 1. Identity, 2. Any medical condition developed since the visa was issued, and 3. Any evidence relating to subversive activities not previously considered. The Commission believes that there should be no substantial difficulty in establishing such a system of unified determinations in foreign areas where there are large volumes of applications for visas. In such places, visa issuance is a full-time job for visa officers. There may be some rearrangement necessary for operation in isolated areas from which few applications for visas originate, and where, therefore, full-time visa officers are not stationed. This is a problem of administrative management, susceptible of a variety of solutions. The Commission believes that in such areas, the agency responsible for the consolidated functions could follow the normal procedure used by many government agencies in connection with overseas activities. The consular officer could be designated as an agent of the immigration authorities to receive the application, which could then be forwarded with the requisite documents and evidence to the nearest overseas regional office of the consolidated agency. The determination would be made by an officer stationed in such a regional office. If the evidence is incomplete, he could request the consul to conduct any additional interrogation or investigation deemed necessary, or, if advisable, the consular officer could, in these few cases, be authorized to act on behalf of the consolidated agency. It has been suggested that there may be some difficulty in stationing officers of the consolidated agency in some foreign countries. Immigration officers have already performed duties under our immigration laws in Germany, Great Britain, Canada, Italy, and in other countries. To satisfy any requirements of protocol, such officers could be attached for technical purposes to our embassies or other accredited offices with conventional titles. The differences between present procedures and the consolidated procedure the Commission has recommended, including suggested appellate procedures, are illustrated in Chart 1. Chart 1. Comparison of present and proposed procedures. Type of action. Overseas, action on visa. Present program by American consular officer. Proposed plan by officer of proposed commission. Overseas appeal. Present program, no regular appeal provided. Proposed plan, appeal to Statutory Board of Immigration and Visa Appeals. At port of entry, action on admission. Present program by immigration inspector with complete authority to review consular action. Proposed plan by inspector but limited to 1. Identity, 2. Health, 3. Security. At port of entry, determination on questionable cases. Present program to Board of Special Inquiry, after December 24, 1952, to single Special Inquiry Officer. Proposed plan to hearing officer under Board of Immigration and Visa Appeals. Type of action, appeal, initial. Present program to non-statutory Board of Immigration Appeals. Proposed plan to Statutory Board of Immigration and Visa Appeals. Final appeal, present program, no further appeal, but Board of Appeals may certify immigration cases to Attorney General and Attorney General may review on own motion. Proposed plan, review by proposed commission in selected cases involving discretionary relief. The consolidation of all immigration functions in one responsible agency is an essential aspect both of the new approach to immigration, which the Commission believes to be long overdue, and of the efficiency in government, which it was the purpose of the Hoover Commission to reach. Whatever mechanical difficulties may arise from such a consolidation could, with proper spirit and goodwill, be overcome completely and promptly. End of Section 15. Recording by Maria Kasper.